We have all our jurors?
Yes.
Excellent. We just need to get our defense attorneys. There they are. All right, Ms. Rivers, are you ready?
Forward me the Zoom for me.
Yes, let me do that. Did you all get the Zoom link, lawyers?
I haven't received it yet.
I've received it.
All right, let me forward it. All right, you should have it now. Do you want to get plugged into that before we get rolling? Okay. Is it not working?
Yeah, log in from here. I'm trying to figure out what's the password and what's the.
Oh, that's weird. That's all that it forwarded? That's not helpful. Well, let me try again. I don't know why it didn't just forward the whole. Let me try that again. Let's see. Well, but if you open the thing that's attached, it does have all the info. There's an attachment to the thing that I forwarded, and that's got.
Yeah, to open it up on the phone.
Oh, why are you trying to log into your phone?
Well, I can't log in through here.
Because,
It won't log into my email. When you sent it, I can't log into my email.
oh, so it doesn't, that's not what sends things up here?
No,
Okay.
this one is-
What, are these both good and
They're both
happy?
good. Yeah.
Okay, let me just write down,
Yeah.
let me just write down the info for you. So what's wrong with the computer? Huh?
Yeah, I mean, they were just-
You go.
Thank you.
Hmm.
Oh.
You good? Okay, let's get on the record in State versus Poole. It is Thursday, the 11th, a little after 9. All our jurors are here and ready to go. Do we have Mr. Swanner in hailing frequency?
Yes,
Great,
Your Honor.
he's back, thank you. Mr. Body, anything we need to take up before we bring the jurors in? Mr. Miller?
Yes, Your Honor. Yesterday, Your Honor issued an order compelling Dr. Roberto Hernandez Irizarry to be compelled to come to testify today. OCGA 24-1324 requires that in order for a service to be in order for.
Can you give me that statute again, please?
24-1324.
Uh-huh.
In order for a subpoena to be effective or in order for Your Honor to issue a motion to compel, service has to be perfected of the subpoena on that doctor. That subpoena also has to be delivered to that doctor within 24 hours. Case law on 313 Georgia Court of Appeals.
Before you go any further, what's your standing to engage on behalf of the doctor about whether the subpoena is valid, or assume you're right? I'm gonna assume for purposes of this discussion right now that you're exactly right. How do you have any standing to engage on behalf of the doctor that he should or shouldn't show up?
Due process on behalf of my client, Your Honor.
Okay, you find me a case that says you've got standing to object on behalf of a third party and the manner in which someone is being brought into court. You find me that case, and we can talk about it.
All right, so can I make my record?
Yeah.
All right, so Your Honor did issue that subpoena without any type of hearing.
So I know you don't like being interrupted, neither do I. I didn't issue any subpoena. I have issued 0 subpoenas.
The motion to compel.
I didn't issue a motion to compel.
To compel that witness to come to court.
I did sign an order saying you were subpoenaed, doctor, and you need to come to court today. You were here yesterday pursuant to a subpoena. That's what was represented to me. That was what was represented to you, that the doctor showed up pursuant to a subpoena that I suspect, although I haven't seen it, covers the duration of the trial. And what was relayed to you and to me was that the doctor was declining to honor the duration of the subpoena. I'm here today, meaning yesterday, and that's as much as I'm able or willing to do. And so I was asked to provide an order saying the subpoena means what it says, and you need to be here by 10 o'clock today. So I just want the record to be clear. I apologize for interrupting. You should make the record you want to make.
Yes, Your Honor. In the order, the very first line in the order is that he was properly and lawfully subpoenaed to testify in this criminal trial. There's been no showing by the state that Dr. Roberto Hernandez was either properly or lawfully subpoenaed to testify in this criminal matter.
What makes you think he wasn't?
I don't have any evidence of it.
Okay, so you have no basis to challenge it other than you don't like the fact that he may be here today.
We gotta do things the right way, Your Honor. And if he was properly and lawfully subpoenaed, then we should be able to see where he was actually lawfully subpoenaed. We don't.
Why do you ask me for the subpoena? Have you asked the state for the subpoena? No. So why are we having this conversation if you haven't even looked at the subpoena yet?
Your Honor, I'm making a record.
Well, okay. But you are saying things on the record that you have no basis for saying. You're saying he wasn't lawfully subpoenaed, and yet you haven't even asked the state for the subpoena. So we're stopping. After you've done the due diligence that an effective lawyer would do, then we'll talk about this again, okay?
Check the docket.
Nope.
There's nothing in the docket to show that he was subpoenaed.
Okay, good to know. When you're ready to get on the record that you've confirmed that there was no lawful subpoena, or you've got a copy of that subpoena and talk about how it is unlawful, we'll continue the discussion, okay? We've got jurors ready to go, and you don't have a basis yet for your motion. You are speculating that he was not lawfully subpoenaed. You know what you need to do. Anything else from the defense before we bring the jury in?
Judge, just for the record, I did want to correct one statement. If it was represented in court, I think it was done so on accident. The doctor is under subpoena, has been under subpoena. Our expectation was that he was going to be presenting testimony at 4 p.m. And so since he works at Grady, our investigator was going to go pick him up. and bring him here at 4 p.m. Just for the purposes of the record, I didn't want the court to, or the defense to think that he was here just waiting.
Okay, I appreciate you clearing that up. Really, the crux of this, I understand Mr. Miller's concern. I still don't think that he has standing to challenge this, but assuming he does, and he'll find that case that says he's got standing, if it's out there. The issue is the subpoena, not was he here yesterday or not. So I'm going to let the two sides work through what subpoenas look like, and I invite Mr. Miller to renew his objection when he has the evidence to substantiate it. Anything else from the defense? Okay, let's bring the jury in. And sir, if you could get Mr. Swanner back in here, please. Yeah, he should come on up. Thank you. Morning again. Thanks for coming back. You were under a lawful subpoena. All right, you just wait for the jurors to come in and we'll get you back in.
All right, the jury. The president's court.
Thank you, Deputy Gordon. Everyone else should be seated. Good morning, ladies and gentlemen. You are really good at being on time. It's not necessarily an honor you want to have earned for having been here so many days, but this is a very on-time, long-term jury. Thank you for doing that. We had to talk about a couple things before you came out here. Last night, we stopped with the conclusion of the direct examination of Mr. Swanner. He is back. Thank you, sir, for being back. He remains under oath, and now is the time for the state to perform any cross-examination of Mr. Swanner. Mr. Abadi?
Good morning, Mr. Swanner.
Good morning.
So I want to talk about, I guess, you did a report in this case.
Yes, sir.
Correct.
Yes, sir.
And you told the jury what items of evidence did you, or what items as related to the case file you reviewed in order to author your report. You told the jury?
I looked at there was a Dropbox link
that was sent to me from Mr. Miller that I guess, I'm assuming that was forwarded from the DA's office with a whole list of files and reports and stuff. There was the autopsy report for Mr. Minor and Mr. Jones, medical records and EMS report for Mr. Poole, the skirt report from Corporal Lee. I don't remember all that was in there, but there was several items in there.
Okay, and I think you mentioned, you looked at a scene video, correct?
Yes, sir.
So what I didn't hear you mention yesterday, as you were talking about, pack travel and forensic mapping, you were talking about that yesterday?
Yes, sir.
Things that are important, to do forensic mapping and, I guess determining a path of travel. If there's a video of the path of travel that the car took, prior to colliding into a wall, that would be important to review, correct?
Yes, sir.
Okay, it doesn't sound like you reviewed that, correct?
I did review that video, that drone video that starts where the skid marks start and goes to the crash and then goes to the final rest of the vehicle. I reviewed that.
You did the drone video?
Yes, sir.
I'm talking about the dash cam video of the high-speed chase.
Yes, sir. I watched that as well.
You haven't mentioned that until now.
Well, the purpose of me being retained for this case was to see if I could determine where the occupants were. I viewed everything that was sent to me, but if it wasn't pertinent to what I was doing, I didn't list it or I guess mention it yesterday.
Like, you remember yesterday on Direct, you talked for quite some time about forensic mapping and scale drawings and the importance of measurements. You remember all of that?
Yes, sir.
And you would agree, based on what you just said, that you were hired to determine or to see if you can come to the conclusion as it relates to the occupants movement in the vehicle, correct?
Yes, sir.
So all of the questions and talking about forensic mapping and the scale drawings, but whether they were, 12 feet off, 15 feet off, wasn't important to what you were investigating, right?
Not for what I done.
No.
No, sir.
And as it relates to the things that you reviewed, I guess what you would qualify as important to your investigation, nowhere in your report does it mention that you reviewed the crash data retrieval information that we talked about yesterday, correct?
Correct.
And nowhere in your report does it say that you reviewed, again, all of the dash cam from April 9th, 2021, correct?
I reviewed it, but it wasn't part of my deciding factor in what I determined, so I didn't note it in my report. I understand that if it ain't in my report, it didn't happen. That's a cliche in law enforcement, but it wasn't pertinent to what I was there to do, so I didn't note it in my report for that reason.
But I guess I hear you saying that just because it's not in your report doesn't mean you didn't do it or you didn't review it, right?
For what I was retained to do, I put that pertinent information in that report, but I did not list all that I reviewed or watched or looked at.
You didn't review it, right?
Correct.
Now, in your report, you talk about, you said the EMT or EMS records for Mr. Poole, correct?
Yes, sir.
And you talk about the fact that you reviewed the Grady records for Mr. Poole, correct?
Yes, sir.
That you reviewed the Grady hospital records for Mr. Poole. Can you tell the jurors how much of the Grady records for Mr. Poole did you review?
I believe I looked over all of it because it was a lengthy file report from Grady. Because there was some stuff that looked like you had to look. I guess you had to know what to look for it. But I did review the Grady records for Mr. Poole, correct?
So you'd agree the Grady records were roughly, I think it was 2,199 pages, correct?
I don't know exactly how many, but it was a lot, yes.
Okay. And I think you talked yesterday about the fact that you reviewed the photographs that were taken at the scene, correct?
Yes, sir.
Right. And then the photographs that were taken of the 2017 Infiniti Q50 at Dudo's, the record shop, correct?
Yes, sir, that's the inspection photos.
Okay. And can you tell the jury, as it relates to your investigation, did you go to the area of the exit 2 off of Lennox Road at 400 North?
Where the crash occurred?
Correct.
Yes, sir.
And anything about your visit? Well, your report doesn't reflect that you visited the site of the collision, correct?
Correct.
And I guess you would deem that wasn't important to what you were hired for as your part of your role in this investigation for the defense, correct?
Correct.
Now, and then you reviewed the autopsy report for Mr. Minor,
Yes, sir.
and would you agree that the focus of your reason for being hired was Mr. Minor's injuries, correct?
I wasn't aware of it when I was retained for the case. I was just sent the information and I came to a conclusion based off the information. I wasn't informed of hypothesis or assumptions prior to me looking at what I looked at.
And what I would consider to be the cover pages, page 1 of your report. Do you have a copy of your report?
Yes, sir.
And obviously, refresh your recollection at any point, just let all the parties know you're doing that, okay?
Okay.
So, if I was to go to page 3 of your report, in your report, you say the Infiniti struck the wall on the north side of Lennox Road with its front left side. Yesterday, you talked about the point of impact being the front right side. So which is correct?
It's going to be the front right side. That was an oversight on me in that report.
If your report was to analyze the point of impact from being the front left side, as it states on page 3, your conclusions wouldn't be the same, correct?
Correct.
And then yesterday, towards the end of your direct examination, you mentioned several times the term barrel roll. You remember talking about that?
Yes, sir.
And can you point to a page in your report where you discuss what a barrel roll is, or even use the term barrel roll in your report?
No, sir.
And so yesterday was the first time that the term barrel roll in relation to this case, and you had ever, I guess, been told to the parties into the jury, correct?
Yes, sir.
That you say in your report, after striking the wall, the Infiniti rotated and overturned, coming to a final rest facing south and caught fire. That was your conclusion in your report.
That was in my report based off what I deciphered from the skirt report and the crash report. My primary focus was the initial impact with the wall to determine occupant seating due to after the initial impact and the overturning and the path of travel after the initial impact, the occupants would be thrown around the vehicle, for lack of better words, and their seating positions at that time wouldn't be as accurate as they would be at the initial impact. So that's what I focused my primary focus on.
Right. But at I guess the start of where you actually, first paragraph, you said the following was determined from this review and reconstruction, correct? That's what you said?
Yes, sir.
And underneath that is where you make statements about the infinity striking the wall on the north side of Lennox Road from the left side. That's part of your conclusion, correct? I know it's an error, but that's where you were.
That's in my report, correct?
And that's a conclusion in your report.
That is from reviewing the information from the State Patrol reports. I didn't go through there and put it back together and determine that. I utilized what the State Patrol had in their reports and you went with that because I was focused on the primary impact with the wall.
But I get what you're saying now, but in your report, it says the following was determined from this review and reconstruction.
Correct.
Underneath, after you say the following was determined, you then say about the striking of the wall with the car from the front left side, and then you go to say the infinity rotated and overturned, coming to a final rest.
Your Honor, I would object to counsel simply reading from the report. It's not in evidence. If you want to ask him a question to refer to refresh his recollection, that would be more appropriate.
I'm finishing my question. That's different than what you said yesterday.
Okay, don't answer the question yet. Okay. So your objection is that this is not a proper form of impeachment?
That's correct. There's two. It's improper as well as counsel is simply reading from the report procedurally.
Okay, I think you can impeach him with his report, but why don't you first refer him to the segment so he can read it? And then he can own it or disavow it or explain it, whatever he's entitled to do, whatever.
So on page 3 of your report, you have it in front of you?
Yes, sir.
You see where it starts with, I guess the second paragraph. Anywhere in that second paragraph that you mentioned that the car experienced any sort of roll or barrel roll.
Other than overturn, no, sir.
So at no point in your report do you indicate that there was a barrel roll or roll of this vehicle, correct?
No, sir, because I was retained to determine if I could where the occupants were seating during the crash. The only way you can do that is the initial impact with the wall, because after that, like I said, everybody gets dislodged and thrown around the vehicle. So my primary focus was on the initial impact with the wall. And while I had that in my report based off of what I was reading from the skirt report and the GSP crash report, my focus was not on that part of the crash. It was the occupants and the initial impact with the wall.
You would agree that nowhere in the documents that you reviewed, whether it be the skirt report, any reports from Georgia State Patrol, or any of the EMS or medical records, did it indicate that the vehicles struck the wall on the front left side?
No, sir, that's an oversight on my part, and that's just a error on my part with that. That's all that is.
And yesterday you talked about the importance of the timeline of collision and what happened after, correct?
Yes, sir.
Today, are you saying that, I guess that timeline is not important?
Could you explain that differently?
Just said that your focus was on the car, the initial collision
Yes, sir.
with the wall, and then you said people were jostled around. And my question about rotating a barrel roll, you said that wasn't important to what you were investigating.
Objection to the form of the question, or if that even is a question.
I'll ask multiple
Okay.
questions, but I can ask it.
Okay.
So what happens to the vehicle after it hits the wall, whether it be the left or right side, is that important to what you were hired to do as an accident reconstructionist?
I don't feel like the post-impact path of travel or post-impact information was pertinent in determining the seating of the occupants when the initial impact occurred.
that's because of the training that you've received as it relates to the laws of physics and principal direction of force and some of the things that you talked about yesterday, correct?
Yes, sir.
And we can agree that the principal direction of force, as it relates to this collision was front right, correct?
Correct.
So if that vehicle is traveling front and to the right, right?
Yes, sir.
And whether you mentioned it in your report or not, you reviewed the crash data retrieval report, correct?
Correct.
And you would agree that at the point of impact, the vehicle was traveling 78 miles an hour, correct?
Yes, sir.
And that when it hit that wall on the front right side of the vehicle, it was doing that at 78 miles per hour.
Approximately, yes, sir.
Well, do you have any reason to believe that what the data that you saw in the crash data retrieval report is incorrect?
No, sir.
So the crash data retrieval report says that the vehicle hit the wall, the point of impact was 78 miles an hour, correct?
Yes, sir.
And that vehicle is traveling with all its force, 78 miles per hour, front right.
Yes, yes, sir.
So all of the occupants in the vehicle, whether you're the driver, passenger, backseat person, all of the occupants in that vehicle are traveling front right at 78 miles per hour, correct?
When they're traveling the same speed as the vehicle, but when the damage occurs, they're going to go toward the damage profile.
Where's the damage profile, right?
Yes, sir.
Front right, correct?
Correct.
And they're traveling towards the damage profile at the same speed, 78 miles per hour, correct?
Yes, sir.
And when so you would agree that the person sitting in the front right or the front passenger seat receives the first initial impact in that car, right? Let me ask a better question. The person who's sitting in the front passenger seat is closest to the point of impact, correct?
Yes, sir.
And based on what you said yesterday and on your analysis, that person was Devin Jones, right?
Yes, sir.
He ejected from the vehicle, right?
At some point, yes, sir.
Well, based on what you said today, it was at the point of the initial impact, correct? Because that was what was important and pertinent to your investigation, right?
Yes. But that's not when he was ejected.
Let me ask you this, it's possible that he was ejected at the point of impact, correct?
I don't believe that. No.
Okay, tell me why.
Because where he ended up, if he would have got ejected at the point of impact or impact where he hit the wall, he would have came out at that point and not ended up where he did. He is between the initial impact and the final rest of the vehicle, so he got ejected after the initial impact and before final rest. I don't believe he got ejected at initial impact, no, sir.
Okay, so that's your opinion, right?
Correct.
And you looked through all the photographs from the scene, correct?
Correct.
And then your review of the photograph, I guess above the concrete barrier of the overpass on Fort Lauderdale is that chain link fence, correct?
Correct.
So there was damage to that chain link fence above the concrete barrier, correct?
Yes, sir.
Now, you talked yesterday about the center console, seats, things of that nature, right?
Yes, sir.
And in a vehicle, those are, would you consider those to be obstacles or barriers in a vehicle for occupants?
Obstructions, maybe. I wouldn't call it a barrier. I don't think it seals off completely. I'd call it more an obstruction than a barrier.
So you would consider this to things in the way of the occupants?
Yes, sir.
And in your review of all the photographs and the report, you would agree that at no point do the seats come out of the car, right?
Not to my knowledge, no, sir.
And the center console, though damaged, it's still in the same place, in the vehicle, correct? Still in the center,
Yes, sir.
right? It's not gone, right?
No, sir.
Just damaged, correct?
Extensively damaged, yes, sir.
And, as it relates to the front compartment of, the vehicle, you'd agree there's still a steering wheel, right?
Yes, sir.
The dashboard and the front driver's seat, and that goes along to the front passenger seat, correct?
Yes, sir.
And, there's still, I guess, part of the center console that goes up to the middle of where the front compartment is as well, correct?
Yes, sir.
All of those are obstacles, correct?
Yes, sir.
And you would agree that the front, the front compartment, the front of the vehicle, where the driver's seat and the passenger seat are, individually, the driver's seat is its own little compartment, correct?
Yes, sir.
Got, well for your feet, correct?
Yes, sir.
Above your feet, or above that well is the dash area, right above your knees, correct?
Yes, sir.
And, you would agree that it's got the same build on the front passenger side without the steering wheel, correct?
And that without the instrument cluster, but yes, sir, there's a dash and there's a well down there to put your feet in. Yes, sir.
You say without the instrument cluster. What do you, tell me about that?
It's just a dash. It's not, it don't have the speedometer or tachometer or anything like that. It's just a dash.
Now, the back area, I'm gonna go ahead and show you states. 170 through 172. So, you generally recognize, states 170 through 172. I know you didn't take the pictures.
It's the interior of a vehicle. I'm guessing it's similar vehicle to what was involved in the crash.
Let me ask these questions. So prior to your testimony and part of your review of the case, did you look at vehicles or did you Google images as it relates to 2017 Q50s?
Yes, sir. I did a Google image for the interior of the front.
Okay, and in your review, did you do, I guess, searches? Or are you familiar with cars with the size of the Infiniti Q50?
Do-
Based on your training experience, a number of years for state patrol?
Experience with these vehicles in what way?
Size of the vehicle. Are you familiar with vehicles that are similar in size as it relates to the Infiniti Q50?
I guess it's just a mid-size sedan.
So in states of 170 through 172, are those photographs, do they depict a mid-size sedan?
Yes, sir.
Anything about those photographs that doesn't fairly actually depict what you would define as a mid-size sedan?
Well, it's just the interior, but I don't see anything to suggest anything else.
State of Market states 170 to 171.
Is it 170 through 71 or 72?
72.
Three pictures. All right, Mr. Miller.
I would object to a proper foundation for those pictures, being admitted as an evidence. I would not have an objection to them as a demonstrative, but I don't think proper foundation has been laid for them to be admitted.
Okay, I follow you. If they're coming in as a demonstrative, they still can be published and shared. But to me, the distinction would be, would they go back with the jury or not?
That's part of it. I just don't want there to be but that's something that will go to his, wait, so, okay. Yeah, I would still object.
Okay, so what I'm going to do right now is admit them as demonstrative so they can be published and discussed by both sides. And then we'll talk more about ought they be admitted full blown as evidence and go back with the jury. So they'll be made part of the record, Both sides can put them up. The internet's working right now, so they can be up on a screen. But Mr. Miller, just help me remember when we're working through what exhibits go back with the jury. These are for now demonstrative and not evidentiary, consistent with your objection. I know you objected to keep them out altogether, but I think right now we're in that middle space.
What numbers were those?
170 through 172. Does your screen have that? No, it's not good. I want to make sure it didn't have that stay muted box so you couldn't see.
I just pushed it.
Thank you.
So, this is state exhibit 172, that's on the screen before you. And so, are we looking at, it's the backseat of what you would consider to be a typical mid-size sedan?
Yes, sir.
Would it shock you to know would it shock you if this was exactly a 2017 Q50 backseat?
It would not surprise me, no, sir.
So based on your review, your number of years of experience, this is what you expect a 2017 Q50 backseat to look like, right?
Yes, sir.
And we talked a little bit about it, but the two seats, those would be what you would call obstacles or obstructions.
Yes, sir.
And you see the middle console where it's raised up, but you see the air, I guess the vents, right?
Yes, sir.
That's another obstruction, correct?
Yes, sir.
Now, based on what you've talked about today and yesterday on direct, the principal direction of force is front right, correct?
Yes, sir.
So an individual who is seated in for example, the back driver's side seat or in that area is going to go front and to the right, correct?
Everybody will, not the back passenger on the behind the driver's seat will go that direction, but everybody in the vehicle will go that direction also.
Okay. Specifically, right now, I just want to talk about the person who would be in the back seat.
Okay, yes, sir.
That person is going to go front and right, just like everybody else, right?
Yes, sir.
And you would agree that in the foot or feet area of the back seat, it's not built the same as the front driver's seat and the front passenger seat, where there's a true well and other, I call them obstructions, you call them, what do you call them again?
I like your word obstacles.
Okay. Obstacles, in that back seat, right?
Yes, sir. It's just a flat area from the back of the seat, not a cockpit area.
So the person in the back seat would go front and to the right towards the point of impact, correct?
Yes, sir.
So the obstacles in the direction of the person in the back are the two chairs, correct?
Yes, sir.
And that center console, correct?
Yes, sir.
And you talked yesterday about an A and B pillar. In state exhibit 172, is this your B pillar?
Yes.
And so that would also be an obstacle, correct?
That would be an obstacle for somebody sitting behind the passenger seat, or if the direction of force was opposite the front left, that would be where the B pillar would come in to be an obstacle for somebody sitting behind the driver's seat.
So if there's just one person sitting in the back seat,
Yes, sir.
okay? And the point of impact is front and to the right,
Yes, sir.
towards the passenger side of the vehicle.
Yes, sir.
And the person in the back is going front and to the right, correct?
Yes, sir.
The B pillar is in this photograph that I just pointed to in the middle of state exhibit 172. That is front and to the right of anyone seated in the back, correct?
Yeah, but it's not where the direction of force is coming from.
Explain that to me.
Can I stand up and do that? Okay.
Keep your voice up.
Okay, if the occupant's sitting right here
Mhm,
and the principal directional course is up here,
mhm.
it's gonna go there, it's not gonna go right there and take a hard right to the big pillar. It's gonna go more at an angle and not a hard turn, if that makes sense.
It's gonna go front and right,
Yes, sir.
and you agree that this V pillar is front and right to the person sitting right here.
That is correct, it is front and to the right.
So it is a potential obstacle or obstruction in front of the person in the back seat, correct?
It could be.
Okay. Okay. States 171. Okay, in stage 171, we're looking at the driver's seat of a mid-size sedan, correct?
Yes, sir.
And based on what you know, and do you see the steering wheel?
Yes, sir.
You recognize the emblem on the steering wheel?
I see it, but it's an infinity.
So is this, based on what you reviewed and the research you did, is this similar to the front passenger driver's compartment like an Infiniti Q50?
Yes, sir.
Okay, and in looking at State Exhibit 171, can you tell the jurors what are the obstacles that you see based on the training and experience that you have that are in a driver's compartment?
Would the
Front right.
impact, it's gonna be the center console. This area right here, the gear shift is gonna be an obstacle because the driver is gonna go toward the direction of the impact.
Okay, so would you agree that this whole center console is at what you would, in the middle of state 171 is an obstacle, correct?
Yes, sir.
And then underneath, the steering wheel is the dashed area for the driver's side, right?
Yes.
And you've got the steering wheel, that's an obstacle, correct?
Yes.
And then you've got some extra equipment as it relates to the instrument panel that you described on the driver's side, correct?
Yes.
And you would agree that based on your review, that's 2017 Indy Q50 was equipped with side airbags in front, correct?
I do not recall that, but I do not know.
Okay. Would you be surprised if I think it states 37, which is the crash data retrieval report, indicated that there were front side airbags in that vehicle?
I don't doubt it. I just don't recall
Okay, we'll
that
get it in
part.
a second.
Okay.
That's something that you don't doubt, correct?
Correct.
And you'd agree that the front seat area also had another airbag that comes straight out, correct?
Yes, sir.
And can you tell the jurors, in that instance, the airbag, I know you said is for safety purposes, the airbag is another mechanism that is to help keep the person in the area or the seat where they are, correct?
No, sir.
Tell me why not.
The seatbelt is designed to keep you in the seat. The airbag is designed to keep you from hitting the hard objects like the steering wheel and dash and the side curtain airbags that you mentioned, they're starting to get more popular and come out of the A pillars and B pillars and the roof to, to keep occupants from hitting that part, but the airbag is not designed to keep the person in the seat.
Secondary mechanism to, well, one is a mechanism for safety, correct?
Yes, sir.
And you would agree that it's a secondary mechanism that can act or work to keep people contained in an area, correct?
I don't think they're designed to keep people contained in an area.
Well, airbags come out pretty fast, correct?
Yes, but they deflate pretty fast as well.
When they come out with a lot of force, correct?
Yes, sir.
And when your body gets that force, your body does what?
It the airbag absorbs some of the force when you hit it, but it's like I said, it deflates just as quick as not just as quick, but it deflates pretty fast after it inflates, and it's not designed to keep the person in the seat.
Look, well, from what you told us today, it's designed to keep people from hitting a hard object.
Correct.
No, a person, it's designed to keep them from hitting a hard object and then deblocking, correct? Here would say, for example, the B pillar, correct?
Can you repeat that just to make sure I'm on the same page?
You said today that airbags, their main purpose is to inflate and to keep people from hitting hard objects, correct?
Correct.
So in order to keep someone, an occupant in the vehicle, to prevent them from hitting a hard object, it acts as a barrier, an obstacle to that hard object, right?
It comes out from the hard object. A lot of times, like the airbag in the steering wheel or the airbag in the dash, it comes out from there to keep somebody from hitting that. Maybe a slight barrier between them two, but it won't keep an occupant from hitting whatever it is if the seatbelt's not worn properly.
Okay. Someone unrestrained, okay, and the airbag deploys, it still serves the same purpose, correct?
It does, but it's not as safe as wearing a seatbelt.
Of course.
Right. It inflates real fast and keeps the person from hitting the steering wheel or the dash, but it's not designed for anything else other to keep somebody where they're at.
So for somebody who is in the driver's seat of the vehicle, like the one in State's Exhibit 171, the impact of being front and right, like we talked about, okay?
Yes, sir.
And the obstacles for somebody in the driver's seat that's experiencing a front right impact at 78 miles per hour you'd agree, is the entire center console, correct?
Yes, sir.
And you'd agree that the steering wheel is an obstacle that plays a part in an impact like that, correct?
Yes, sir.
And you'd agree the entire front dash is an obstacle that the obstruction that the front driver would hit during a front right impact, right?
Yes, sir.
And there's an airbag that deploys that also can play a part as an obstacle, correct?
Yes, sir.
Because the front, well compartment of the driver's seat, it's not a big compartment, correct?
Correct.
And somebody who's in the driver's seat, when the front impact on the right-hand side occurs, their knees and their feet are in the driver's well compartment where the dash is and where the gas and brake pedals are, correct?
Yes, sir.
And the brake pedal is the one that's furthest from, the center console, right?
Yes, sir.
And, all of those, all while being that front driver's seat is kind of sits lower, in the well, correct?
I guess it can be adjusted however, but it does sit lower than the center console and the dash.
And so you talked yesterday about, I guess, mainly Mr. Minor's injuries as related to his torso, right?
Yes, sir.
And you talked about the fact that he had I guess, a bruise on his right-hand side was consistent with hitting the center console, correct?
Yes, sir. I also believe he had internal bleeding from reading the autopsy report.
Do you believe anything that had related to do Mr. Minor's injuries was only consistent with him being in the driver's seat, right?
Based off of everything I looked at, yes, sir.
You would also agree that if Mr. Minor was in the back seat and he hit any of the obstacles that we spoke about, the two front seats, the center console, the B pillar, those also could create injuries consistent with what Mr. Minor experienced, correct?
I think it's very unlikely.
Mr. Minor had ribs that were cracked. They were 4 through 9.
Yes.
Okay, do you know where those are?
No, sir. I am. I watch a lot of medical shows, but I'm far from a doctor.
So when a person who's sitting in the driver's seat is being forced front and right, he's being facing the center console, correct?
Yes, sir.
He's gonna go predominantly that way, like, so you got the center console is the gear shifter, radio instrument cluster, and on the right side and on the left side would be this side of the steering wheel.
Okay. And you said you worked specifically in the skirt team or with the skirt team about for how long?
7 years, I think, from 2014 to 2021.
And in those years, you sounds like you saw and worked a number of crash things, collision scene, correct?
Yes, sir.
And in those years, you worked with the skirt team. Did you work on collisions that were similar to this front impact collisions at high speed on the right side?
I don't remember one specifically jumping out at me, but before that, I worked in Villa Rica, and we worked pretty much, you can think of it, we worked it there. But I'm sure I encountered one at some point.
Well, of the crashes that you encountered were a number of them front impact collisions.
Yes, sir.
And you would agree that in front impact collisions, that injuries that are commonly seen with those front end collisions crashes are lower extremity injuries, correct?
I have seen some lower extremity injuries from frontal crashes, but I've also learned that there isn't really a rhyme or reason for some of the injuries that occurred during some of the crashes.
You also learned that the prime reason as to why lower extremity injuries are common in front impact collisions is because in the front of the vehicle where the driver and the front passenger are seated, they have all the obstacles that we've discussed. The steering wheel, the dashboard, the feet being housed in the well of where the pedals are, correct?
Yes, sir.
So that's why, isn't that why lower extremity injuries are common to people like the driver in a vehicle?
I I was always, I don't know if I was told this or assumed this, but I was always under the impression that the lower extremity injuries are caused by somebody being either on the brake or on the gas and having a frontal impact and basically the energy going back up through the leg causing uh, injury, breakage, fractures, and from a foot being on the brake pedal or gas pedal.
So, based on what you believe or you recall being taught, in one of your training is that lower extremity injuries are common, especially for the driver, because he or she is working the brake or the gas, right?
Yes, but not always.
And you said something a second ago that there's no rhyme or reason to injuries or, whatever you said as it relates to injuries in a motor vehicle crash.
I've seen um I've seen stuff that's been unusual in crashes.
But the majority of the time in crashes that you've been investigating, the laws of physics and things of that nature, the science has control, correct?
Yes, sir.
And the principal direction of force is something that applies to every investigation that you have worked, correct?
Yes, sir.
And in the last part we had talked about relates to the principal direction of force. An individual seated in the front passenger seat would do the same front right as relates to the impact, right?
Yes, sir.
And that person would hit the front passenger compartment, dashboard, door, things in that way, right?
Yes, sir. Toward the A pillar that way.
The A pillar, we're looking at states of the 171, is the A pillar this middle thing right here?
Yes, sir.
Right behind, I guess, in the picture, it's right behind the visor, right?
Yes, sir. It's on the edge of the windshield on the passenger side.
Okay. And you would expect, like you said earlier, like all occupants, that person is going to the front right of the vehicle because of the principal direction of force, right?
Yes, sir.
Judge, Your Honor, asked and answered.
Sustained.
Now, as it relates to injuries, because you said that was your main focus, right?
Yes, sir.
In your report, you indicate on page, or but I would get to the page eight. The only mention of Mr. Poole's injuries other than that he had burns was that he sustained abdomen injury in the crash. That's the only injury you described in your report, correct?
I don't recall exactly what I put in there, but if that's what you're saying, I don't.
Yeah, right.
Yes, sir.
You need to review your report in order to refresh the recollection as to what you notated Mr. Poole's injuries were in your report. By all means, just look up when you're done.
Are you talking about
I'm asking, in your report, isn't it true that the only mention of Mr. Poole's injuries is you said that Mr. Poole, during the motor vehicle crash, received or got abdomen injuries?
what page did you say that was on?
Page eight.
I don't know if they have numbers. Are you able to show them what page
Yeah.
it looks like?
This, what I'm thinking, page eight. And for the record, and for all parties, there are purple underlining of that report. No notes, no secrets.
And you can take it back once he's looked at that, but it's helping him find which page on his report.
Okay. I did list Mr. Poole's abdomen injuries in there, but that wasn't the only injuries that I listed for him.
What injuries in your report did you list that Mr. Poole received, other than those abdomen injuries and injuries that he received from burns?
It was the facial burns from the oil and the abdomen injuries.
So what he just said.
Yes, sir.
Okay.
So in your report, as it relates to Mr. Poole's injuries, you don't list or mention that he had a right femur fracture, correct?
Correct.
You don't mention that he had, I believe it was a left tibia fracture, correct?
Correct.
And you don't mention that he had fractures or broken toes, correct?
Correct.
All of that was not included in your report, right?
Correct.
So if it's not in your report, you would agree that those injuries were not important to your analysis, right?
Correct.
So the lower extremity issue are injuries that Mr. Poole sustained. You didn't even use as part of your analysis and conclusion in this case, correct?
Not when I took totality of the circumstances into consideration.
Well, if you're taking the totality of the circumstances into consideration, all of the injuries for all of the occupants would be important, and that would actually be the totality, correct?
Yes, sir.
And you can do that.
I looked at what was more likely than not to cause the injuries to a suspected driver that I determined that I suspected Mr. Minor was the driver.
Well, when you started your investigation, you said it was independent, correct?
Correct.
So would it be fair to say when you started your investigation, you didn't know who the driver was, right?
Correct.
You're starting with a clean slate, right?
Correct.
So if you're starting with a clean slate, you would consider all injuries, correct?
I did look at all of them, but just because it's not noted in my report, it doesn't mean I didn't look at it.
But you would agree in your report, you extensively cover and explain and detail the injuries that you read in the autopsy report that Mr. Minor had sustained, correct?
Yes, sir.
To the point where you verbatim wrote in your report the internal injuries you talked about that Mr. Minor received, correct?
Yes, sir.
Nowhere in your report did you find it important to reference the serious injuries that Mr. Poole sustained, correct?
Correct.
And femur, based on your training and experience, is a hard bone, correct?
Yes, sir.
So I want to show you page 10 of State Exhibit 137. Excuse me, page 11. Now, as it relates to the ACM of the crash data, the information from the ACM, so the crash data retrieval information, you said during your number of years with Georgia State Patrol, you performed, I guess, the retrieval of that information.
Yes, sir.
And I think a little bit described the process yesterday, remember that?
Yes, sir.
And as it relates to the events, isn't it true that the CVR or the little black box, it only records or holds 2 events at a time, correct?
It depends on the manufacturer. Some hold more, but in this instance, in this ACM, there was only 2 events listed.
That's how it is wired, that's all it's wired to hold at a time, correct?
I'm not 100% sure for this manufacturer, but some can hold more and some can't. But if it can only hold 2, then I'll take your word for it, but I don't know that for sure.
You don't have to take my word for it. You'd agree that at the first couple pages of all crash data retrieval information, it's the definition section that talks about
Yes, sir.
The things you'll see, correct?
Yes, sir.
And in and on that definition page, it tells you that it only holds two, events at a time, correct?
Okay.
Asking,
If that's what you say, I'd take your word for it. I have no reason to doubt it.
reviewing, right?
Yes, sir.
And so I want to go to event number 2. And you see that pretty clearly?
Yes, sir.
All right, you see, in the first column, it says time stamp.
Yes, sir.
5 seconds, right?
Yes, sir.
That means, that's the information that that was recorded as it relates to 5 seconds for, the collision, correct?
Yes, sir.
Then if we were to go down, 0 is 0 seconds, before, that's the point of impact, correct?
Yes, sir.
And you see 1, 2, 3, to the second to last box, or excuse me, column where it says service brake on or off.
Yes, sir.
And you see where it says 5 seconds prior to, the collision, it says off, so the foot's not on the brake, right?
Correct.
And then do you see from 4.5 seconds to the point of impact, at the point of impact, it says on all the way down, brake activated, right?
Yes, sir.
So you would agree that the person driving the vehicle at the time that the collision occurred had their foot on the brake, correct?
Yes, sir.
As we talked about earlier, lower extremity issues or lower extremity injuries are typically sustained because people are activating the brake at the time of the collision, right?
Yes, sir.
And so you would agree that a femur fracture, tibia fracture, foot, toe fractures are consistent with the person driving the car, correct?
Sometimes, yes, sir.
But in your report, there's no mention of what we just talked about as it relates to the specifics of for the brake being compressed or not compressed in your report, like the CDR shows, correct?
Correct.
And you would agree that that information, based on your training and what you've been taught, as it relates to lower extremity injuries and how they're sustained, have the importance to include in your report, right?
Yes, sir.
You did.
Correct.
It didn't coincide or meet with the conclusion you were here to talk about today, correct?
It didn't. All the information is important, but it was not what I utilized to come to my conclusion.
So because it wasn't what you because it didn't, I guess, there was facts that didn't help your conclusion, you left them out, isn't that correct? Because you reviewed them.
There was a lot of information. I couldn't put all of that in my report. I reviewed all of it, but I didn't put all of it in my report.
You say you didn't put all of it in your report. You didn't put the information related to Mr. Poole's full spectrum of injuries in your report, correct?
Correct.
You didn't put the information, you didn't really put any information related to the crash data retrieval report information, correct?
I felt like the skirt report was primarily focused on that and the speed, so I felt like that part was covered. I reviewed it, but I didn't focus on it entirely.
There's no mention of the CDR information that we're looking at here in dates 137 on page 11 in your report, correct?
Correct.
And you would agree, in order to have a conclusion based on the totality of the circumstances, which you said, this information would be important to see and I guess include as it relates to your conclusion.
It was reviewed, but it was not included in my report.
Let me ask you this question. Anybody who was to receive your report, how are they to know that this was part of the review?
Uh, I don't,
Objection of relevance, Your Honor.
Overruled.
I did not list everything I reviewed in this report. Since this time, I've changed how I do my reports a little bit and I list everything that I review. But this case, I did not list everything I reviewed and did not list the CDR information.
The change that you just described, when did you put that, the change relates to listing all the things you reviewed in the process?
I don't know exactly when it was,
6
Probably-
months, a year?
probably in the last 6 months, 6 to 8 months, maybe.
Okay, and you said you authored this report, when?
I believe it was last year.
And was there anything keeping you from, modifying or doing an addendum to this report as it relates to the things that you reviewed and you talked about today?
I could I could have modified it or edited or changed it, but when I excuse me, when I done this report, I was under the impression that it was going to be going to court sooner than it did. Had I known the time frame of this, I would have modified it and done it, added more information to it.
You agree that from whenever you did this report, whatever, a year or so ago, you've had conversations about the case and the upcoming proceedings for today, correct?
Yes, sir.
During those times, or those times would have been opportunities to put your new practice into place and do an addendum and things of that nature, correct?
Yes, sir, but I'm not real sure on editing or supplementing a report that I've already turned in, and I should have spoke with Mr. Miller about that, but I was erring on the side of caution, not trying to look like I was changing it to change the outcome of it.
And lastly, as part of the training and experience that you've had working these kind of incidents and collisions, you don't talk about the position in which an occupant is found in a vehicle, the importance of that to your investigation, right? We haven't heard about that.
Not after they're not restrained and they're thrown about in the vehicle after the series of events to come to final arrest.
But that will be a part of the totality of the circumstances of your review, correct?
It would, but it wouldn't be pertinent to what happened pre-crash, pre-impact.
Why not?
Because during the sequence of events, at 78 miles an hour hitting a wall, things are going to get thrown around the vehicle. And then when the vehicle overturns, things are again going to be thrown around the vehicle. So it's not going to be how it was prior to the impact.
Okay. But how they're found, in your, I guess, opinion, is not important to your investigation.
Not to determine who was sitting where pre-impact, no, sir. Unless they're wearing seat belts and still in the original seat when that wasn't the case in this.
Your review and what you put in your report, Mr. Poole was found in the front compartment of the vehicle on his back, correct?
Well, he was on the roof being the vehicle was upside down, but I believe he was over the front seats.
And your report indicates his head is kind of out the passenger compartment of the vehicle and his feet are near the steering column, is what you write in your report, correct?
I believe so.
And you don't mention it in your report, but in your review, would you agree that Mr. Minor was found in backseat of the vehicle?
I believe that's where he's listed on the crash report, but I didn't I don't think there was any EMS reports on Mr. Minor that had access to.
You didn't review an EMS report from Mr. Minor.
I don't think it was included in the original discovery.
Watch the dash cam and the body cam from the Atlanta Police Department where you can see Mr. Minor being extracted from the back seat of the vehicle.
Objection to counsel testifying to what's in the video.
Sustained.
Did you watch the part of the vehicle or the videos, whether it be the dash cam or the body cam of Atlanta Police Sergeant Matthew Stinson, where the extraction of Mr. Poole and Mr. Minor occurred?
I watched the dash cam from the trooper. I didn't watch any body cam from APD. No, sir.
Dash cam of the trooper. Did you watch the part where the extractions occurred?
I don't recall if the video stayed on through that time. It may have, but I know at one point there's a lot of firefighters or EMS around the vehicle and you can't really see what's going on during there, but you can see Mr. Poole halfway out the passenger window right after, I believe it was Trooper Clark came up on the wreck after the car came to final arrest, and I believe he put the fire out with his fire extinguisher, and you could see Mr. Poole out the passenger window.
So I want to, I guess, finish up with making sure I understand what your conclusions are, okay?
Okay.
So with the principal direction of force being front right, like you said yesterday and today, all occupants in the vehicle are moving to the front and to the right, correct?
Objection asked and answered.
Several times. Next question.
So, can you explain how, well, let me ask you this. If Mr. Minor and he's found in the backseat of the car, can we agree on that?
I believe he was found over the back seat. Yes, sir.
Found laying in the backseat, correct?
Objection, no foundation's been laid for that. He's already testified he didn't.
I see that. So when you reviewed all of the documents that relates to the skirt report, the reports of the members of Georgia State Patrol, all of the documents and the videos that you reviewed, were you able to see in those reports and in those videos where Mr. Minor was found in the car?
The crash report had him listed in the back seat.
And where he is, okay, the crash report had in the backseat. Would you disagree that that's where he found the car when he was found extracted from the vehicle?
I do not doubt that he was extricated from the back seat after the car came to final arrest.
Okay.
And the reason I'm hesitant to answer that is because the vehicle's on its roof, so it's upside down, so he's laying, I guess over under the back seats at that point. But yes, Mr. Minor, I believe, was on the roof under the back seats or over the back seats, however they are, and then Mr. Poole was in the front area, passenger area.
I guess you feel more comfortable with my question. Is Mr. Minor found in the back of the vehicle?
Yes, sir.
Regardless of whether it's on its roof or it's right side up, in the front compartment of the vehicle?
And the back one. Yes, sir.
The things that are separating the front from the back of the seats, correct?
Correct.
And based on what you told us as relates to principal direction of force, and everyone's moving front and to the right. So you said well, explain how he's found in the back, based on principal direction of force.
The principal direction of force and the initial impact would not have anything to do with Mr. Minor getting to the back of the vehicle. That would, when the vehicle, after the initial impact with the wall and the vehicle continues on its path and overturns and rotates, that's when the occupants can get rearranged, for lack of a better word.
When occupants are however occupants are rearranged in a vehicle during a crash, the force in which the occupants are all receiving it, it's still the same for each occupant. It's still front right or front left. All the occupants are going in the same direction at all times, correct?
Yes, sir.
So it's your testimony that Mr. Poole went front to right, correct?
Yes, sir.
And then it's your testimony that Mr. Minor went back to the front, front to back. They're going the opposite direction based on.
Your Honor, he's mischaracterizing.
So you'll get to redirect. I think it's an appropriate question. Can you take down on the screen, unless you're still using that chart?
Well, we asked the question. So the principal direction of force, you said, Mr. Poole went front and to the right, correct?
Yes, sir.
And based on your testimony and where Mr. Minor was located in the back, you said he originated as the driver, correct?
Yes, sir. That's what I determined.
So based on where the driver's seat is located, it's no mystery, right?
Correct.
And Mr. Minor said it ends up in the back, right?
Correct.
You're saying that he went front to back, correct?
Not at the initial impact, no.
Well, the initial impact, which way did he go?
Front to right.
And like all occupants, right?
Yes.
And no matter rotational, whatever, a spin, the cars to roll, any of the things that happen to a car, the force that the people in the front and the back feel are the same, correct?
With the initial impact, correct.
Well, that's with all impacts, correct?
Well, the initial impact in this one, it basically dislodged the occupants from their original seating, so they're no longer in a seated position. They're going to be more riding the interior of the vehicle, depending on where they was at. And then when it overturns and rotates, they're basically sliding on the roof of the vehicle on the interior, so Mr. Minor can get with the vehicle sliding and rotating to come to final rest facing the way it originated from. Mr. Minor can get spun around in the vehicle and end up over the back seat.
And over Mr. Poole.
With Mr. Poole going through between the seats, he's going to be lower than Mr. Minor, because when he hits that center console, it's going to go down. It's going to obstruct him. He's going to hesitate for a second. Well, Mr. Minor, when he hits the interior, it's going the way that the interior of that car is designed, it's going to be like a ramp because it goes up. It's going to hit it, and when it overturns, they're going to be on the roof of the vehicle.
You don't have to wait to him.
Okay.
For him, you should keep talking.
And with the rotation of the vehicle, it's going to spin, and with them being in the vehicle like that, they're not going to be bound by the seats that they were sitting in, because they wasn't restrained to them, so they're free to move as it rotates.
Okay. You would agree that where Mr. Poole is found is like almost in the direct pathway of where, the same pathway as Mr. Jones, correct? He just wasn't ejected.
Correct, because Mr. Jones was already kind of at the threshold with the initial impact hitting the wall, and then when it overturns, that creates a avenue out of the vehicle. Well, Mr. Poole is going to be between the next one up, I guess, basically, And then Mr. Minor's gonna rotate around because he didn't go out of the vehicle. He stayed in the vehicle.
The next one up would be the second person closest to the point of impact, right? Based on what you testified to.
Well, Mr. Poole would be coming from the back seat between them, basically.
So the person closest to the point of impact is the front right passenger, right?
Yes, sir.
This person who is the next closest, or second closest to the point of impact is gonna be the driver, correct? Front.
Yes, sir.
back, yeah,
Yes, sir.
and you would agree that Mr. Poole pathway of travel, or you would agree the driver's pathway of travel is similar to the one that Mr. Jones takes, correct?
Yes, sir.
Except for the driver of the vehicle has obstacles like the steering wheel, the dash, the driver's footwell, where his feet are pressing the brake, correct?
Yes, sir.
That would lead to lower extremity injuries, most likely, correct?
Yes, sir.
Which Mr. Minor had none of.
No, I don't believe so. No, sir.
Do you need a review report? Did you notate that Mr. Minor had any lower extremity injuries?
I don't recall any. All I remember is the internal stuff and the side and the rib injuries.
Disagree. The fact that Mr. Minor experienced no lower extremity injuries.
I believe you. Yes, sir.
And against the principles that you've talked about today and yesterday as it relates to the principal direction of force, the laws of physics, it's your testimony that Mr. Poole is the backseat passenger and Mr. Minor is the driver, and they basically do the opposite of each other, correct?
They get rotated around. Yes, sir.
Well, you'd agree based on what you testified today that Mr. Poole, based on your conclusion, isn't rotated at all. He's still going in the same direction of principal direction of force, front right.
During the initial impact, but when the vehicle's on its roof rotating after it's overturned, that direction is no longer where he's headed.
And in your review, were you able to notate or determine the height and weight of Mr. Poole and Mr. Minor?
I believe the incident report had them all about the same size.
Okay, so you reviewed the medical records, correct?
Yes, sir.
Reviewed the EMS reports, correct?
Yes, sir.
And the autopsy reports, correct?
Yes, sir.
And in those reports, they all specifically notate the height and weight of each individual, correct?
Yes, sir.
So that would have been part of your review, right?
Yes, sir.
Nowhere in your report is that notated, correct?
Correct.
You would agree based on the things that you reviewed, pictures, things of that nature, that Mr. Poole and Mr. Minor, they're full-grown men, correct?
Yes, sir.
And somehow they're able to, these full-grown men are able to switch places in a small compartment vehicle, correct?
Well, you make it sound like it's magic or something, but
He hasn't had the opportunity to answer.
Just let him answer and you can respond with a question.
at 78 miles an hour, that's a lot of force. It's not like they're doing the tango or something to switch places. They're basically getting thrown around in the vehicle because at 78 miles an hour, that's a lot of energy. So it's not like a simple them walking around or moving around the vehicle. It's them being thrown around the vehicle.
Thrown around in a vehicle that has a bunch of obstacles that they're encountering, correct?
I believe it'd be less obstacles when it's on its roof.
I believe it'd be less obstacles when it's on its roof.
The way with the induced damage from the impact, the roof is going to bow some, so it's not going to be as tight to the top of the chair seats as it was pre-impact. So it would, I guess, allow for more room to go between the roof and the top of the seats.
When it's on the roof, it's going to be, when it's flipped over and it's on the roof, you're saying it's bowed?
Well, in the initial impact where it hit the wall, the induced damage where the window's busted, it's going to create a bowing.
That I follow, but I'm curious from your experience, and then you're saying that it turned over, and so now the full weight of the car is on the roof.
Right,
Um,
it didn't crush or anything. It may have did a little bit in a certain area, but the, the whole thing is not like it was pre-crash, so it's gonna be,
It's true.
the Boeing is gonna have it to have more room up there between the roof and the top of the seats.
Okay.
Is that for both sides?
Depending on the damage profile, but it probably more in the middle, just based off of how it is, but it it may be lower on one side, but I feel like I think it's probably about the same on both sides.
But room for front and back to swap places, basically, right?
Uh, yes, sir.
Thank you. No further questions.
Mr. Miller. That's you.
Good morning, Mr. Swan.
Morning.
Going to, on cross. You stated that it was unlikely that Mr. Jones would have exited the vehicle at initial impact. Do you remember saying that?
Yes, sir.
All right, and your determination of that was based off of what?
The location of Mr. Jones's body.
Okay, and when you're making your determination, do you look at physical evidence at the scene that also would corroborate your finding of when he would have been ejected from the car?
Um,
Is that something that you would do?
yes, sir.
All right, now I'm showing you uh you said that it is very unlikely that it would have been an impact. I'm showing you Defense Exhibit 39. I'm sorry, States Exhibit 39. You said that it would be very unlikely at impact. Looking at States Exhibit 39, is that physical evidence that would corroborate him coming out at a different time?
Yes, sir. It if he would have came out at impact, he would have came to rest closer closer to where the impact occurred. Um, with the vehicle overturning after the initial impact is more feasible as to where he came to rest being thrown out after the roll than the initial impact.
All right. Now, in States Exhibit 52, on cross, the state discussed the damage that was done to that fence. Do you remember that?
Yes, sir.
The damage done to that fence. Damage done to that fence, could that have been caused by Mr. Jones hitting the fence?
No, I don't believe so. No, sir.
And now looking at you stated once the car, that Infinity went across the once it went across the intersection, that it hit that wall and then it did a barrel roll,
Yes, sir.
correct?
Yes, sir.
Um, to support that it did do a barrel roll, there is physical evidence. Is there physical evidence on the wall that corroborates that? I'm trying to show you. David. The space exhibit 51. In States Exhibit 51, and you can look on the screen as well. Is there corroborating physical evidence at the scene that supports a barrel roll in this case?
The vehicle ending up on its roof is an indicator that it did roll. The striations on the wall, they're going in an upward motion, so that means the vehicle hit it and went up, and it couldn't go through it, so it's going to be redirected to the right, so it's going up and over.
All right, and you stated that you did actually visit this scene, correct?
Yes, sir.
Can you still see the evidence that that vehicle did a barrel roll when you went to see the scene?
I know the wall was still damaged. I don't recall if the striations were still on it, but I remember that the wall was still damaged.
And you, when the vehicle initially hit the curb, you described that it would be similar to running over a speed bump very
Yes, sir.
quickly. Is that correct?
Yes, sir.
Now, with that, you stated that the occupants would jump in the air at that point.
Yes, sir.
Is that correct?
Yes, sir.
Now, with regards to Mr. Minor, or we speak generally, with regards to the driver, would that motion of them lifting up in the air quickly, would that expose the torso of that individual?
It would elevate it, more than normal.
And so if a person is going to the front right at the driver, if a person is going to the front right, would you expect for, or would injuries to the right side of that torso be consistent with that driver going forward and to the right?
Yes, sir.
Would I'm showing you defense exhibit. Defense exhibit 3. I'm showing you defense exhibit 3. And the abrasions that we see in defense exhibit 3, are those consistent with the individual going um forward and to the right towards but the that dashboard area of the vehicle?
Are you speaking of the marks on the chest on the right side?
Correct, right.
Yes, sir. That would be consistent with that. Yes, sir.
All right, and then you stated that airbags do not keep people in the area. That's the job of the seatbelt. You remember stating that?
Yes, sir.
And the deflate of those airbags, do you know if it is just as quickly as the inflation of it? Are you aware of that?
I'm not aware, but I don't think it's as quick as it gets inflated because it gets inflated super quick. But I believe they have like a hole in the back of them, so that way they kind of deflate right afterwards. It's not a long process.
So it's not a long process. And when an individual is unrestrained, the effects of those airbags, would you say that it's lessened by that? And let me rephrase. When a person is unrestrained, the effects of those airbags are not going to have the same effect as they would if a person actually had their seatbelt on. Is that correct?
Depending on where the impact is, it'll soften the blow a little bit, but it won't be a lot of help, I guess, at that point.
All right. And when when you were asked to look at this file, you stated what all did you have, or what all was sent to you in order to determine, in order for you to make your findings?
I don't recall exactly what all was in there, but it was the Dropbox link that the DA's office had sent you with all the discovery, autopsy reports, medical records, skirt reports, EMS reports. There was a lot of information.
All right, and that Dropbox link, There was no body cam footage in that link, was there?
I didn't recall.
But defense counsel decided to send it to his own expert.
So why don't you lay some foundation for your question?
That it was your understanding that everything that was that defense counsel had at that time was given to you to make your determination. Is that correct?
Yes, sir.
And when you were given that information, you stated that you did not have any type of hypothesis. Is that correct?
Correct.
All right. So when you were given that Dropbox, did you have any idea what defense theory of this case was?
No, sir.
The determination that you made on where each person was sitting in that car was based off of what?
Matching injuries to the damaged part of the interior of the vehicle.
Now, going to that damaged portion that is on the interior of the vehicle. Looking at that damaged portion of the vehicle, I'm showing you states 83. I'm showing you states 83 and 106. Now, looking at states 83, the damaged portion of that vehicle, where that center console is, that based off your training experience, that tells you what?
That it was hit by something.
All right. And then looking at one oh three. And we see in states 103 that there's a Boeing 106, for the record, 106. We see that that passenger seat is bowed, as you described it. And looking at that in conjunction with 86, where the damage is to that center console, what does that tell you?
Something went through them seats. Something caused them seats to bow out.
All right. And then matching that, excuse me, matching that up with the injury profile of Mr. Poole, is that how you determined that he was in that backseat? I'll rephrase.
Okay.
Are those some of the factors that you used to determine the positioning of Mr. Poole in that car?
Yes, sir.
All right. So there were, it just wasn't these two determining factors. Is that correct?
Correct.
And would you also agree that when you are trying to place individuals in a car, you have to look at everything to make that determination? Is that correct?
Yes, sir.
And so an individual who only has injury to their femur, that by itself, would you agree that that's not all of the circumstances of, that's not all of the determining factor of where a person is in the car, correct?
Correct.
Would you also agree that while a person that has just one single injury, you have to look at more than just what that injury is to determine where that person was in the car?
Yes, sir.
And your determination is corroborated by other factors in that car. Is that correct?
Yes, sir.
All right. Now, you're talking about or the state brought up the AC. Oh, another thing. That seat, is, if a seat is leaned back, does that open up more space in that center area for an individual to go through it?
It would have more room on between the top of the seat and the roof because it's laid back. It's not straight up.
All right. And do you think it would help the jury to understand the movements of the body if you were able to draw it?
Um, I don't, I think these pictures are pretty good for what we're looking at. Um, I don't think I need to draw at this time.
Okay, all right. Well, let's do this then. You were discussing on cross that all individuals are going towards that A pillar. And Council, Mr. Abate,
Your Honor, we lost our screen back in.
Okay.
and Mr. Abate, this made mention of the B pillar. And Mr. Abate made mention of the B pillar as an obstruction, correct?
Yes, sir.
All right, and so A pillar is this pillar here, correct? B pillar is this pillar that's right by the passenger seat.
Yes, sir.
Right. If this seat is leaned back, is that an obstruction that would make it harder for a person sitting in that seat to go towards that B pillar?
It would because but that person would be going more, if they're sitting there, they're gonna be going kind of in a direct path to that, so they would be more going toward the front of the vehicle and not to the side of the vehicle.
Okay. And so for the type of impact in this collision, would, could you say that that B pillar is a non-factor?
Yes, sir.
And you're describing how everyone would move in the car after impact. And you stated everyone was going towards that A pillar. Now, when Mr. Minor gets to that A pillar, would Mr. Jones already be there?
Yes.
And as the car has the delta V in that change of direction, would all of them still be trying to go towards that principal or the area of impact where that impact was?
Not after when it initially hits it, they would be going toward that, but when the vehicle's going up the wall with the striations after impact, when it's going up the wall to the left, and then they wouldn't be going that way anymore.
All right, and so at that point, they are just it's you said it yesterday, is freestanding or free falling in the car? What was the word you used?
I don't recall. Free floating or
Free floating in the car.
yes, sir.
And so at that point, those individuals are free floating in the car. And so once that car is still traveling, is that correct?
Yes, sir.
And you made a mention of the path of least resistance. Could you explain the path of least resistance to the jury?
It's basically like no obstructions like water. If you pour water somewhere, it's going to go with the path of least resistance. It's going to go the easiest way that it can go without finding some kind of obstacle or obstruction.
All right. And so the path of least resistance with Mr. Minor, you were stating that because Mr. Poole was hitting that center console, Mr. Minor would be above him. With that path of least resistance, then push Mr. Minor behind to the back of the car.
As it's rotating, and if that passenger seat's down, like you mentioned in the B pillar picture, it would allow a lot more room for someone to go between the roof and the top of the seat. And as that vehicle's rotating, it would most likely put Mr. Minor in the back seat as it's rotating after the initial impact.
All right. And you stated all of this happened in the blink of an eye. Is that correct?
Really fast, yes, sir.
On cross, Mr. Abate described these three individuals as big grown men. Do you remember him stating that?
Something to that effect, yes, sir.
All right. These, in your review of this, of the medical records, did you see that anybody was over 6 feet tall?
I don't recall if I did, no, sir.
All right, and you don't recall anyone being just like bodybuilder or?
No, sir. They all appear to be slim, build, no, not obese or anything like that.
And so when it comes to variables and factors in a collision, with the fact that individuals are smaller in statute, make it easier for them to maneuver after a collision where they are unrestrained.
Yes, sir. They would be. It would be more likely that they would be able to access places that would seem difficult otherwise.
And you stated that the roof would bow at initial impact. And I know we talked about contact damage versus induced damage. That bowing factor, what type of damage is that? Is that contact or induced?
That's going to be induced.
That's induced. And so where normally a roof might be more flat, once that induced damage occurs, you're saying that roof would be more of like a dome? Is that fair to say? Or
Yes,
how
sir.
would you characterize it?
A dome would be pretty close. It'd be more rounded instead of flat.
In your report, um, where it talks about all right, in your report on the third page, Mr. Bate discussed that you never put that the car did a barrel roll in there. Is that correct?
Correct.
All right, now in your report, where you are discussing, excuse me, on that third page, what happened? What was that based off of?
That was based off of just reading the skirt report and looking at the crash report.
Okay, so what your report has is what happened in the crash is detailing, or is, I guess, mimicking what Skirt has in their report. Is that correct?
Yes, sir. I did not do, I guess, an independent path of travel determination for the vehicle because that wasn't my primary focus for my report.
And And in your review of the the medical records, the ME reports, the injuries that were sustained by Mr. Minor were more consistent with the individual that would have been hitting that front console dashboard area of the car. Is that correct?
Yes, sir. That's what my determination was.
All right, nothing further. Thank you.
Any recross?
There you go.
Deputy Gordon, if you would collect any questions from the jurors. Jurors, you're going to take your morning break a little late, but this is a natural break point while the lawyers and I talk about your questions. Appreciate you bearing with us as we got through the testimony. Thank you. So during the break, please don't talk about the case, do any outside research. But when we bring you back out here, we will go through the phase of asking any of those questions that are legally appropriate to be asked, and we'll go from there. Thank you.
All right, agree.
How long is the break?
8 minutes, maybe more.
Yeah.
All right, Mr. Swanner, you're on break for 5, 6, 7 minutes. We'll see how long it takes. I'm going to talk with the lawyers some, then give them a little break, and we'll pick back up.
Okay, can I just leave this right here?
Should leave it right there. Thank you. All right, Ms. Rivers, we're gonna be on break. I'm gonna talk to the lawyers back there, but we're gonna be on break. And then we'll get things on the record before the jury comes back in after your break.
Okay.
Yes, Your Honor.
Okay, Mr. Poole, when you and I spoke last week, you had shared with me that you understood your rights to testify and not testify. And at that juncture, you had expressed an interest or a desire to testify. And I found that that was a knowing and intelligent exercise of your right to testify. As we progressed through the trial, Mr. Miller indicated that you might be thinking about things differently, which is perfectly okay. I need you to share with me now on the record what your choice is, because we're just about done with Mr. Swanner, and we probably won't take a break after the close of his testimony before I ask Mr. Miller to call the next witness. So is it still your intention to testify?
So not,
Okay, you are choosing not to testify.
yes, sir.
All right. And you've had an opportunity to think through that. All right. Well, one, I find that you are knowingly, intelligently, and voluntarily deciding not to testify. And two, as I shared with you before, I'm going to add a charge to the jury charge, and I'll share it with all the lawyers before the jurors would see it, that instructs the jurors that they are to draw no conclusions at all, but in particularly no hurtful or harmful conclusions from the fact that you didn't testify. I don't talk about exercising your right to silence. I simply say when a defendant chooses not to testify, juries to draw no conclusions from that. So I will tell them that, okay? All right. Mr. Miller, anything else you want to talk about or get on the record before we bring the jury in to wrap up Mr. Swanner's testimony?
Would now be appropriate time for me to make my record on what we were talking about this morning?
The subpoena?
Yes.
Yeah, why don't you? My guess is we will break for lunch once you rest. But why don't you finish fleshing that out? I observe, but I know you'll get this on the record. I think the state got you a copy of the subpoena, so we're now in a better position for you to share what you want to share about the subpoena for Doctor.
Right. And I would like to make the subpoena a part of my record, which was shared with me. And we'll call it. Witness, I mean,
I got it. We have one of the ones you call like 37.
we'll call it Defense 37. And with the understanding that it will not go back to the jury.
Okay, but it's being made part of the record. I think that's appropriate. So defense 37.
But it was shared with us as a subpoena. And I would note, Your Honor, that one, the state did proffer, or Mr. Rao did proffer that the witness was not actually in court yesterday. And so it would be some communication was over the phone. On the subpoena that was given to us, it states that
Thank you.
the date that he was to be subpoenaed was December 9th. Law states that they must have a day in order for a subpoena to be effective. It must be a day. We don't know the time, so if we're doing a 24-hour, full 24-hour, we'd have to flesh that out more. But even more than that, the subpoena is not signed, is not acknowledged by the witness, and it is not a proper subpoena that would be enforceable in order for them to ask for a motion to compel.
So what's the law that you say says 24 hours? You cited a statute during round one of this discussion, 24-13-24, that talks about how service may be affected. Let's just, so we're making a full record, what is this law you're talking about that says it has to be 24 hours in advance?
Yeah, it's in the footnotes where it goes to timeliness,
The footnotes of what?
24-13-26. Where it looks at Eubanks v. Brooks, 139 GA App 166, where it said the trial court could not impose sanctions upon a witness who failed or refused to appear in answer to a subpoena served less than 24 hours before the required appearance. Also Byron v. State, 229 Georgia Court of Appeals, 795. Trial court did not err in failing to enforce defendant subpoenas because the subpoenas were not served more than 24 hours prior to trial. The distinction in this case is not only was it not served 24 hours before trial, it was literally served in the middle of trial, Your Honor. And so I'm trying to see if there's more.
And Judge, while he's looking, can I just ask one question? Wouldn't the appropriate party be making this record to be the attorneys for Brady? Or is that inappropriate?
I'm going to talk about that. And Mr. Poole and I already engaged on that. And he gave me his perspective that he thinks this implicates the due process rights of his client. I want to let him make a record. And that's what's happening right now.
And that's Your Honor. And then there's another one, Buster v. Poole, 279 Georgia Court of Appeals. Because the driver waited until the eve of trial to serve Dr. with subpoena for doctor's testimony. The service was not reasonable under there. It says under former OCGA 2410-25A. With respect to service to the Grady Legal Department, our office was not able to contact Grady Legal in order to speak with the doctor. We've not had an opportunity to, still have not had an opportunity to speak to the doctor. It's now after 10. I don't see my investigator, but I understand that he's still not here so that I could have so I could talk to him and see what the substance of his testimony is going to be. We've not had that opportunity. Grady Legal closes at 5 o'clock. We left the court at 5:45 yesterday. So it would have been impossible for us to contact them in order for us to get him. Yeah, that's all that I had.
Okay. So a few things, 241326, the statute that you pointed me to, Mr. Poole, and which the couple cases you just cited relate to, are if a court is seeking to hold someone in contempt for failing to comply with a subpoena, and that's where the 24-hour rule is. I'm not trying to hold anyone in contempt. I hope I don't have to do that. That is a tool of last resort. So I don't think those are quite on point. What I think is most on point is this question of standing. And there are cases in which defendants have sought to suppress evidence, and that's in effect what's happening here. You want to exclude the testimony of Dr. Hernandez. His full name is longer than that. I'm going to say Dr. Hernandez for short, because of a defect you think exists in the subpoena. This has been tried before, and the appellate courts have routinely and consistently said a defendant lacks standing to challenge a subpoena to a third party, whether that is a cell phone service provider or another individual. It is the recipient of the subpoena who exclusively has standing to challenge the sufficiency and the timing and the nature and the scope of the subpoena. Maddox versus State, 346, Georgia Appeals, 674. Courtney versus State, 340, Georgia Appeals, 496. So the main argument you're making, which is there's some issue with the subpoena and it was inappropriate for the court to enter an order stop-gapping that subpoena when the court had been informed by an officer of the court that someone was resisting compliance with the subpoena. I don't need to reach whether the order was appropriate. I think it was. because it would be Grady Legal or some other agent acting on behalf of Dr. Hernandez and not Mr. Poole's lawyer, who should be advancing those arguments. And I'm not seeing those people here trying to raise those arguments. Now, you melded in a second point at the very end, which is that you, Mr. Miller, have not had a chance to speak with the doctor. I want to address that in two ways. One, you had a concern yesterday that it was inappropriate for the state to even try to call Dr. Hernandez, even if he said, I am ready to go and I'm standing here right now, which he wasn't. And that was a notice issue. The record should be clear that Dr. Hernandez is a name and an actor contained within Defense Exhibit 8. And in fact, things that he wrote and indications he made in the record were things that the defense relied upon in presenting their case. I believe the law is pretty clear that the state can call someone who is used in that way as a witness, and it's not a well-founded response from the defense to say, I've never heard of this person, I don't know what this person has to say, when in fact, what the person has to say is memorialized in the very records that the party resisting this person's appearance tendered into evidence before the jury. So I don't find an issue there. Lastly, I do sympathize with you that we learned about Dr. Hernandez fairly late in the day yesterday. I don't know if he's here right now. He's not in our courtroom, but we're going to take a lunch break before he testifies, and I'm going to ask the state during that lunch break to inquire of Dr. Hernandez if he's comfortably sitting in their office, whether he's willing to talk to you, and you can make a record of that either when he testifies or before he testifies that he didn't want to. I don't know why he wouldn't want to talk to you, but if for some reason he doesn't want to, you're certainly able to get that on the record. Otherwise, you'll have the lunch break as an opportunity to speak with the witness who was contained in the records that you tendered in this case. So those are my rulings.
Your Honor, very, very briefly, and I'll find it in a second, but my understanding is that when a witness is in the discovery from another party, so the discovery, those medical records were the discovery given to the defense by the state. They weren't tendered by the state, they were tendered by the defense, but those records were part of their discovery. And as such, because it is part of the discovery that they tendered to us, do not need to give them notice that we would be calling this person as a witness. But that person should be, if they are planning on calling them as a witness, because it is in their discovery and not the discovery that we turned over, they should have that individual listed as a witness to the case.
Okay. Don't know that I agree, but either way, what we're talking about in terms of discovery, actually your client's medical records. And yes, the state obtained them. That's not discovery that you couldn't have obtained either. And I suspect if the state hadn't obtained them, you would have, because they are, again, your client's medical records, not anyone else's. But putting that to the side, I find that you were duly on notice of this doctor and his thoughts and the contents of his statements in the medical records upon which you relied in your presentation of your part of the case. So what we're going to do now is get Mr. Swanner back in, please. We'll bring the jurors in. I will ask some of their questions, and then you both will be able to follow up, Mr. Miller and Mr. Abadi. And then it sounds like the defense will rest after that. That'll be our lunch break, but we'll talk before you're excused after the jury steps out for the lunch break. We're almost done, Mr. Swanner. Thank you for your patience.
Here, if you need.
Okay. Mr. Abadi, anything else before the jurors come in? Mr. Miller, anything else before the jurors come in?
Okay.
All right, let's bring them in, please.
All right, Missouri. Do it for the count of votes.
Thank you, Deputy Gordon. Everyone else should be seated. All right, ladies and gentlemen, we are going to proceed with a little more questioning for Mr. Swanner. Mr. Swanner, from your experience as a crash investigator and subject matter expert, could airbags, as they deploy, push an unrestrained passenger from a front seat to a back seat?
No, sir.
Okay. Have you, in all the accidents you have encountered, either back when you were with GSP or as you've been doing your work in the private sector, seen examples where front seat and back seat passengers change places?
I've seen, people be thrown around the vehicle, but that exact example, I don't recall it, that exact example, but I do know that people get dislodged and thrown around the vehicle.
This would be a first if it played out the way you described, back ends in front and front ends in back.
Correct.
Okay. Please share with the jury, and if you need to consult your report first, all the injuries that you wrote down that Mr. Poole sustained as a result of the accident.
The injuries that I had Mr. Poole listed with were abdominal injuries. The injuries that he sustained were not as extensive as Mr. Minor's.
So my question wasn't, are they worse or better or red or green?
Okay.
What did you put in your report about what injuries Mr. Poole sustained?
Abdomen injuries and burning from oil or a hot liquid to his face area.
Okay. Describe for the jurors which way you understand, if you were able to determine, the car overturned. If it overturned, if this is the car traveling, it flipped over, we'll call that sort of longitudinally, I made that term up, or if it was laterally, in other words, it just rolled over on its side, or what were you able to determine the way in which the car flipped?
What I was able to determine based off what I was looking at, when it hit the wall, it went up the wall and went that way and overturned lateral, I guess is how you described it, but it's sideways, not front to back.
If you were to place a percentage confidence level on your conclusion that Mr. Poole started in the back, Mr. Minor started in the front, and Mr. Jones started in the front, 0 meaning that you're just All right, okay, flip the coin, I guess. 100% being, I guarantee you with certainty that's where they were. What percentage confidence level do you put on your findings?
I'm gonna be at 100% based off of what I looked at in my findings to come to that.
Okay. I'd like you to walk the jurors through the chronology of the accident, and here's what I mean. Which came first, Mr. Jones being ejected or the car flipping?
It would be the car flipping, and when the car flips and gets, when it starts that and it hits, when it starts overturning and it lands the way it does, that's when Mr. Jones comes out of the vehicle.
And describe for the jurors the path of travel Mr. Jones took to get out of the vehicle. Windshield, side window, hole in the roof.
I suspect Mr. Jones came out of the passenger window, being it was busted from the induced damage with the initial impact with the wall. That's when the window busted, and then when it overturned, he exited out the passenger window.
You described Mr. Poole and Mr. Minor, I don't remember the exact term, sort of floating around on the roof, because now the roof is sort of the floor of the incident. Were they doing that before, during, or after Mr. Jones's ejection?
Mr. Poole gets thrown from the back seat to the front seat at initial impact, and then as it's overturning, Mr. Jones comes out, and then when it's sliding and rotating to final rest, that's when the occupants are rearranged.
But I thought you just said Mr. Poole gets thrown to the front seat, and then you say the occupants get rearranged. Are all three of them at one point in the front seat area?
Yes, sir.
Okay. And then explain to the jury how it was if all three are in the front seat, only Mr. Minor ends up in the back seat.
Well, Mr. Jones gets ejected. He's out of the equation at that point. And then Mr. Minor, when the initial impact, he's going toward that impact, but he's going to hit that center console area, and he's going to be closer to the passenger door. And then when it overturns and starts to rotate, that's going to create his opportunity to get to the back seat when it's overturned and rotating to final rest. That's when Mr. Minor is basically rotated to the back seat or the back part of the roof.
And I appreciate it because the car's upside down. When you say something like that was Mr. Minor's opportunity to get to the back seat, are you saying that would be something he's consciously seeking to do? Or you're saying now there aren't obstacles or obstructions in the way for that to occur?
That would be there has to be a clear path for him to get back there, and that's when that opportunity arises. That's when it's on its roof, it's rotating, the seat's laid back. That's when he has a clear path to get to the back seat.
Okay. But again, my question, not that, hey, I am personally trying to get to that back seat because it's a safe place to be. You're saying as the physics and dynamics are working, that's how that could occur.
Yes, sir. He's not consciously climbing to the back seat.
Okay.
He's being basically a passenger of the vehicle, and he's going where physics and force is taking him.
Got it. You were asked earlier if drawing this would help you explain. You said, no, I don't think I need to draw. Do you think it would help you explain any further than you already have? If we set up 4 chairs in front of the jury and you showed how the bodies were moving?
I can attempt it, but I don't.
If you think there are difficulties with it, not meaning it would be hard for you, but that it wouldn't accurately represent it, then we shouldn't do it. It's just a question.
I don't think it would be an accurate representation due to how quick it happened and the forces that were applied when it happened. I could try to mimic it, but I don't think I would do exactly how it was and be accurate with that part.
All right. Did either of you find the photo with the hole in the windshield?
Yes.
Okay, can you publish that, please? So which exhibit is this?
It's 71.
71, state 71. If you see in state 71, Mr. Swanner, some of the windshield in where we're looking, it's the upper left, but that's on the passenger side of the car. There's no windshield there. Is that a possible exit route for Mr. Jones? And if not, why not?
It's possible, because it is an opening and it is the avenue out of the vehicle for him. But I do not believe that would have happened at initial impact.
That what would not have happened at initial impact?
Him being thrown from the vehicle,
Because,
where he wound up, where his final rest of the body, it does not match up with the path of travel pre-roll. It does after the initial impact and the path of travel to the final rest of the car. He's along that path, but not he's not anywhere that he would have been if he'd been thrown out at initial impact, because he'd been in a different direction.
okay, got it. Thank you. Mr. Miller, do you have questions for Mr. Swanner based on what he and I just discussed?
Yes, Your Honor, very briefly. I'll do it this way. That last question, regarding the hole in the windshield. You stated that, there are injuries. There are injuries in the, when you're making your evaluation, that those injuries, have to be, you have to match those injury profiles with the evidence that you find at the scene, correct?
Yes, sir.
Would the hole that's in that windshield, I'm showing you States Exhibit 156. Would the injury in States Exhibit 156 be consistent with causing that hole to be there in that window, in that windshield?
It could be. I haven't I have not looked at this extensively, but it could be as a result of that.
Okay. and, okay, but based off of the evidence that was at the scene, you would say that it is very unlikely that initial impact would have caused, him to go out of that car, correct?
Yes, sir.
Mr. Body, nothing? Okay. Thank you, Mr. Swanner. You should take your binder, leave all the other stuff up there. Appreciate your time.
Thank you, sir.
Mr. Miller, next witness.
At this time, Your Honor, the defense would rest.
Okay. Ladies and gentlemen, we've reached another juncture in the case. The defense has rested. It also happens to be noon, so lunch. We're going to do lunch now. When you get back, we will move along with the case, whether the state has a rebuttal witness or witnesses, or whether we move straight into closing arguments. One way or the other, you're going to start hearing closing arguments this afternoon. And I'll talk a little bit about those just before they start. But the fact that the defense has rested doesn't mean it's time to deliberate. You still don't have the law that you must apply to the facts, whatever you find the facts to be. So enjoy lunch wherever you go. Don't talk about the case, and no outside research. On this clock, it says 12:10. Is having you all back here by 1 too soon? I'm seeing no one say no. So let's try to get started as close to 1 as possible. And I heard Ms. Hansberry actually scrounged up some snacks for you guys. So let's hear it from Ms. Hansberry. And eat them all, okay? We'll see you back as close to 1 as we can make it happen. Thank you. All right, everyone, please be seated. Mr. Abadi, do you still plan on calling any rebuttal witnesses?
Yes, sir.
And is that limited to Dr. Hernandez Irizarry? Okay. Can you see to it, please, that Mr. Miller or Ms. Bird or both have an opportunity to speak with him if he wants to speak with them? Thank you. And if you could do that at the start of the lunch break so that there's the maximum possible window for them. That's the only witness you intend to call. Okay. I think the only other thing we need to work through, I will get a revised jury charge that changes only by adding the charge I told Mr. Poole I'd give, which is, that's all right. Let me know when you're done. Thank you for helping him. Includes the language about the jury not considering the fact that a defendant didn't testify. We have Exhibit 20. I need to get you a ruling on that so that you can be thinking about your closing argument, because we will segue from, if you don't have rebuttal or whatever it would be from the defense side, we will segue directly into closings. It would be great if we could do closings today. We lose some of these jurors next week. So the sooner we can get the case to them, the better for everyone. So that's how I would like the afternoon to flow. Mr. Poole, why don't you, because it's been a minute, get on the record whatever you want to about your theory of admissibility of Defendant's Exhibit 20, which I've got in front of me, and I'll make part of the record regardless. It is a photo, as I understand it, of Mr. Minor as he appeared in his casket at the time of his memorial service.
You said Poole, but
I'm sorry, I don't want you to talk about it, Mr. Poole. I mean, Mr. Miller.
Yes, Your Honor, all evidence is relevant. The arguments that the state has made for this, picture not to go in, would go towards its weight and not its admissibility. The defense has a cleaned up picture, that would display, injuries that Mr. Minor, suffered, as a result of this collision. In absent of displaying a cleaned up photo of Mr. Minor, the one that we would be forced to use would be one that would be, I could argue prejudicial because it would show Mr. Minor in not such a great fashion. It would be the autopsy photos, which contain, blood, and it's just not a clean situation, and it's not something that the jury should be subjected to in order for the defense to prove our point. One of the arguments that the state had
Can I
made.
ask a question?
Go ahead.
The photo you're referring to from the autopsy, is it one that they've already seen, or it's one that you have that you would use instead of 20 if 20 is not coming in? I should ask it differently. It's already in evidence. It's one of the,
I'm not sure.
Okay.
To be honest with you, I'm not sure if it is or not. But I know it's one stylistically and taste wise that I think would not go well in closing, as being the last thing that the defense shows, or one of the last things that the defense shows the jury. In addition, the arguments that the state has made prior, again, which do go towards the weight and not its admissibility, are that because there was a full examination of Mr. Minor, that these deformities that defense is arguing would be because of the way it was put back together. Our counter is that Dr. Henninger has been performing autopsies for a number of years and is seeing thousands of people who are having the same type of autopsy done that both Mr. Jones and Mr. Minor had in this case. And so to follow the reasoning that the state is providing would say that every single person that Dr. Henninger is coming into contact with would have the same deformities once those persons are taken to funeral homes. And that's just not probable or likely. And I don't know if the county would continue to let him work if everybody was not back to their original state once they left the ME's office. So for all those reasons, Your Honor, the picture is relevant. The arguments that the state have would go towards its weight, and it would not go towards its admissibility. The state had the opportunity, they knew about the picture, and they had the opportunity to explore any concerns they had with the picture with Dr. Henninger on their direct of him, and they chose not to do that. That is their choice. But because they made that choice, they cannot now come and try to force the defense to say, why didn't we explore those? Because we didn't need to. So for those reasons, Your Honor, the picture, again, Your Honor has stated in a previous trial that once you saw it, and I have that Your Honor saw the picture and the defense and allowed the defense to enter the picture into evidence if we could have it authenticated. We were unable to authenticate it through that witness because it was a family member. He was having a hard time on the stand, a number of reasons. I get it. We get it. So nonetheless, new trial, we changed our strategy and way of entering the picture in a way that would get it in. the picture was properly authenticated at this trial. One of the comments that I think is most telling that Your Honor made at the last trial after viewing the picture and saying you can get it in was, "I can see why you want to get this in." I think that comment to me says that Your Honor understands that there is some probative value in this picture getting in. And so all of those reasons, any objection that they would have would go towards its weight. It would not go towards the admissibility of that picture.
Thank you, Mr. Rao. I think this well, you had advanced some arguments before, so we'll start with you.
Yes, Judge. One, I maintain the objection as it relates to relevance because the purpose of introducing that photo at the time that the examination took place with, I think it was Mr. Williams, if I'm not mistaken, was the purpose of saying, hey, you went to a funeral and this is how he looked. There was no causal connection between the crash and the bump or the whatever it is that the defense wanted to portray in that photograph, such that a foundation was even laid by the defense during the examination or cross-examination of Dr. Henninger. The defense actually had an opportunity to lay that foundation as it relates to a future admissibility of a photograph that would convey the things that the defense wishes to argue. However, there was no foundation laid as it relates to Mr. Williams, not that he would even be the appropriate witness to lay a foundation as it relates to the bump on Mr. Minor's head at the funeral home and what could have caused that. That foundation should have been laid as it relates to Dr. Henninger, and any future foundation could then be satisfied. However, the purpose for admitting that photograph, regardless of what the defense wishes to argue in closing, was, hey, this is a photograph of Mr. Minor at a funeral home. There was no relevance as it relates to why a photograph of Mr. Minor approximately 2 weeks after the incident would be relevant for anything as it relates to the issues that are at determination for this trial.
Well, I that last point you're making, I probably directed Mr. Miller not to state on the record at the time he and the witness were discussing 20 why he thought it was relevant. And he then made that presentation after we were done for the day. So I appreciate your point that Mr. Miller at that moment didn't say, well, let's assume it's Mr. Williams. Mr. Williams said, yeah, this is how Mr. Minor looked at the time of the funeral. How he looked at the time of the funeral is not relevant to who was driving the car. But if how he looked at the time of the funeral includes some type of injury that was caused during the collision, that piece is relevant. That witness couldn't necessarily talk about it. That witness could get the photo in saying, this is how he looked at the time. And I precluded Mr. Miller at the time of his exchange with the witness, because the jury was standing right there, from getting into all of that. But I believe he did timely articulate why, and what he said many times, why he needed the photo. And I have in the past said, I can see why you'd want it. That doesn't make something admissible just because it is needed or it is wanted. So I have a few observations to make. One, and this goes to relevance, a steering wheel mark on the forehead of Mr. Minor is not consistent with the defense expert testimony. The defense expert testimony is that Mr. Minor went sideways and then slid up the ceiling and ended up in the back of the car. The defense expert's testimony was repeatedly and consistently those airbags, which would come straight out of the steering wheel and prevent someone from impacting the steering wheel, played minimal to no role, because the driver, which Mr. Swanner says is Mr. Minor, would have basically been going sideways. Yes, forward, but you impact the dashboard sideways up and into the back. So it's not particularly consistent with the theory advanced by the defense as to what happened with Mr. Minor's body. Be that as it may, I'm not the one who decides consistency or inconsistency. I want to put the burden of proof where it belongs, which is not with the state. It's not the state's job to look at all the defense potential exhibits and try to undercut them with various witnesses. The obligation to lay a sufficient foundation for an exhibit, even if it's going to be admitted through witness X later on in the trial, resides with the proponent of the exhibit. This is Defense Exhibit 20. So it was in fact Mr. Miller's obligation, should he have chosen to do so, which he did not, to explore Defense 20 with Dr. Henninger. Take a look at this picture. Is this consistent with how someone would look post-autopsy and post whatever it is that happens at a funeral home? More on that later. And that wasn't done. That part of the foundation was never laid. And it's not the opponent of the exhibit who needs to build the defense to the exhibit through those witnesses. It's the proponent of the exhibit who needs to do that. Didn't happen. So I make two formal evidentiary findings. Number one, I find at base that Exhibit 20, Defense Exhibit 20, is not relevant. I understand why you want it, why you need it. That doesn't make it relevant because there is no evidence in the record that Mr. Miner's appearance in Defendant's Exhibit 20, the day of his funeral, was not impacted by either the invasive procedures conducted at the Fulton County Medical Examiner's Office or whatever they did at the funeral home. There's all sorts of makeup on his face, and I don't know who did it, why they did it, and what else someone in a funeral home did to make Mr. Miner suitably presentable in this solemn occasion. The record is silent as to that. And so you could say that goes to the weight of it, but it actually goes to the admissibility of it. We have no information of that whatsoever. I make as a secondary finding, if there is an appeal and an appellate court says, you know what, if there is some probative value to this because of the argument, even though it's inconsistent with the defense theory of the travel of Mr. Miner's body, that there's some probative value of what appears on this photograph to be a forehead injury to Mr. Miner. Setting aside the fact that there are other photos of his forehead that are contemporaneous with both the accident and the autopsy. I find that that probative value is minimal because of all these undercutting factors about we don't know what the impact of the autopsy was. We don't know what happened at the funeral home. And because that probative value is so minimal, it is substantially outweighed by what would be risk of confusion and unfair prejudice because the jury would not receive, but they could have had the proponent of the exhibit asked Dr. Henninger what the impact of the rest of the autopsy is on the forehead skin as the head's being pulled this way and that way, and the cranial vaults being emptied. None of that was presented to the jury, though it could have been. There also has been no medical testimony as to whether this photo is similar in appearance in terms of the forehead as Mr. Miner's forehead looked at the time of the autopsy. Lastly, there is no testimony from anyone who was preparing Mr. Miner's body for its final laying to rest in the casket, whether that be an embalmer, a funeral home worker, whatever. We don't know. There's nothing about that. And so that makes it both unfairly prejudicial and it generates a risk of confusion, which is a separate, independent 403 factor. So having weighed all those things, I believe the state of the record is that Defense Exhibit 20 does not come in. I will nonetheless make Defense Exhibit 20 part of the overall record so it is available for appellate review should there need to be appellate review in this case. I want you all to get something of a lunch break, and I know Mr. Miller wants to talk to Dr. Hernandez, so if you all could get to Dr. Hernandez first off, and then let's be back at 1 o'clock. Mr. Miller, anything else from the defense?
No, Your Honor.
Anything from the state? See you at 1. Ms. Rivers, you ready? Okay, we're back on the record in State versus Poole. Mr. Poole and his two lawyers are here in court. The prosecutors are here. And we should be ready to pivot to the state's rebuttal case. Mr. Abadi, anything we need to get on the record before we bring the jurors back in?
State, because we're gonna have to not go to the doctor.
Okay,
After speaking a bunch with each other strategically, after we made the decision before we had heard the full extent of this planner's testimony, and we're fine and close them out.
okay. So you don't, the defense is rested, you're not calling any witnesses. All right, then let's talk about what happens next. Mr. Miller, anything you want to get on the, I didn't mean to get you mid-bite. I'll come back to you. I'll remember what I was going to ask. Mr. Abadi, does the state plan to open and close? Okay. Do you need, are you using your funny monitor or you'll just be using our system? Okay. You're going to plug into, or you're going to do it however you're going to do it. Okay. All right. Anything you need before the jury comes in and I explain that we're getting to closings? Okay. Well, make sure you're not still chewing. Mr. Miller, anything about Dr. Hernandez or about closings?
No, Your Honor, did you send the new jury charges? I didn't receive.
I didn't because I didn't get to it. But again, the only thing that's different from what I emailed you is I will be inserting the standard language. So you should feel, if you want it for your closing, I can send you the language right now. But you're free to talk about it in your closing because it will be given. I just hadn't inserted it in between. I've got that stock language, just not from the time we did this before because Mr. Poole testified then. So I will email it to all four lawyers, the blurb, but I'll also email to you the revised final version.
Okay.
Does that work?
Yeah.
Okay. Anything else?
No, Your Honor.
All right. Please check to see if the jurors are ready. Oof. There you go. Huh?
All right, Missouri. Really further accounted for?
Thank you, Deputy Gordon. Someone lose something?
But it's fine.
Okay, all right. Hope it's not your ID or something. Welcome back, ladies and gentlemen, from lunch. Any place new today or it's same old, same old?
A lot of us brought our lunch.
You brought your lunch, okay. All right, good. Excellent. And you didn't bring it in glass and you didn't bring it with sharp metal cutlery. Fantastic. Hope that worked for you. Where we are in the proceedings, you all can be seated, is that the defense has rested. The state will not be presenting any rebuttal evidence, so the record is closed in terms of the evidence. You've received everything and anything you're going to get about what the facts may be in this case. What remains are the closing arguments or summations from the lawyers, and then the charge that I give you as to the law that applies to this case. The lawyers are about to get up in just a moment, and they get up in a certain sequence that I'll describe momentarily, in an effort to persuade you to decide the case in one way or the other. So the prosecutor is going to say you should find Mr. Poole guilty. And Mr. Miller, should he choose to give a closing, no burden on the defense, but I suspect he'll get up. He'll talk to you about why there's reasonable doubt. And so you should acquit Mr. Poole. And you should feel free to be persuaded by one or the other argument. But recall what I told you at the outset of the trial part of this case. You are the fact finders. And so just because a lawyer puts it on a screen and tells you, you know what, this is what happened in this case, you're actually deciding what happened. And so they may weave together strands that you find to be persuasive. But if you're convinced that the guy had a blue shirt on and the lawyer keeps telling you it was a red shirt, this means the lawyer's got the facts wrong. You decide what the facts are based on everything you've received from the witnesses and the exhibits. And then, like I said, you're free to be persuaded by what the lawyers have to say. When they're done, I'll give you the charge of the court and your deliberations will begin. Because the state has the burden of proof, they get to open and close with closing. So one of the prosecutors will get up in just a moment to give the first part of the state's closing. And then that person will sit down. Mr. Miller has one opportunity to talk to you all. He'll cover whatever he feels is appropriate to cover with you. And then one of the prosecutors will have a chance to get back up and have that final word. And when that argument is done, then we'll probably need to take a break. But at some point, I'll give you the charge of the court. All right? Thank you. Mr. Rao?
Yes, sir. Thank you. Good afternoon, ladies and gentlemen. I appreciate everyone's time and patience throughout the course of this trial. I know it's been a long and arduous process to get here, starting from last Monday all the way up until this Thursday. So I promise I'm going to be as brief as I possibly can while still making my points. I'm going to be up here talking to you a little bit about the legal principles as it's going to be applicable in this particular case. The defense is going to have an opportunity to present their arguments, and finally, Mr. Abate will have the opportunity to present the state's final arguments in this particular case. And ultimately, what we're all here to decide is whether or not the state has met its burden beyond a reasonable doubt in proving the 5 charges that the defendant has been indicted for. 2 counts of felony murder, 2 counts of vehicular homicide in the first degree, and 1 count of fleeing and attempting to elude a law enforcement officer. And it's the state's burden to prove each and every one of these charges beyond a reasonable doubt. And as we started this trial from point A to point B, which is where we're at now at the close of this case, the defendant retained the presumption of innocence prior to the state presenting evidence. However, it's the state's position, based on all the evidence that's been presented to you, that the defendant is guilty beyond a reasonable doubt. And I know it may have seemed like we've taken some twists and turns to get to this point. There may have been some scheduling issues. Maybe there was some testimony that didn't really understand why it was particularly relevant to the issues in this particular case. And so no matter what the twists and turns that have taken place throughout the course of this trial, there's only one reasonable conclusion that we can make, that the defendant was the driver of this vehicle, and he is guilty of each and every one of these charges beyond a reasonable doubt. And that's our burden of proof. And I'm sure all of you at one point in time, if only once, I've heard the phrase beyond a reasonable doubt, be it because you watch courtroom dramas on TV, watch movies, read books. You've all likely heard the phrase beyond a reasonable doubt. But what does that mean in the context of your deliberations when you go back there and decide whether or not the defendant is guilty beyond a reasonable doubt? The way I like to first start off by defining it to jurors is telling you what it is. So it's not beyond all doubt, right? It's not a doubt for the sake of having a doubt. There's no numerical percentage value that you place on the evidence to make a determination as to whether guilty or not guilty. And it's not a vague or arbitrary doubt. It is not a doubt for the sake of having a doubt. What reasonable doubt is legally defined as the doubt of a fair-minded, impartial juror honestly seeking the truth in this case, or in any case that you all find yourselves as jurors. And if there is a doubt that you have as it relates to your findings, it must be based on common sense and reason, which is why all parties were harping on the jury selection portion. Can you be fair and impartial, or is there anything that can affect your ability to be fair and impartial? Because honestly, you all are here because you were the first 12 or 14 jurors that had what we believe to be common sense and reason based on your life experiences, and the people who did were struck. And that's how you all ended up here. Just in case if you were wondering, why did the state, why did the defense pick me? It's more of a deselection process than a selection process. And you were the first 14. I know we lost one juror throughout this process. You were the first 14 that had that could show that you could be reasonable, fair, and impartial as it relates to your decisions in this case. And so ultimately, what you're going to be asked to do when you go back there and deliberate is look at the evidence presented to you in this case and come up with the most logical, reasonable conclusion as it relates to who was driving this vehicle at the time that Trooper Clark started his pursuit to the point in time when the vehicle crashed. And so look at the evidence and make the determination as to what is the most reasonable conclusion based on all the evidence that's been presented to you throughout the case. And both myself and Mr. Abate will talk a little bit about what that evidence is. So one way I like to conceptualize reasonable doubt is we've all likely heard the phrase, anything is possible. Anything is possible. Well, what reasonable doubt needs to be distinguished from that phrase is the difference between what is possible and what is reasonable. So anything is possible is not the standard. Just because there may be a quote unquote vague or arbitrary doubt that you might have as it relates to this case, that's not the standard. Is it beyond a reasonable doubt? So you have to look at what is reasonable in this case and make a logical deduction based on the evidence presented to you as it relates to whether or not the defendant is guilty beyond reasonable doubt, being the driver and committing the offenses charged. And so one way I thought about conceptualizing reasonable doubt to you all is, let's say, for instance, yesterday we all received a weather forecast indicating that it was going to snow today, okay? And all of the people in the media were saying it was going to snow today. The weather app said it was going to snow today. And so we look outside, we see the clouds of darkness going, maybe it's going to, we have a perception that maybe it's going to precipitate sometime soon. And later that night, we go to our house, we get into bed, close the blinds, and then wake up next morning and you look out the window and you see snow, right? You didn't actually see it, but you see what you perceive to be and what is consistent with snow. And what is the logical deduction that you make? That it snowed in between the time that you went to bed, when you didn't see snow outside, to the point in time when you wake up and you open the blinds or go outside and you see there's snow. Well, it's also possible that some vague or arbitrary thought in your head could come about, and you might think that, for instance, someone like Jeff Bezos or Elon Musk or Bill Gates, with their hundreds of billions of dollars, could have hired some sort of stunt company to blanket Metro Atlanta with fake snow. It's possible, right? I mean, they have the money to do it. It's certainly possible that that could happen. Is it reasonable to think that that's what actually happened when all the contextual evidence that we received the day before from experts, expert meteorologists who are broadcasting what the news is, what your weather app is telling you, and all the other contextual indicators that you have based on your common sense and experience to make the deduction that as soon as you open the blinds or walk out that door, that what you see is snow? Or do you follow this vague or arbitrary thought that maybe Elon Musk or Jeff Bezos or Bill Gates, maybe all of them together, pulled off this big old prank on Metro Atlanta and paid someone that would well be within their funds to do to blanket Metro Atlanta with snow? No, it's not reasonable to think that, right? The most logical deduction that you can make from that, based on your common sense and reason, based on the contextual evidence that's been presented to you throughout the course of the day, based on your perceptions, that it actually snowed. And so that's what the standard is beyond a reasonable doubt. What is the most logical conclusion that you can make based on the evidence that's been presented to you throughout the course of this trial, and not some vague or arbitrary doubt as it relates to who the driver was? So in the context of what is reasonable versus unreasonable, the question that we have to ask, that you will all be presented with and have been presented with throughout the course of this trial, is it reasonable for the driver and the rear seat passenger to swap places? Is it reasonable, based on the evidence that's been presented to you through witness testimony, expert testimony, is it reasonable to conclude that? The answer is no, because the driver, the front seat passenger, and the rear seat passenger at all times must be traveling with the forces that are pushing in the direction that they're going. There's no equal and opposite forces that would allow someone to end up in the back and someone in the front, someone in the back to end up in the front. That doesn't make sense, and that doesn't align with the laws of physics that have been testified to by even the defense's own expert. And we'll get to him shortly. In a forward right collision, all the forces are generated and going in the direction of the crash. And that's consistent with where Mr. Jones ended up. That's consistent with where the defendant ended up. And that's consistent with where Detarius Minor stayed in that vehicle at the point in time from when the vehicle collided to within seconds rested at final rest, with all two individuals remaining in the vehicle, Mr. Poole being in the front, and Mr. Minor being in the back. And there's nothing that would cause the swap that would make sense based on common sense and reason and scientific principles that have been presented to you throughout the course of this trial. So when you hear the claim that's been presented to you throughout the course of this trial, as the argument has been made to you by the defense, that somehow the driver of the vehicle and the rear seat passenger somehow swapped places, it doesn't make sense in the context of the evidence that's been presented to you. And Mr. Abate and I will continue to talk to you a little bit about why. So, in making the determination as to whether or not the defendant is guilty beyond reasonable doubt, there are things that you should and should not consider when determining the ultimate issue in this case, as is who is the driver of this vehicle. So there are things that you should not consider. For instance, passion, sentiment. It's not about public opinion as it relates to whether or not you think GSP should initiate pursuits to pull over individuals driving in excess of 40 miles per hour over the speed limit. It's not your dislike of police. It's not the disagreement with the law that the judge is going to charge you on, that you will go back there and apply to the facts of this case. And it's not about penalty or punishment. All your job, ladies and gentlemen, is to hold the defendant accountable and make a determination as to whether or not he did this. As it relates to penalty and punishment or any consequences and what those consequences look like, that is solely within the discretion of this court, Judge McBurney. It's not based on conjecture, it's not based on prejudice, and it's not based on sin. I think we can all agree that there were a lot of friends that lost two friends. And they're watching a third one on trial for the death of those two friends. It's not about Miss Martin's loss of her son. It's about whether or not the defendant committed the acts that he is charged with. Is he the driver? That's the question. And in so doing, these are the things that you should consider. The elements of the crime, which we'll talk about towards the end of my presentation. The law that the judge is going to charge you with. The photos and documents and exhibits that have been presented to you throughout the course of this trial that you'll have back there with you to go over during your deliberations. It's about the defendant's actions and statements on the morning hours of that April morning in 2021. The statements that he's been accused of making to Ms. Martin, to EMT Joe Connors, to Trooper First Class Clark. It's about the credibility of the witnesses that we'll touch on. It's about forensics and expert testimony, and how does that apply as it relates to how we can determine that the defendant was the driver of this vehicle. And most importantly, it's about your common sense. You get to take your common sense and your life experiences and go back there and deliberate as it relates to how do you come to the most logical conclusion in this case as it relates to who the driver was in this vehicle. And you've heard evidence that the defendant was the driver of this vehicle, both in terms of what the troopers and EMTs saw, to the medical evidence, to the expert testimony from the skirt investigator, that all show and point to one direction, that is the defendant being the operator of that motor vehicle at the time that this pursuit happened. And so evidence falls under two umbrellas, direct and circumstantial. So direct evidence is evidence that points immediately to a particular fact. That is things that you see, hear, observe. So Trooper Clark saying that he observed a white Infiniti Q50 driving in excess of 40 miles per hour. That's direct evidence that that vehicle was driving in excess of 40 miles per hour, or in excess of speed of 100 miles per hour. What the EMT technician said about seeing the defendant lying supine on his back in the front portion of the vehicle, with his body partially ejected from the vehicle and his feet by the steering wheels, consistent with what Trooper First Class Clark said. That's all direct evidence of what they saw and observed on those morning hours in April 2021. Circumstantial evidence is the second umbrella in which all the evidence falls under. And what circumstantial evidence is legally defined as, or I guess the shorthand version of what it's legally defined as, is basically looking at a group of direct evidence or facts and grouping them together, and then drawing the logical inference that you deem to be justifiable, that then in and of itself becomes the fact that you get to go back there and deliberate on in this particular case. Of course, we have qualifications. So, one way I like to conceptualize circumstantial evidence is a common experience that we all likely have had in the past. Unless you drive an electric vehicle at some point in time, be it a few days or a few weeks, you will eventually have to stop at a pump to fill up gas. And so, if you're anything like me, you wait until the fuel gauge on the dashboard goes closer and closer to empty as possible, perhaps even the yellow light. And eventually, at some point in time, you realize that you have to go fill up gas. So you go to the nearest gas station, you stop at a pump, you get out of the vehicle, you open the tank, you go up to the pump, you put in your card, or you go to the cashier and you pay cash. And you take the nozzle out of the pump, you select the grade of fuel that you need for your particular car, You insert the nozzle into the vehicle and you press down on the leak. And at that point, you hear something that's consistent with liquid going into the car. You may even smell something that you affiliate with gasoline. And you see the amount of gallons on the indicator at the pump go up. You see the amount of money you have to pay go up even more. And eventually, the pump stops. Or the nozzle stops putting fuel into the car. You remove the nozzle, you put it back into the pump, you close up the tank, you get into the car, you turn the car on. And eventually you see the indicator on your fuel gauge on the dashboard go from empty to full. The yellow light's no longer there. You turn on the ignition, and you continue driving on, going about your day. And at that point in time, none of you have actually seen the gasoline go into the vehicle. You're using contextual indicators to make a determination that as you continue driving, everything is good. Your fuel gauge went from empty to full, and eventually you just make the determination and arrive to a conclusion that what went into your car was gasoline. And I have yet to experience a translucent hose attached to a nozzle where I can actually see the gasoline go into a car. So more often than not, you're not actually seeing it go into your car. But you're looking at a group of related facts. The fact that your car initially started off at empty and is now full, that you heard liquid go into the vehicle, you may have smelled something that you affiliated with gas, and you're able to continue driving without any issues to make the most logical conclusion that what went into your car, even though you did not see it, based on a group of related facts that you put together, draw the most justifiable and reasonable conclusion that gas went into your car. That's no different than the logic that you apply as it relates to circumstantial evidence in this case. And as it relates to the weight of direct evidence versus circumstantial evidence, there's no rule indicating that circumstantial evidence has more or less weight than direct evidence. They're both given the same consideration, and ultimately, the weight that you all want to place on it is up to you as it relates to how you apply the facts in this case to make the determination that you do. The law does not require a higher degree of certainty as it relates to circumstantial or direct evidence. You can in fact convict or make convictions just on circumstantial evidence alone, because more often than not, criminal activity doesn't always happen with eyewitnesses to point out that that person is the shooter, or that person assaulted that person, or that person was the driver. So sometimes you just have to make those determinations based on the evidence presented to you and draw the most logical conclusion as it relates to who the driver was in this particular case. So in this particular case, as I previously mentioned before, there's plenty of direct evidence of what the on-scene witnesses saw, as well as what the expert witnesses testified to. So for instance, this case all started with Trooper Clark observing the defendant's vehicle going 95 in a 55. And that's direct evidence that that vehicle was going 95 in a 55 mile-per-hour zone. That after the pursuit, when the vehicle attempts to make a left turn at the exit off of 400 onto Lenox Road, that the defendant's entire body was in the front portion of the vehicle with his feet by the steering compartment, that he was pinned down, that he was partially out of the vehicle. Mr. Minor's entire body, as the evidence has shown from the body camera footage and the dash camera footage, was in the back, and that he was extracted from the back. That Trooper Clark's testimony that the defendant told EMT Joe Connors, who then told him, hey, the defendant just said, or this guy just said he's the driver. That's direct evidence. The fact that Trooper Clark went to the hospital and talked to Kenneth Poole, and Kenneth Poole said, I don't know why I did it. That's direct evidence. The medical evidence in this particular case. The fact that the defendant had a femur fracture, that he had broken toes, all consistent with being someone operating a motor vehicle in the driver's seat, pressing on the brakes,
causing those fractures in his toes and into his femur as the vehicle collides with that barrier is all consistent with the defendant being the driver. That's direct evidence of what you can take back there with you as it relates to who the driver was in this case. The fact that there was no lower extremity injuries on Mr. Minor, on his legs, is all evidence, that direct evidence that you get to go back there and take with you. The fact that Devin Jones, who everybody is at least on board with, is the front passenger, who also suffered a femur fracture on his right leg, same as the defendant, is direct evidence that you get to go back there and take with you. And of course, the laws of physics, which apply indiscriminately to everybody, the defendant included, which all state that the principal direction of force, the point in time that the impact occurred, was forward right when the vehicle collided with that barrier at approximately 78 miles per hour. That all the occupants in that vehicle would have been traveling forward right in the direction of the front passenger area. The same area that the defendant found himself in. Now, circumstantial evidence is taking those group of direct facts and drawing the most logical conclusion as it relates to who the driver was. Now, short of Detarius Minor or Devin Jones surviving this fatal accident, you're never going to have someone point out, yes, the defendant was the driver at the time that this pursuit occurred. Short of having a camera inside the defendant's vehicle showing that the defendant was the driver, you're never going to have direct evidence that everyone saw the defendant drive the vehicle at the time of the pursuit. So what you, ladies and gentlemen, have to do is look at the circumstances and the direct evidence that's been presented to you and draw the most logical conclusion when you group them all together as it relates to who the driver was of this vehicle at the time that this pursuit happened to the point in time when the crash occurred. And in doing that, you'll have the evidence that's been presented to you, be it in documents or testimony that you recall, videos, things of that nature, to go back there and deliberate on as it relates to what is the most logical conclusion in this case as to who the driver was that morning. You'll have photos, documents, videos. You'll have the explanations that have been presented to you by the skirt investigators, and I guess the defense's expert, as to the concept of physics and occupant kinematics, that you'll have to go back there with you and deliberate on. And you'll have the witnesses, and you get to determine their testimony, what their testimony was, and the credibility of that testimony. That's important. So ultimately, you as the jurors get to make the determination as to who you deem to be credible and not credible in this particular case when the witnesses testified on that stand. You'll get to determine things like the manner of their testimony and draw the conclusions that you draw as it relates to how you perceive their credibility. You get to look at the nature of the facts they testified to, whether they were in a position to testify to those facts, what motive they may have had, what bias they may have had, and what corroborates their testimony. Those are all things that you'll have in charge on as it relates to assessing the credibility of what they testified to. And so when we're talking about witnesses, it's important for you to look at the context in which they are saying things. What are the circumstances surrounding their testimony in this particular case? What did they gain or lose with their testimony? You know, what's motivated them to be on the stand in this particular case and tell you the things that they told you during the course of this trial? And what do their actions and words really say within the context of this trial? So, as it relates to Trooper Clark, the insinuation is either the defendant didn't give that statement to Joe Connors, and Joe Connors didn't tell Trooper Clark, or that Trooper Clark didn't go to Grady, or Trooper Clark did go to Grady and didn't get a chance to speak to the defendant. And that essentially he did not say the things to Trooper Clark that Trooper Clark said he did. which is that he was a driver, he doesn't know why he did it, and that he should be completely discredited. But I'll ask you this, and you can have issues with how he conducted that investigation. You can certainly reach out to all those officers or those post commands and say, hey, these are the things I did not like in terms of how you went about this particular case. But let's also look at it in the context of what it really is. What motive does Trooper Clark have to lie about the things that he testified to? Now, I say this in the context of what he did in this case. We observed the dash camera footage, we saw the pursuit, and we saw the first act that he did when he got out of that car, pull out a flashlight, and go immediately to the driver's side portion of the vehicle, trying to see if anyone needed assistance. Made a full lap around the vehicle and eventually observed the defendant. What is the first thing that he did? He went back to his car, he got a fire extinguisher, and immediately started putting out the fire. And you heard Trooper Buffington, that's not exactly a safe zone to be in at that particular time. You don't know what's gonna happen. The car could explode. The fire could get even bigger. Trooper Clark put himself at risk by putting that fire. Don't make any mistake about that. No matter how much they try to minimize that, he put his life at risk to save the defendant. That was the first thing he did. Trooper Clark also offered encouraging words. He could not touch the defendant. He's not a medical professional. He waited until the actual medical professionals or people in positions to actually be of use to the defendant to arrive on scene. But what is the first thing that he did before he got out of the vehicle? He radioed in and called it in to make sure that as much time as he could get them to get here as quickly as possible, he gave them that opportunity before going out and risking his life and saving the defendant. And then he offers him words of encouragement. He didn't yell at him. He didn't say, why did you make me do this? Why did you flee? Why did you do any of this? No, he said, look, it's all right. Hang tight. Help is on the way. Hang tight. Don't move. Help is on the way. Help is on the way. Later, he tells one of his colleagues, I don't know why, something to the effect of, I don't know, all he had to do was stop. But that's probably everyone's conclusion at that point in time, including you, ladies and gentlemen, when you watched the pursuit. All he had to do was stop. So that's not a comment that's untoward. That's a general question. Why didn't he stop? But when he's talking to the defendant, all he's doing is letting him know help is on the way. Putting himself at risk to put that fire. It's his job. That's what he's trained to do. That's what he's sworn oath to do. Let's not make let them not minimize it. That's what he did. He put himself at risk to put that fire. And then when asked, hey, do you remember going to grave? He said, yes. Do you remember what time? He said, I don't remember. It's important to note that because if Trooper Clark really wanted to lie, don't you all think that he could also just make up a time that's consistent with a report in medical records? If he really wanted to get his man, he could have lied. He just said, I don't remember. I don't know. He had opportunities to do that. He just stuck with what he could recall and couldn't recall. He could not recall the time. So he simply said, I could not recall. He could have lied, since that's what the defense is accusing him of. But he didn't. He said, I don't remember. But I do know that I spoke to the defendant, asked him 3 poignant questions. And he ultimately said that he was the driver. Then you take into context some of the defense witnesses that have been presented to you. And I genuinely mean this when I say I know that they're all hurt. I know that they're all hurt. You saw Mr. Williams break down. I know that they're all hurt because those 2 boys that were killed as a result of the defendant's actions were like family to them. Same as the defendant. The defendant is like family. And I know it hurts them to have to relive that night and talk about it. But you also have to look at the context of what they're saying 5 years after the fact. And it's understandable when you look at it in the context, which is that 2 of their friends are gone. 1 of their friends remains. What did they benefit by Mr. Poole being held accountable? 2 of their friends are gone. Mr. Poole's here, and I know, just like you all know, just like I'm sure they know, that Mr. Poole didn't mean for those two individuals to die. He did not mean for Terry's Minor and Devin Jones to lose their life. All he was trying to do was get away from the police. There was no intent to kill them. There's no malice. And I know they know that. You all know they know that. And they don't benefit by him being held accountable. Because then they lose a third friend. So look at the context. And ladies and gentlemen, we all have very close friends. I mean, we've heard it time and time again from each and every one of those witnesses that barbershop or affiliated with that barbershop. They're all like family. And they know. Some of them were actually there when he was taken into custody. And not one of them said anything. If you had very close friends, people who are family to you, and you had information, at the very least, you would want the authorities responsible for the investigation to know. Why would you wait 5 years after the fact? I mean, you know he's being taken into custody. Why would you wait 5 years to say something as it relates to potentially exculpatory evidence? And even though the reality is none of them can really tell you who was right. But they waited to tell you what they had to tell you. And also, with respect to Trooper Clark, you know, if he really wanted to get his man, he could have told Brady, you could have gotten the law enforcement presence there to let him know when he was being discharged. They could have put a hold on him after being discharged. They could have had a GSP trooper on standby, waiting for him to be discharged before taking him into custody. He just literally told him, hey, you got warrants, and so handle your business here. And then when you're done, go turn yourself in. If he really wanted to get Kenneth Poole, there are so many things that he could have done that he chose not to do within his discretion. So take into account all of these things when you're determining the credibility of their testimony. And with respect to the defense expert, I really wish that credibility wasn't sold at $500,000. The reason why I say that, okay, is because one thing that he said really caught my attention. He said, I was just hired for my sole purpose to look at the injury profiles of these three individuals and match them to the damage inside the vehicle. As soon as he said that, something went off. Because if that is the sole reason for why you are looking at the evidence in this case to make a determination, why would you pick and choose what you want to put in your report, what you want to talk about on direct with the defense about what the injuries were? If that is your sole purpose, wouldn't you, as an expert witness in accident reconstruction, trying to match injuries to damage profiles, list out all the injuries that Mr. Minor had? All the injuries that the defendant had. All he said that he testified to, that's in his report, as it relates to this defendant's injuries, is that he has abdominal injuries. That's all he testified to. He didn't mention the broken femur, the fractured tibia, and he certainly didn't mention the fractured toes on his right foot, consistent with hitting the brake pedal. Nowhere on direct and nowhere in his report does he mention that. That is something that is absolutely important in determining the injury profiles. And when asked why you included some information and didn't include others, he just said it wasn't pertinent to my investigation. Didn't give a reason why it wasn't pertinent to his investigation. All he said is that that wasn't pertinent to what I needed to do. But the only reason why you said that you were hired was to match injury profiles to the damage of that vehicle. And if that's the only thing that you did, were supposed to do, you failed. You purposefully neglected to mention that. It wasn't until Mr. Abadi on cross said, hey, you mentioned all these things, but wait a minute, there's some injuries to the defendant. And it wasn't important for him to include in his report. It wasn't important for him to talk about on direct. He had one goal in mind, which is to assist the defense. The defense's theory has always been Darius Meyer was a driver, which is why the majority of that report is all about Darius Meyer. And maybe a couple of paragraphs about Kenneth Poole. And what's talked about with Kenneth Poole is motor oil on his face. Doesn't take into account the medical records also determined those could be airbag burns. But specifically neglects to mention femur fractures, tibia fractures, toe fractures, all consistent with being the driver. And so please, when you go back there and testify, or excuse me, I'm sorry, deliberate, take that into account. Now, as it relates to the testimony of a single witness, the testimony of a single witness, if believed, is sufficient to establish a fact. And there's no legal requirement generally to corroborate that. If you find that to be true, it's well within your discretion to determine that in and of itself is a fact that you can establish in this case. And here there have been mentions by Ms. Martin, Mr. Jones's mother, as well as EMT Joseph Connors, Trooper Clark, as well as Trooper Clark's own recitation of what we heard the defendant himself say to him. That statement said he was the driver. Without those statements, all the physics, all the direct evidence that you see in that car still point to the defendant. But what those statements do is serve to corroborate the scientific principles that there's no way that Kenneth Poole could have been anywhere else but the driver's seat with that vehicle. So we're getting towards the ending portion of my presentation. I told you I would talk to you a little bit about the charges in this particular case. A couple of legal concepts that you'll be charged with is intent and motive. First and foremost, there's no burden on the state or any prosecuting party to prove motive. The reality is sometimes it's really hard to explain why some people do the things that they do. I have seen things that are almost comical to explain to why people do those things, the most horrific things that you could imagine. But there's no explanation as to why sometimes people do the things that they do. Intent is something that you will be charged with, and it may be inferred from the proven circumstances of the case by the acts that you observed on video or relayed to you through testimony of individuals that were there. And essentially what the intent portion of each of the charges that has been charged with is not necessarily an intent to break the law, it's in the intent to commit the actual acts that constitute the violation of the law. So, with respect to the 5 counts that the defendant has been charged, counts 1 and 2 are felony murder. So what felony murder says is that if a death occurred while a defendant was engaged in felonious activity, it's felony murder. So it's just committing a felony, whether you intended to kill somebody or not, that results in the death of another. So you don't have to prove that the defendant intended to kill. This isn't a malice murder case. This is a felony murder case. So all that you are required to determine in this case is whether or not the defendant committed the felonious act. In this case, which is count 5, fleeing and attempting to elude. And again, I'm not saying that he intended to kill his friends. I absolutely believe that at the point in time when the pursuit engaged, he fully expected all parties inside to come out unscathed. But he committed the felonious act, and as a result of that, he tried to make a run at that exit, collided with a barrier, and in doing so, 2 of his friends were killed. And in this case, as I indicated, the felonious act, fleeing and attempting to elude. So, fleeing and attempting to elude, as charged in this case, is failing to bring their vehicle to a stop after being given a visual emergency light signal to stop, while operating a vehicle in excess of 20 miles per hour over the speed limit. Well, the area that Trooper Clark first observed the defendant's vehicle was at 75-85 junction. And that speed limit was 55 miles per hour. He observes the defendant's vehicle at 95. That's well in excess of 20 miles per hour. The driver of that vehicle continued to drive on despite blue lights, and thus the driver of the vehicle is guilty of fleeing and attempting to elude because he failed to come to a stop. And we know that because the only reason he did stop is because the vehicle crashed. Counts 3 and 4, homicide by vehicle in first degree. What's required to be proven in this particular, or these particular charges: driving the vehicle with reckless disregard for the safety and people, property, reckless driving by doing the following: driving in excess of 100 miles per hour without exterior lights, without changing lanes, without signaling, disregarding traffic control devices. In this particular case, it was the red light at the exit off of 400 onto Lennoxworth. The law does not require that the defendant again intended to cause the death of anybody. It's just that the death happened as it related to the acts previously mentioned. Again, it's charged with 2 counts of felony murder, 1 count for Devin Jones, that's count 1, 1 count for Terrius Minor, that's count 2, and counts 3 and 4 are respectively Devin Jones and Terrius Minor's death. So what is the ultimate issue in this case, right? It's who is the driver in this case. And all the evidence points to the defendant. Why am I able to say that? Based on the evidence. So again, in answering that question using physics and common sense, for a driver and rear seat passenger to swap places, the driver would have to ultimately move back against the forces that are being generated inside that vehicle upon impact. And the rear seat passenger would be having to go forward. Now, that rear seat passenger wouldn't be going forward, right? That's all been clear as it relates to the principal direction of force, that they would be going towards the impact of the vehicle. But nothing about what Mr. Swanner said makes any sort of sense as it relates to how the two respond. And if it did, it would be something that certainly would have been in visual form. Something of that magnitude when you're completely contradicting what a skirt investigator said. When you're trying to be independent, when you're trying to say, hey, I agree with these findings or I don't agree with these findings, that something as paramount as that would not be something as an expert, as a professional, that you would wait to just simply talk about. You would put that in a report and you would document that. You would allow other people to make those findings, agree with those findings or disagree with those findings. But that's not what he did. He just went and babbled on in a way that doesn't make any sense. And when pressed on it, but how you're able to get to those conclusions, all he can really say is it was a crash, it was a violent crash. Doesn't mention anything about what he testified to in his report other than the injuries. And again, those injuries aren't even complete. So you can absolutely take issue with his credibility as it relates to his testimony in this case. In a forward right collision, all parties are moving forward right. And each party has obstacles in their pathway. The driver would have center console, the footwell, which is why the defendant broke his femur, which is why the defendant broke his toes when he was applying the brakes and crashed into that barrier. The defendant is guilty on all counts, based on all the evidence that's been presented to you, beyond a reasonable doubt, drawing the most logical conclusion when grouping the facts together and making a determination. And that's why the defendant should be found guilty on all counts in the indictment. I appreciate your time. Thank you.
Thank you, Mr. Rao. Mr. Miller, when you're ready.
Ladies and gentlemen of the jury, my name is Stephen Miller, as you all know. That's Ms. Bird, as you all know. And that is Mr. Poole. And they want to say that he is a murderer. They want to say that he is a murderer. They are saying that he's a killer. And not only is he a killer, but he killed two of his best friends, two of his brothers. And to show that, that's what they gave y'all. That's the evidence that they gave y'all. They want to call him a murderer. And what did they give y'all? I don't recall. I don't recall. I don't remember. I must have made a mistake. Oh, that other person was in that seat. You're right about that. Cheat sheets. Cheat sheets. I don't know who was at the hospital with him. That's what they gave y'all. To call him a murderer. To say that he is a killer. I do not recall. I cannot tell you this. I don't have the answer to that. No one ever did that part. That was his job. That was his job. No, that was his job. And they want you all to call him a killer of two of his best friends. Ladies and gentlemen, they have got to prove beyond a reasonable doubt every single element in that indictment for each charge. Let me rephrase. They have to prove every single element of a charge with intent to commit. That's got to be proven beyond a reasonable doubt. The judge is going to give you the law. I want to touch on a few. Mr. Poole is not only presumed innocent, he's innocent. And there's nothing that they've done to change that fact. That presumption remains with him unless it's overcome by the state with evidence that's sufficient to convict you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment, every element of each crime charged. There's no burden upon the defendant. Burden never shifts. If a defense is raised, which it was, by the evidence, the burden is on the state to disprove the defense beyond a reasonable doubt. They hadn't met the first burden of proving beyond a reasonable doubt with the evidence that they presented. They certainly haven't met the second one of disproving beyond a reasonable doubt our evidence that Mr. Poole was in the backseat of that car. They can't even disprove that. Why? Because not only is the truth that he was not the driver of that car, the evidence points to that. And that is why there is not only reasonable doubt, but no doubt that he was not the driver of that car. Just a few points of where does that reasonable doubt come from? That preconceived location of him inside the car when it came to final arrest. What's Trooper Clark saying? All you had to do was stop. From the jump, immediately, he assumed that Mr. Poole was driving that car at the scene. I suspected him of driving that car. Statements, let me do this. Statements by Mr. Poole. And you all will get a charge of out-of-court statements by a defendant. They must be corroborated, or you cannot consider them. That's what the law says. Those statements have to be corroborated. What is corroboration? I went to the store. Jane says, I saw Steve go to the store. That's corroboration. That's how you get to a truth. That's what lends credibility to a person. I did this. This person says they saw this. This person says they saw that. It's corroborated, and it's corroborated, and then you have the truth. Then you understand what really happened. Corroboration. This is court. This is court. Evidence, corroboration. Knowing what you're here for. This is not a game. No one is playing. You bring that to the stand and they expect y'all to call him a murderer based off of that. Why are they playing? Joe Connor's on the scene, and then there's a question mark. I shouldn't even be able to make that a thing. That's the point. We're gonna go into it more. But the fact that you got a statement from someone that I can show was never even at the scene, that's a problem. That is an issue, a huge issue. Trooper Clark is walking reasonable doubt. Corporal Lee has already admitted that there was no independent investigation. He went off of what Trooper Clark told him. If anybody is trying to make some puzzles fit, it's Corporal Lee. Everything they gave you is trying to make puzzle fit. Puzzle pieces fit where they do not belong. That's everything that they gave you. That's not how this works. None of that is corroboration. What that is trying to prove a negative. And it's impossible, and that's why their case is falling apart. That's why people can't recall. Because they're trying to prove something that didn't happen. They're trying to prove something that does not exist. He is not a murderer. And they did not prove that. Mr. Poole in the back seat follows the physical evidence at the scene. It follows the physical evidence inside the car. Somebody went through that back seat. The center console tells that story. That passenger seat tells that story. The driver's seat tells that story. You know who didn't get up there and lie? Those pictures. The pictures that Corporal Lee brought, they did not lie. They show somebody went through that back seat. The evidence they brought, go through some of the testimony from different ones. Ms. Martin, she's the mother of Mr. Jones. She stated the reason or the way they got the picture of Mr. Minor in is because she claims she went to the barbershop to see Mr. Jones while Mr. Minor was there. The barbers came to this on the stand and they testified. When Mr. Minor came to Atlanta, Mr. Jones took his spot at the barbershop. They never worked at the barbershop at the same time. They testified that she said that she had phone records showing the conversation between her and Mr. Poole. She didn't produce it. I understand the position that she's in. She's been told a lie. And she wants that lie to be what's happened. But evidence of the following. She said that she had a statement from Mr. Poole that very closely resembled that statement that Trooper Clark said. When asked by Ms. Bird, have you ever told anybody this before? She said, no, no one's ever asked this question. You have kids. One of your kids is involved in a situation, and it's a bad situation, and you are talking to the person that they are saying did it. For 5 years, that person tells you something that you're not going to tell anybody until you take a stand because it's the first time somebody asks you that question. You're going to hold an incriminating statement until 2025 of December. I understand the position she's in. I understand, but it's got to follow the evidence. Take note. As you all are here, you should be observing everything that happens in trial. Evidence comes from the stand. Evidence comes from what's presented on the screen. Take note of appearances of witnesses, how they present. Do they come off? Can you read them well? Notice things. If someone is on the stand and somebody walks up to that person while they're on the stand and whispers in their ears and then walks off, take note of that. If that person walks back up to them and says something in their ear, take note of that. If you then see that person on the stand grabbing tissue, who was already smiling, grabbing tissue, now they're tearing up, make note of that. Observe everything that happens in trial. Sympathy, prejudice. Your verdict must be based solely upon the consideration of the evidence, according to the laws given to you in this charge. It is your duty to consider the facts objectively without favor, affection, or sympathy for anyone. It's also your duty to report to your honor if you perceive that a juror is making decisions based on improper consideration of race, gender, religion, or sexual orientation. Sympathy cannot be taken into account here. This is court. You're on the 8th floor. You're with the Honorable Judge McBurney. We deal with evidence. I think does not exist here. I believe does not exist here. Evidence is what we work with. That's the confines of this. Evidence to prove that he is a murderer. Where is that? I will. Mere presence, you'll get that. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows beyond a reasonable doubt that that defendant committed the crime, helped others to do it, or otherwise participated in criminal activity. This is what I concede. Mr. Poole was in the car. I'll concede that. Mr. Poole was in the backseat of the car. Is the other part. The simple fact that he was in that car does not make him guilty. That's what Trooper Clark wants you to believe. Where's that evidence coming from? It comes from the testimony, it comes from the exhibits. You heard the testimony from Clark, Gass, Lee, Buckingham, EMT Barry, Hainger, Tate, Martin Patrick. And then we brought as well Mr. Williams, Ms. Jefferson, Dr. Conley, Nurse Freeman, Ms. Lewis, Ms. Poole, Ms. Phillips, and Mr. Pettis. And then the accident reconstructionist that did an independent investigation of this, Mr. Swan. Mr. Tate's testimony. Why was he here? What did he offer? It didn't move the story, nothing. He said there was a video, I was on live, and Mr. Jones was saying we're on the way to the Airbnb. Right? The only other thing I could think of is to confuse you all and make you not think Mr. Poole was driving his car at some point when he was in Atlanta. I'll concede that as well. At some point in his drive from Memphis to Atlanta, he was the driver of that car. The devil is in the details though, because they gave you that video. What do the details show? This occurred going north on 75, 85. At the split, still going north on 85. You all are citizens of Fulton County. Y'all know the city. You know the highway. Definitely the details. What's in the background? Of this video. That's the Bank of America Plaza. On 75, 85, right now it's to their left. Which means that they are going south on 75, 85. Y'all know this city. As blurry as it is, that's a bridge. The 17th Street Bridge. Coming from 85 or 75, going south in that direction with the Bank of America Plaza to your left, and the 17th Street Bridge over you is going south. It's going towards the Airbnb. Where did Brandy tell y'all the Airbnb was? Right around the corner from the courthouse. How you get there? Going south on 85, going past this courthouse. That's how you get there. The devil's in the details. Why did they show you that? You stated it was a video, live story. We don't know. It's so blurry. It serves no purpose. Trooper Buckley testified. Mr. Meyer was crunched up in the back. Clark testified that he was laying in the back. Both of them were calling it a seat. Car is upside down. That's what we call mischaracterization. It's confusing. The car is on its roof, there is no back seat. Buffington did not produce his dash cam. They did not get that seat. Gas is another trooper there, has a car, has a dash cam. They did not give you his dash cam either. Janelle, another one. His dash cam's not here. I told y'all in the opening, I'm gonna give you everything I can give you that they don't give you. Full picture, everything that's going on. Why don't you have everything? But on direct, Trooper Clark stated, I like this part. He stated that I went to the hospital, Buffington and Janelle were there when I went there. He's trying to insinuate that when I went to the hospital to do this interview, both of them were there. On cross, when I asked them, were they there? Were they in a room with me? I don't know where they were just there. So why did you tell us? What was the point of that? Why would you tell them they were there and then they weren't even in the room to corroborate, as the law states that you need, this statement that you had? Why? Buffington didn't testify that he went to the hospital that night. And neither did Trooper Ganell. Remember I told you, corroboration. I said this, he said that this happened, and then we stack it all up, and then that's corroboration, and then we have a fact. Gas. Evidence not collected at the scene. They did not do an inventory sheet. They did not do a tow sheet. And as such, there was no hold placed on the vehicle. They charged him with murder. And you can't even put a hold on the vehicle so that we have all the evidence for you. They charged him with murder. And we don't have an inventory sheet of all the evidence that was out there. EMT Barry came. He testified that he responded to the vehicle crash. He's no longer with Grady, but was at the time. Dispatched at 3:08, arrived at the scene at 3:25. He said at the time when he arrived, he was the first one to get there. The first EMT to get there. That Mr. Poole was with fire. He stated that he was about 15 feet away while fire attempted extrication, that he could not go into that area. So his first time encountering Mr. Poole was not until he was extricated from the vehicle. He stated that the damage to the vehicle was to the front passenger side and that he was laying on his back on the roof of the vehicle, not in the seat, on the roof of the vehicle. Asked, where did you get that information in your report that said that he was the driver? I got it from fire. Fire came, they testified, we couldn't tell where anybody was. Where did he more than likely get the information from? Trooper Clark. He said that the scene was substantial. While he's in the back of the truck, the EMS truck, his primary focus is keeping that person alive. His report states that he was alert, but what he told you all was, I cannot testify I can't testify to anything that's not in my report. So he can't tell you the questions he asked. He can't tell you if he was actually alert and how he remembers him to be. He can't give you that. All he can do is tell you what's in his report, which is the same except for the part that contradicts what Grady is saying. He says the mask was on Mr. Poole, the same mask that fire had on him during the ride to the hospital. And then he relayed blood pressure to Grady. He relayed the pulse to Grady. He relayed the oxygen saturation to Grady. And this is what he told you. He said there were only 2 people on each truck for Grady. On his truck were him and Megan Wingo. And he said the other truck that was there was for Mr. Minor. And he cannot identify the other 2 people that were on that truck. He does not make any mention of a third ambulance. What he says is, we were the first on the scene. Mr. Jones was already declared deceased. Because if there was an ambulance that was going to take Mr. Jones, it would have been us, because we were the first ones on the scene. The other ambulance was waiting on extrication, which would have been him and the one that took Mr. Minor. 2 ambulances. That is all. No evidence of a third ambulance. He said the 2 on his truck, him, Wingo. Joseph Connors was not on his truck. Joseph Connors did not sign his report. He said that other truck, that other ambulance is going to have their own report. And it's going to be signed by the 2 people that were on that truck. He said Atlanta Fire told him he was, Mr. Poole was the driver, and so he added that to his report. The deceased person is not our responsibility. And then when they showed the video, he pointed to himself with the cap on, and then he pointed to Wingo. And you all will see it, where both of them are standing there waiting on Mr. Poole for extrication. It's just the 2 of them. And it's just the other 2 paramedics that were there for Mr. Minor. And that's all that you see there. And then Mr. Abate asked him about Joseph Connors. I have no recollection of working with someone named Joseph Connors. He doesn't recall Joseph O'Connor being there. Me, Wingo, that's all I got for you. Those other two EMS. Connors was the testimony that we read to you all. And this is the gist of it. We mostly learned about his background, 17 years as a paramedic, he's a former Marine. He does not have any independent recollection of the events. This was a substantial, significant crash. You all saw first responders out there with their phones. You all saw people out there taking pictures. Everybody, Captain Henderson didn't even have a report, but recalled this because it was so significant. Joseph Connors, no clue what you're talking about. With that kind of crash. I saw you all's faces when the first time you saw the car in opening, in Mr. Abate's opening. Y'all felt something when you saw that. Mr. Connors, nothing. He does not have an independent recollection of the events. He cannot testify that he told Trooper Clark anything. He does not recall telling Trooper Clark that he was not at the scene. You all have a statement from a person that was never at the scene. That is ridiculous that I can make that argument in a murder trial. That is ridiculous. That's what they presented to y'all as evidence that he is a killer. A statement from somebody that wasn't even there. Murder. He's charged with murder. And you got a statement from somebody that says, he told me he was a driver, and that person wasn't even at the scene. Captain Henderson, he was excited to see Mr. Poole in the courtroom. That was genuine. When he looked over and he saw Mr. Poole, he was genuinely excited. He stated that he shed tears after this call. It was significant. He remembers it despite him not having his report. He remembers the call. He said, I asked him about the report. He said he has a report, but he hadn't seen it before trial. We don't know where that report is. We don't know what's in that report. Stated that he thought that he would be blind because of all that oil. That he was in so much pain that he was in shock. And then he described shock to you all. Said, quiet, not making noise at all. And that's concerning because the way that his legs were mangled in that car, he should have been yelling. Highly probable that individuals would not be in the same position. Too many variables. He didn't tell EMS that Mr. Poole was the driver. They didn't have any seatbelts on. And he said there's too many variables. He went through the list and said, you can do this 1,000 times and it not end up the same. Too many variables. Somebody might grab onto a chair on the way out. This thing might hit them, that's in the back seat with them, changing the trajectory, possibly. The car may hit it slightly at a different angle the next time, and then it does a different roll other than the barrel roll. Too many variables for them to even think about that. You know whose job that is? It's accident reconstructions. It's not EMS's, and it's not fires. The purpose of a seatbelt is to keep a person where they are. It's not a person where Now, if you put them together, okay, we're getting somewhere. But that seatbelt is what keeps you in your seat. Is what keeps you there. The airbag does not serve that purpose. It doesn't. He stated that when he checked Mr. Jones and they were the first on the scene, he did not have a pulse. And we already know that EMS is not going to go near someone that is already pronounced dead. Because Barry told you that's not us. That would be law enforcement's job. EMS is not going to do that. Then you had Pettis. This was that video from Stinson. We already got identifications from, what we got from Pettis as well as from, Barry. Barry said, this is me here. This is Wingo. Pettis said, that's me right there. And that's my partner, Bird. That's Bird. The only 4 EMSs at the scene. 2 beds. And that's Mr. Poole getting out. That's him after extrication. Even if Joseph Connors was there, you all will have these videos. Even if he was there, there's no opportunity for him to talk to him. One, EMS never went to him while he was at the car. But secondly, when you all see the video, he is immediately taken to the ambulance, put behind the truck, and they leave. You hear the sirens, they're gone. What opportunity would he have had, Joseph Connors have had to say this? There is none. Because he wasn't there. It's not just what is said, can you corroborate? What lines up? What actually makes sense? And a person being carted off after extrication, telling somebody, oh yeah, I was the driver. After being taken in the back of the ambulance doesn't even make sense. Doesn't make sense. EMT Pettis came on, we call it EMT Pettis. We call it the fire chief as well. I like to keep my promises. And I told y'all, if they don't give it to you, I'm gonna try to give it to you as much as I can. So we call Pettis. He said he stood with his partner and the other EMS personnel. There's only 4 there. He stated he does not know Joseph Connors. Now, Vante got up and said, do you remember telling us on the phone that Joseph Connors was there? His response was, yes, I remember telling you that. And then I got up. Did you know what Joseph Connors looked like? No. Did they show you a picture of Joseph Connors? No. After we showed you one, was that person at the scene? No, he wasn't. Do you remember telling us that Joseph Connors was there? He testified that he had only been at EMT for a couple of years. He didn't know who this Joseph Connors person was. And if he told you he was there over the phone and you haven't shown him a picture and you haven't shown them anything to identify this person, and then when he finally sees the picture, finally sees the video, and says, no, he wasn't there. That's me, that's Wingo. I don't know that guy with that hat standing over him, but that's Bird. Because Joseph Connors wasn't there. Dr. Hinger, he brought in the pictures of Mr. Minor as well as Mr. Jones. The pictures of Mr. Minor show an imprint of an airbag into his chest. It's on the right side. He tried to clean it up and say, well, it would be on both sides when I asked him the question. I drive like this. This is how I drive. The other day, I hit a corner too hard. Why hit it? I was turning. And I had to lean into the turn. Okay? I'm leaning into that turn. And I got my hand up here. And I'm driving with one hand. Where's that airbag gonna hit? Where are you gonna see that impression at? It's gonna come here. And he stated that it is possible for airbags to cause fractures to those ribs. He stated that. He said they're consistent with airbags. He said the burn comes from the side center console of the gear shift. I'm sure I got that picture up, but you all saw it of Mr. Minor, of the abrasion, the deep strawberry that was right here, that was on his hip. And it is consistent, according to Dr. Henninger, with the gear shift. And then he said I had a right humerus fracture consistent with airbags. That's right here. He said that's consistent with the airbags. I'll also state or contend that you know what else is consistent with coming up out of that seat and hitting that windshield. It's also consistent with that. There's a right side of that chest with that bruising caused by the airbag. And like I said, you're driving like this, and you're leaning into it, all this is exposed. All of his injuries were internal, into the chest, into the torso, liver, gallbladder. And then there were those rib fractures here, but also posterior. It's been a long week.
2
Minutes?
No, 2 weeks.
Oh, okay.
You have plenty of time left, but it's been 2 weeks.
This is the abrasion shown on Mr. Jones. Corroboration, consistent with. It is consistent with somebody sliding back towards that bridge. At impact, if Mr. Jones came out then, he would have hit the fence. Consistent corroboration. Swanner told y'all how he got there. And the way that their accident reconstruction to say that he got there doesn't make sense. He tried to argue that the bridge is at a slope and the blood would have ran into the street. Why would that doesn't make any sense? Why would they design a street for the water to run into the middle? The whole purpose is to get the water off the road. It doesn't make sense. That's consistent with sliding along that pavement, and that's consistent with that blood trail that you all see going towards the bridge. Here's the abrasion. Gear shift. Airbag. Windshield. Line up the injuries with the car. Line up the injuries with what's damaged in the car. Dr. Hendry said the contusion is similar for both front seat passengers. Mr. Minor had burn marks on the lower right side, abrasions. Mr. Jones had a similar mark on his lower right side. You all will have that picture showing it. I can't put anyone in any position for sure. That's what he said. Just give me something, I can't tell you where anybody's sitting. Swanner can. But we should not expect our medical examiner to do that. Only thing for sure is the person that was ejected. Ribs are hard to break, and the ribs are broken posterior, as well as here on the right side, and that the airbags do cause fractures. Ladies and gentlemen, if you are in the back seat of a car and everything in that car is moving at the same speed that that car is traveling, and that car hits a wall at 78 miles per hour, if you are in the back seat, what is going to hit you from behind to break those ribs posterior? What could do that? Now, if you are the driver of the car and you are in that car going 78 miles per hour and you hit a wall at that speed and you're going forward like this, someone from behind could hit you posteriorly to break your ribs. But how do you have broken ribs posterior if you're in the back seat of a car. Everything's going forward. Everything is going forward. More injuries to minor. Contusions on the chest. You all have seen that. Contusions on the chest. Abrasion of the right abdomen. Here. Contusion on the lungs. Here. Lacerations on the liver. Here. Horizontal laceration across the hilum. I'm not gonna pretend like I remember where that was in the body, but it's in the torso somewhere. Gallbladders, up underneath the liver. Right ribs 4 through 9 fractured. 1, 2, 3, 4, 5, 6, 7, 8, 9. Right side, fractured. Hemorrhages on the left rib, but not fractured. Pubic symphysis slave. That's the tendon that is right down here. You know what is near? The steering wheel as you're going up and to the right. Right kidney. Here. And the nurse told you that that could be damaged from the front or from behind. And the right kidney being damaged from behind is consistent with somebody from behind hitting you as you're going towards the windshield. The right kidney, coupled with the posterior ribs, doesn't make sense to get injured if you're in the back of the car. Because you're in the back of the car, you're the last thing. Everything's going forward. Right humerus fracture. Humerus, windshield. Trooper Clark. Trooper Clark. Horrible investigation from the beginning. He didn't even follow his own policy and procedures. He admitted that you have to turn on your lights if you're speeding, if you're changing lanes, and he didn't do that. He said he first noticed the vehicle on 85 north just before the split. He did not know who was driving. He could not see inside the car. The windows were tinted. He did not know how many people were inside the car. He did not receive any information regarding the driver of that vehicle. That's why he continued with the pursuit. Started to narrate as soon as he saw the vehicle. It's important to document, important to get narration prior to the lights coming on. Because he said, when the lights come on, it only goes back 30 seconds. He wanted to get more. It's so important to document. And it's so important to get all that information. Why don't we have any corroboration for everything else that you did? Why don't we have any corroboration of that? We don't have anything else to show anything else that you did. Instead, this is what we have. That's all we got. All he had to do was stop. Because from the beginning, despite knowing who was driving, despite knowing how many people were in the car, despite having any information on the driver, he saw one person that was still alive, and all that person had to do was stop. And Mr. Rao can say he's speaking in general, he being everybody. Pronouns matter. He didn't say they, because the car had 3 people in it. He didn't say them, because the car had more than one person in it. It said he. And the only person that was still alive was him. And that's what he was blaming everything on from the beginning. All he had to do was stop. And then he told everybody at the scene the same story. He did not put the position where anyone was in his report. Because he can't. Did not have dash cam footage to show where anyone was. He said he went to the hospital shortly after. Then he said it was immediately. And then he said it was sometime afterwards that he went to the hospital. He can't even tell you what time he went to the hospital, so I can tell y'all what cocktail of pain medicine that Mr. Poole was on when he was there. But what he said was immediately. And what we know is immediately, he was given fentanyl. Fentanyl. Shortly afterwards, ketamine. He said that he went to the hospital unaware of the medicine he was under. He said that he was conscious, breathing, said he could talk normal, have a regular conversation. He doesn't remember anybody in the hospital with him. Not a single person. Again, this is such a significant crash that there are witnesses that don't need reports that can tell you where they were during this scene, and they are first responders. He can't tell you when he got this statement who was in the room with him, where he was. Was he in trauma? Was he in an actual room? He can't give you that. He can't tell you that. And then you see this. Hours after the accident, and Mr. Poole still looked like this. And his cousin told you all, I was there. I touched him, he didn't do anything. I talked to him, he didn't say anything back. That was the condition that he was in. Again, fentanyl immediately afterwards, and ketamine. That's what he looked like. Pain levels were at a 10. But Mr. Clark, Trooper Clark, is having a conversation with this individual. That's what he wants you to believe. Corroboration, where's the evidence of that? Where? How? How are you having a conversation with this person? And his cousin can't even have a conversation. They said he couldn't even open up his eyes. And who else said that? Captain Henderson. I'm surprised that he's not blind. Captain Henderson told y'all that. So did the cousin, so did the auntie. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. There is no specific amount of supporting evidence necessary. You must determine whether other evidence, proven beyond a reasonable doubt, sufficiently supports the defendant's alleged statement to justify a conviction. The statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. It's hard to do that under the influence of ketamine and fentanyl and tramadol and all the other vast opioids that were given to Mr. Poole. But it has to be voluntary. And to be voluntary, a statement must be freely, willingly given, and without coercion, duress, threats, use of violence, fear of injury. Burdens on them to establish that the statement was voluntary. If you do not find that the statement was voluntary, you may not consider it for any purpose. We don't have any statement here, ladies and gentlemen. There's no corroboration of any statements. And we have somebody that wasn't even at the scene that says that Mr. Poole gave him a statement. You don't have a statement to work with. You've got evidence of Mr. Poole inside of a car at some point, and that is it. you can't consider that statement. The medical records are important for a number of reasons. They show more than just everything that Mr. Poole went through as far as while he was at the state, his injuries and the medication. But they also got records or records of some of the individuals that came. And so there is a record of GSP coming to the hospital. But that wouldn't have been around the time that Trooper Clark said that he came to get that statement. There's a record on April the 18th of him coming to the hospital. And it says that his blood pressure was elevated, breathing hard. I think it even said something like he was told about crime or charges, something to that effect. So on April 18th, you all will have those records. That's in there. That's corroboration. Okay, that's something. All right, yeah, you went this day. This other day, nothing there. It also has in there that the family was there, and you'll see notes that say such and such given to his sister or family members upon their request. Mom, this, sister, that. They're in the records, and it's around the time when they say that they were there. Trooper Clark, if it's him, it might be some other GSP person, because all it says is Georgia State Patrol. The only record is at 4/18, April 18th, which is 9 days afterwards. Then you have the Glasgow fluctuating from 15, 11, 14. And according to Dr. Conley, these are all signs of brain injury. Ketamine, oxycodone, and as Nurse Freeman told you, override for fentanyl as a life-saving mechanism that the nurse would do. This statement is not audio recorded. This statement is not video recorded. This statement is not signed. That statement from Joseph Connor is also not signed. It's not audio recorded. It's not video recorded. One, because it wasn't there. But there's no corroborating evidence for that statement. None. Nothing to corroborate any of that statement. It cannot be considered. Here's that note. Georgia State Police entered patient room ×2 to discuss criminal charges. Patient became emotional, heart rate elevated, chest pain, no business, other symptoms noted. Officers exited room as he noticed patient's response. Patient requested phone call to his mother. That's 9 days later. The only time that GSP is mentioned in those medical records. But you got this right here. Another instance where he's trying to tell everybody at their scene who was driving the car without any evidence of anything. That's Trooper Clark. Another time where he's telling everybody at the scene that Mr. Poole just had to stop. Where he is telling everybody at the scene something that he cannot confirm, that he does not know the answers. His testimony was that when he walked up, he saw someone, I said, were they crawling? He said, crawling, wiggling, they were coming out of the passenger side. He's saying when he got on the stage, I immediately saw one suspect in the front and one in the back. He said, but watch the video. And he's asking, y'all see anybody else? Is there anybody else here? He said, investigating a traffic stop. Well, hey, I'm gonna tell y'all this. He's the UI task force, Nighthawks. And investigating a traffic stop is not the same as a homicide. It's two different things. One of you all said, or you asked, if you're able to determine who the driver is just by the tag. His response to that question was, he had no clue who was driving that car. So why are you telling everybody at the scene that all he had to do was stop? Joe Connors never testified that he made any statements to Clark. He never testified that he did not recall. In fact, he testified he did not recall making that statement. In his report, Clark doesn't note this until after warrants were secured. And the testimony was that he received the statement at the scene. If you received that statement at the scene, why is it not in your report until after you got the warrants? Let's have some chronology when we're writing. Let's make it make sense. And again, not audio, not video, not written. All he had to do was stop. Ladies and gentlemen, this is the aftermath of that collision. My first time seeing this is, how do you expect anybody in the front of this car to survive? Anyone in the front seat of that car to survive? Who expects that? Hitting a wall at 78 miles per hour? Logical sense. Let's talk about physics. Look at that car. You expect a front seat person to survive that. We don't need an accident reconstructionist for that. But we have one. On the side, this is just to keep going. Extrication was on the roof. You'll see the spacing here. The roof. No one was in the seat. Corporal Lee, what did he do? Use marking paint for the scene. He took pics and videos, didn't take any pictures of them while they were in the car, how they laid, any of that. He said force caused the vehicle to flip. And then he said it was a violent crash. And the way that he said it crashed, it just doesn't match any of the physical evidence of the scene. I wanted him to, because I wanted to make sure I understood what he was saying. I looked for a car. It's Christmas time. There's none in stores. Let me get the car, please. I did find one. Only thing I could find. What he's saying is that that car hit this wall and then went like that, and then eventually turned over. That's the testimony that he gave. That's not violent enough for what you all see in that picture. It's not violent enough. And not only that, there are no tire marks. There's nothing to show that that happened. There's nothing, it doesn't line up with the evidence. It doesn't line up with the evidence that's on the street. That doesn't make any sense. Laws of physics, he said the crash happened in milliseconds. And that's based off of the ACM. He said it's not my responsibility to do inventory, that's Trooper Clark. He stated that he instructed gas to do a hold on the vehicle. That wasn't done. He said it was done. However, it's not in the file. Everything that's done should be in that case file. It was not done. It was not done. The only thing he's able to tell you, the focus that he had was the speed of the vehicle. That was it. That's the only thing that he can prove to you all, how fast that car was going at impact. His report, based off what Trooper Clark said, nothing independent. Mr. Poole is the driver. Mr. Jones is in the back seat, and then Mr. Meyer was a front seat passenger. That's what he told you all was in his report. I must have made a mistake. But it's odd how the only mistake that you made is based off the information that Trooper Clark gave you, which put Mr. Poole as the driver. Everything else was just plug and play, just put this person here, this person there. Where it doesn't even make sense for Mr. Jones to be in the backseat. And it doesn't make sense for Mr. Minor to be a passenger. And he told you that Mr. Jones came out at impact, which doesn't make sense with the scene. There's a red substance here. I'm gonna say it's blood. Does that definitively tell us who was driving? I would argue no, but it's a super good indicator of who possibly was in that car. A great indicator. We don't know whose blood that is. It's red, it's not black, it's not oil, it's red. It's not burnt, it's not compromised in that way. The only fire was on the passenger side. It is a lily white airbag with the blood stain on it. I would argue when you see the picture of Mr. Minor and you see the damage to his nose, that that's where that blood came from. But you'll never know because they did a complete investigation that lacked finding out simple things. He took about 8 pictures of this, even took it out the car. That is blood. Whose? We don't know. I would argue that maybe it's not definitive of who was driving the car, but it's a great indicator. A great indicator. I would argue that whoever left that blood on that airbag more than likely left that blood on the tachometer as well. But we'll never know because they did a complete investigation. This was evidence showing that it's impossible for Mr. Jones to have come out at impact as he indicated. Because you have Mr. Jones and the evidence lines up with him sliding on the street. The evidence lines up with that car being flipped and him being thrown in this direction towards the bridge. And then you have the car. There, I'm not sure if you all saw it, but there is a, you'll have it. There's a deep cut on Mr. Jones right here. I would argue that that's what caused that. Mr. Swanner, he didn't give me that. It's fine, you know? And he couldn't say that because he hadn't looked at it like that. But me looking at this, that injury marks up to the fracture on Mr. Minor going from here to here, that also is consistent. I would argue. And that's what caused that. But a person going through there doesn't make sense. It's too small. And then you all see the bowed seats that indicate that somebody went through here. Not that something hit up against it, something went through that Mr. Swanner has already testified. The positioning of this seat, I don't know if they're gonna try to say this, but I gotta try to guess. How can somebody fit? The seat is right up on the roof. Remember what Swanner said, the hood bowed like this at impact. What we don't know is when that seat was moved and if it was moved at extrication. That's what we don't know. But we do know that that seat has damage to the bottom of it and it's pushed forward and to the right. That's what we do know. So, what didn't Corporal Lee do? No measurements. Nothing to show anything. No debris field is wide. We don't know how big it is. Nothing is measured. We don't know the distance from the car to the body. We don't know the exact distance from the intersection to the wall. We don't know the distance from the sidewalk to the wall once the car jumped the curb. We don't know any of that. We don't know how far the wall is from the final resting place of that vehicle. We had no measurements. And the debris was never cleared up so that we could clearly see the roadway and what everything did at that point. We don't know the distance of the tire marks at a minimum. He generated this path of travel. States Exhibit 131 that has the infinity in this left lane the entire way down. And this left lane going up right here is always trying to make a left. Why is that important? Because the video doesn't show that car was in the left lane. It actually shows it over to the right lane. That becomes important when I start talking about Brandy's testimony, who said she picked up Mr. Minor from Phipps' apartment on that exit. If you turn right, that's Phipps. If you turn left, it's another street. But Phipps is to the right. Watch the video. And you'll have it back there with you. That car is not in that left lane. It's up against that wall nearly, attempting to make a right. But there's an issue with the car turning right. And that issue is, look at it, it's in that right lane. It's not in the left lane, it's in the right lane. The problem is that there are a set of brake lights right here at the turn. And so that car cannot turn right going towards Phipps. Instead, it has to make a left. See it again. It's not in the left. It's all the way over to the right. It has to make that left at that point.
No, hang on, left on Lennox, left on Lennox, almost
You'll have it back there. My time is limited, and I got a lot more to get to. This is a debris field. What would be nice if it was cleaned up so that we could see that clear path. That way we would know exactly what that car did after it made contact. And if the back of the car turned, where is the physical evidence to show that? If the back of that car went this way, why don't we have any tire marks showing that the back of the car went that way? Why don't we have the tire marks showing that the front of the car was trying to turn that way? Instead, what you have is a line going up that show you that that car did what Mr. Swanner said, a barrel roll. He told you all that seatbelts were designed to keep you in. And then he gave you the Delta V. It said that changes of 15 to 17 serious injury if it's above 24 serious death. In this case, you heard from both him and from Swanner that the Delta V was over 50 in longitude and 41 in latitude. Both well over that. The exam from Dr. Conley was done in April of 24. And he stated that after speaking with Mr. Poole, based on the medical records, he had a concussion at the time he was in the hospital. To show that the Glasgow score fluctuated throughout, and he was alert and oriented ×3, not ×4. That fourth would be, why are you here? The whole you'll have those records. He's A&O ×3 the entire time he was at the hospital. He had opioids in his body. And he said one of the biggest indicators of that TBI, when he had his examination of Mr. Poole, there was prolonged symptoms of a traumatic brain injury. 33 seconds, that's the time it took for Trooper Clark to get from the bottom of the exit to the top where you finally see Mr. Poole. You all will have the video, you can do your own calculations. 33 seconds. We can't see what happens in that car. We have to use forensics, which is Mr. Swanner, to put that together. Nurse Freeman, over 24 years in healthcare, 15 in ER, said that EMS intake is at the same time as Grady. That is Ms. Bell. Trauma room only has doctors and nurses in it. No family is allowed in the trauma room, and no law enforcement is allowed in the trauma room. Why? She said, because that's not important. The only important thing in trauma room is saving that life. And whatever law enforcement has to do, they can do that later. And so immediately visiting somebody, and we all know that that person is in the trauma room, you're not there to help save a life, you're not getting in that room. And then she said that he immediately received fentanyl once he arrived to the hospital. Everything matches up. This is a side by side of that Grady EMS report. 348, unit 643. The unit is like the third, fourth page that you all will have. Patient age 22, motor vehicle crash and ETA 15 minutes. Trauma level 2, based off of the Glasgow score, 11 to 13. 15. Blood pressure was the same. Everything else was the same. The only difference between that report, her report, and Grady's report was the Glasgow coma score. And she said that the EMT person at Grady, all they're doing is writing down whatever is being told to them. While on the other hand, EMS is actually in the back of the truck doing a number of other things. And EMT Barry already told you that he didn't write his report until after the handoff. That's the report showing that the fentanyl was given at 4:12 a.m. His arrival was 4:03. Ketamine, 7:56 a.m. Patient's family is there. That's at 11:39 a.m. At 4:12, 11:21, alert Orion with eyes closed, follows commands and mumbles. Mumbles. This is on April the 12th. This person is having coherent conversations with the officer 3 days before, is still mumbling. What did the family tell you? It was a couple days before he even came to. And then you have this long list of diagnosis, final diagnosis of Mr. Poole. And of the torso, the only thing of the torso that is on there is a liver. That's it. This is Mr. Minor. We've already gone through it. The lungs show contusions, liver shows several lacerations, right kidney has a hemorrhage, gallbladder is ruptured, ribs 4 through 9 are fractured, pubic symphysis is splayed. All of those are the torso for Mr. Minor. And of all of this for Mr. Poole, only the liver. You heard from expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person, experts who fit to give their opinion.
Don't read quite so fast for the court report.
Okay, oh, my fault. How much time do I have?
You have 40 minutes.
Okay. I'll be quick. Just a few more things, but I see you all moving. Experts are permitted to give their opinions based on their training and experience. Testimony of an expert like that of a witness should be given only the weight and credit you believe it should receive. In the game, what's the dynamic of the barbershop? They share everything. They were a family. They were. Mr. Williams drove Mr. Patrick's truck. He drove it from the bar and grill to the, from the bar and grill, to the Airbnb and whatever happened with the place. He drove it from the hospital to Memphis. And when you all asked if he had ever saw Mr. Minor driving Mr. Poole's vehicle, he said yes. He said everyone in the barbershop drove each other's vehicle. They were like family. Videos and pictures show timestamps in Eastern time. That's what Randy told you all. And that's the testimony from Randy Jefferson, from Mr. Phipps, from Mr. Patrick, from Mr. Williams. And Mr. Williams told you all, among other things. And what did they do when they got up here, y'all? They didn't have any notes. They didn't have anything prepared. They didn't have any reports. They had timestamps, and what Mr. Williams said was trauma to go off of. That was their memory. You know who else had trauma? Captain Henderson. And that was his memory. And that's why everything that he remembered was how it was. They had the same memory. Randy said when they left out, it was her, Mr. Patrick, and Mr. Poole outside of that restaurant. And Mr. Poole had some wings. They were out there eating those wings, joking, playing around. She called Scooby fat. Said that he was eating too much, he played too much. These are memories. These are core memories that are coming back to her head. That's what I remember. What she didn't say was, I saw Mr. Poole get into the backseat of the car. That's what she didn't say. She said, at that point, I walked off. That's what her memory was. That's what she said. We were out here, everybody else had left, and then I walked to my car, it was just us there, I walked away. I can't tell you where he got into that car. Thank you. Because if she wanted to lie, she would say, yep, I saw him get into that back seat behind the driver. Boom. But she didn't. She told you her truth. Mr. Phipps, I walked out. Mr. Jones and Mr. Minor were out there with me. They were walking with some females. I told them to be careful. Mr. Minor had the keys. I saw Mr. Minor get into the driver's side, and I saw Mr. Jones get into the passenger side. And then I left. So he didn't even see Mr. Poole get in the back. He didn't see him get in the back seat behind the driver. Mr. Patrick did. And out of all these people, Mr. Patrick is here testifying and telling you all something that his cousin, the person that he mentored, the reason he was cutting hair, family, his actual blood, he told you all what he saw. I saw Mr. Minor driving the car. We were outside playing around. He remembers the moment because he had back and forth with Brandy. And so he told you all that. And then he said, I hopped into my car in the passenger side. House had already brought the cars around. And Mr. Poole got into the back seat of his car. That's what he told me. That's what he remembered. Mr. Williams, I pulled the car up and you all asked, what seat did Mr. Poole get into? And he said, he got in the back 'Cause I ain't asked, I forgot. He got in the back, behind the driver. The same thing that Mr. Patrick said. He got the back seat behind the driver. And then one of you all asked this question. And now it was one of the best questions. When he got arrested, do you know why he was arrested? I don't have any clue. I don't know why he was arrested that day at the barbershop. Mr. Patrick told y'all, I didn't think that this was gonna go this far. That's what he told me when I asked him. Because all of them are like, why are we here? Why are y'all here? Mr. Minor was driving the car. Why 4 years later are we having to relive one of the most traumatic days of our lives? Why are we here having to tell this story? We didn't think it was gonna get this, we didn't think that it was gonna go this far. I don't have any clue why he was arrested. They said that they left Encore, Mr. Williams said that they left Encore at 3 a.m. The chase began at 3:03. What I suspect is gonna argue, just based off of some of the questions, was you don't know where they went when they left. Oh, there was another perfection. Both Mr. Williams and Mr. Patrick saw the window roll down. Now the memory is different because Mr. Patrick said, I remember rolling down the window. And then Mr. Williams said, I rolled down the window. But both of them said that Mr. Minor was driving the car. And that they talked to Mr. Minor as he was driving the car, and they pulled up to that light right outside of Encore. And Mr. Jones was in the passenger seat. And that's all they could see. Mr. Jones in the passenger, Mr. Minor driving, and then they left 3 a.m. Chase begins at 3:03. Now, what I suspect, based off the questioning, you don't know where they went. They could have went to a gas station and switched positions. Why? We're in the car. We already got our positions placed. Why would they switch positions at a gas station? And why would they go to the gas station? Because Ms. Jefferson already told you that they stopped in Alabama to get some gas. So what's the need to go get gas at 3 o'clock in the morning? And this is 2021. Y'all remember COVID? Do y'all remember gas stations being open at 3 o'clock in the morning during COVID? No, that's not a thing that would happen. And where Encore is located, right there across from House told you that the aquarium was right there. There's only one gas station there, and it's
Objection, that's not what the testimony or evidence was, anything about a gas station that relates to Encore.
Ladies and gentlemen, one, you'll remember what the evidence is and isn't. Mr. Miller, you need to stick with what's been admitted into the record here about gas stations or not gas stations. Keep going.
y'all know Atlanta. And you know how to get to the highway from where he said that Encore was, the aquarium. It's 3 a.m. Where are you gonna stop at 3 a.m. during COVID in Atlanta? And why would you? All of their stuff, they didn't have reports, so it had to be timestamped from the pictures that Brandy had. So they were at the house at 10:20 p.m. on April 8 p.m. On April 8th. This is them inside the house. There's Brandy, there's house, there's Mr. Minor behind them. This is those memories. Remember, corroboration. This is what we remember happened. We were at the house. DT and Mr. Williams' house were acting old, so we tried to wake them up. That's them being woke. What time was that? According to the screenshot, that was at 1:20. Then at 2:25, you see them inside the club. That's them inside. Those are the timestamps that they had. Shortly after that is when Mr. Williams said he starts seeing those cars. And if you gotta gather all those people together, it's gonna take some time. And remember, Randy said that Mr. Poole had just ordered those wings. So now they gotta get cooked. And now we had to wait on those wings. And then they went outside while everybody else left. Mr. Minor, Mr. Jones, talking to some girls and walking to the car with Mr. Phillips. Mr. Poole inside with Randy, getting the wings. They walk out and Mr. Patrick is there as they walk out with those wings. What all are you all missing? You're missing the dash cam from all the troopers. They didn't bring that. You don't have body cam, though. You saw another APD officer out there. You saw that he had where's his body cam footage? DNA evidence. It's 2021 when this happened. DNA was a thing. Where's that DNA evidence? The owner of the gun, was that gun legally registered to anybody in the car? Was it a stolen gun? Who owned the gun? Your policies say that you gotta run that, but that wasn't done. And then EMT Joe Connors saying that there was a statement when he wasn't even at the scene. God bless you. And it's again ridiculous that I can make that argument. And then Mr. Poole at the hospital, while he's under the influence of fentanyl, every single other opioid that Grady had, and any objective evidence showing the position of the body. That was the scene. That's when Trooper Clark's dash. And you all will get that. Look at this trooper here taking pictures. You see him? That's how significant this was. That they're memorializing themselves with their pictures. All roads lead to Trooper Clark. Clark said he was a driver, and that's what we had to go with. That's what Corporal Lee told me wrong. And you all take note. They said they were leaving, they went to Encore Hooping. And Brandon told you that he picked them up at Phipps Place Apartments earlier in that day. Phipps Place to the right of that exit. What actually happened in this case? Swanner got it and evaluated it with a clean slate to determine where everyone was sitting. It was beaten that they were forward to the right, forward to the right. That's what we all know. And his positioning follows the evidence. You heard about the A pillar, the B pillar, how the B pillar is significant because they're going towards the area of impact, which is that A pillar. And then his injuries and the injury profiles match up with the physical evidence at the scene. How sure are you? He said, I'm 100% sure. The driver was Mr. Minor. The front passenger was Mr. Jones. The back seat behind the driver was Mr. Poole. 100%. The back seat behind the driver, Mr. Poole. Mr. Jones, front passenger, Mr. Minor was the driver of that car. And that lines up with the evidence. There go those streaks going up the wall. You can see markings on here from where the car headed and went up that wall. The swirl patterns that are on the top here, because that's the door. You see the swirl patterns that are on the door that show that the car spun. That impact that he was saying, contact versus induced damage. Induced damage, the windows going out. All the windows are out, except one. The one behind the driver. The safest seat in a collision such as this one. And the only window that is still there is the one where Mr. Poole was sitting at. That's the only window still there in that car. The evidence, you see the bowing of that seat to show somebody went through. And it's not one thing, it's all of these things put together. the damage to the front driver's seat that show it going in that direction. The center armrest bent to the right. Somebody hit that going in a car that hit a wall at 78 miles per hour. Bent that to the right. More of an indication. All of this is put together. The totality of it. It's not just your leg hurt. You must have been stomping on the brakes and that's what caused it. It ain't that. You gotta look at everything. And then the console, that center console that you all will have, that will also show the same thing. That damage to the right showing that somebody went in between. Motivation to lie. Why would Trooper Clark tell that lie? Why would you? To be quite honest with you, I don't care. I don't know why he was told that lie, but he did. I have no clue why he lied, but he did. He lied to you all. He lied in his report. What I believe happened, based off of how they conducted this investigation, is that they didn't think that anybody was going to survive. That's why there weren't any holes. That's why there wasn't any inventory taken. They thought that all three of those young boys were going to die. And that's why they did the investigation that they did and tried to hammer those puzzle pieces in and put people at the scene that were never even at the scene. Because they thought that all three of them were going to perish. They did not take this serious. They didn't take it serious. So why he lied, I don't know, I don't care, but he lied. And he told more than one. There's no evidence to show that Mr. Poole was wanted. He said he ran it, he didn't get anything saying that he didn't have any insurance. He didn't have anything showing that he was on probation. He didn't have anything showing that he was the driver. He has nothing showing that he has a motive to run. No reason. Proof beyond a reasonable doubt. You all are on the 8th floor of the Fulton County Superior Courtroom in a murder case. A murder case. Beyond a reasonable doubt. Not just a little bit. That's state court. More likely than not, state court warrants, probable cause. Maybe he did. That's at the bottom. You're on the 8th floor, the top floor. You need proof beyond a reasonable doubt. They can't give it to you. They did not give it to you. I told y'all, I've been fighting. We've been fighting since 2021. I need you all to fight with me. I need a psychiatrist to fight with me. I need somebody from Texas Southern, the Army recruiter, to fight with me. I need a UGA football player to fight with me. I need a rum runner to fight with me. I need a CNN journalist to fight with me. I need y'all with me. Tell them, y'all can't do this to people. They did it to their family, they did it to his family, and to everyone involved in this. And they keep y'all here for that. They kept y'all here for that. That's ridiculous. Mr. Poole is not guilty. Let them know he is. Thank you.
We're going to take a 5-minute break just to transition. It can be longer if you need it, but we're going to take a break right now. Ms. Rivers has been going nonstop for both Mr. Rao and Mr. Miller's presentation. When we come back, one of the prosecutors will give the final part of the closings, and then we'll see what time it is, and I may charge you then, or I may charge you first thing tomorrow morning. We'll figure that out. But take your break. Don't talk about the case. No outside research. We'll see you in 5 minutes or longer if you tell Deputy Gordon you need more time. All right? Yeah. You may ask a question as long as it's a logistical question.
What time are you leaving today until my husband has to come pick me up?
Got it. So, Mr. Abadi, ballpark, how long do you plan on using about the rest of the time that you all have? Okay. Okay. I'll be able to charge you today, but then the question is, it'll be 5-ish after I charge you. And the charge is not very uplifting. It's legalese. And so you'll be drowsy, but we can get you to perk back up. And then you could stay and deliberate for a while, but that's only if you all can stay past 5. And once you have the case and you're deliberating, you actually set the clock. You could say, we're gonna be back tomorrow at 11. That's when we want to start deliberating. I don't recommend that. I recommend getting an early start. But if during the break, you should talk about this, you all want to stay later tonight, you may. Once the case is in your lap, then the hours are the hours you want to put into deliberations. Yes, ma'am.
Once we start deliberating, do we have to stay until we reach?
No, ma'am, because let's say you start deliberating tonight, I'm making the time up, at 5:15. It may be it's 6. Eventually, we actually do need to kick you out because we need to make sure you make the shuttle, or Deputy Gordon has to personally drive you home. And his car's not that big, so you could stay 6:30-ish. But if you're not done by then we come back tomorrow morning, and when all of you are present, you get the evidence back and you resume your deliberations. And you go as long as you all need to reach a verdict, if you're able to reach a verdict. And I'll talk to you about that when I give you the charge. Okay? So right now during the break, besides using the restroom, figure out how late you want to stay tonight, and we will respond accordingly. Okay? Thank you. You all can be seated. I will, during the break, print out hard copies of the final charge. So you'll have those. Anything from the state before we break, Mr. Miller?
No.
Okay. Then we're on break, especially you, Ms. Rivers. I have a question for... Is Mr. Hutchins here? You are here. Okay. We're gonna have a real quick conversation. I don't know that it's gonna take all that long to work through what we need to work through. I see Mr. Boyder, who is here. And then are you counsel for the other defendant?
Yes, sir.
Excellent. I need you to step outside if that's okay. Thank you. You're here for the other defendant.
Georgia Power, Your Honor.
Okay. All right. Did anyone bring a court reporter?
We did, Your Honor.
You did. Okay. Well, if you want it taken down, then I don't think we can do it during this quick break.
Well, we're happy to take care of it. Hopefully, it's a court reporter here.
Right.
She is.
Fantastic. If we take care of it quickly during the break, I think that would be in the benefit of all parties.
Why don't we try
Let's do
that? Let's just make it it's formal, and then I'll be ruling, but I'm mostly interested in hearing from Mr. Hutchins why he thinks I don't have the authority to make the record complete, which I think I do. But because he objected, and he's got a full right to object, we're required to have a hearing statutorily, which is why we're all together. So why don't I let other folks who want to take a break step outside, and maybe what we could do is Mr. Hutchins could come to the podium, and maybe two counsel for the defendants could be over where Deputy Gordon is, and we'll have a conversation. I'll come get you. You just relax. Oh, you're doing something. Whoa, what's happening?
The real time stop in the middle, so I'm just
Oh,
passing that to her.
all right. Hey, Mr. Hutchins, I'm Judge McBurney. It's nice to meet you in person. I think you had to travel a little ways to get here, but I thought it was important that we all be in person for this hearing. So let me tell you what I understand is happening. You have filed a suit. I dismissed it. We're gonna have this conversation. If they want to get something on the record, they can do that. But time is short, or we can wait and do this at 5:30. And so I'm happy having the conversation this way. And then if you want to get something taken down and the court reporter's ready, we can do that. But we'll start having the conversation. So Mr. Hutchins, I dismissed the lawsuit because you didn't attend the preliminary hearing, the scheduling conference that I set up. And you've appealed that. Part of the record, I believe, is the communications from my staff to counsel for the two defendants as well as to you. You're proceeding pro se. And the lawyers for Georgia Power and the PSC have asked to supplement what's in the docket, which is part of the record, with the email communications that were sent out to you and to counsel for the two defendants. And you've objected. And so we need to have a hearing on that. Am I framing correctly? Is that your understanding of what we're here to talk about?
Yes, sir.
Okay. Well, why don't you tell me why you think it would be inappropriate for me to include in the record those email communications?
Well, for one, Your Honor, with all due respect, is I feel that it would kind of like hinder my defense of my issues on appeal that I did not properly receive notice of that email, and by it's not a part of the official record that the clerk forwarded to the appeals course, then I feel that the court, might have a say-so in that on appeal.
Okay. Well, I don't want to do anything that inappropriately hinders your appeal. So I'm with you on that. Tell me why you think including those emails would hinder your appeal. Because I'll give you my view. My view is that paints a more complete picture of what happened. Otherwise, the Court of Appeals is going to hear about emails. They'll write about them, and you're going to say, I didn't get it or I did get it. But there'll be this discussion about something that they don't actually get to look at. And so my thought was they ought to be able to see what it is that you all are arguing about. But I'm interested in hearing from you why you think it would hinder your appeal if I included that.
Well, I felt that it would probably be more to persuade the courts in its decision that more likely that the party was correct in alleging that I didn't receive the notice. By putting it in the record, it kind of like amplified a little bit toward tilt the scale, I feel.
Okay.
And I just want hope that it could just remain supportive of my defense that I didn't receive it. By putting it in the record, I think it kind of like opened up another window.
It might show that you received it.
Yes, sir.
Okay. I can understand why you wouldn't like that. Anything else you want to add about the request from the defendants to include those emails? And it may be just one email. I'm not trying to expand the universe, but whatever the electronic communication was from Ms. Hansberry, that's my judicial assistant, to the parties, you and the two defendants. Any other things you wanted me to hear from you on that?
I think that what brought about this issue was the fact that I was required to file all documents through the email system of the courts. And by me not receiving the notice and all, I think it kind of like every other document was filed Odyssey email, and it was mandatory that you have to file it through the courts, all communications.
Okay.
Through that procedures.
But this email from my staff member didn't come through e-file. It was sort of a different channel for you, is what you're saying. Like it was not,
yes,
you're right, it was not e-filed because it was an email. It was my staff communicating the notice of the hearing.
Right, and
Okay.
I never received it.
Okay,
That's the whole point about it.
got it. And that's going to be your argument to the Court of Appeals.
Yes, sir.
Okay.
If I would have received it, I wouldn't be here today trying to, argue this issue.
I get the sense you're committed to your case. You drove all the way here to be here. So I'm not doubting that you are sincere in the arguments you've raised in the complaint that you filed. Okay?
Sir.
Let me hear a little bit from the lawyers on the defense side. Are either of you aware of any limitation I have in supplementing the record that goes up on appeal if I feel that it would assist the Court of Appeals in addressing the claims that Mr. Hutchins has raised?
No, Your Honor, I'm not aware of any limitation. In fact, 5641 that we've moved under really encourages the court, all courts, to supplement the record in order to show what transpired below and to conform with the truth. And we believe that your staff's email does just that.
Okay. Mr. Boyer, anything beyond that?
Nothing further, Your Honor.
Okay. All right. Well, Mr. Hutchins, I didn't want to shorten this unnaturally. Were there pieces of evidence that you were going to also share, or this was going to be the conversation that we had where you articulated, you did it very well, the reasons why you think that the email, is it just one email?
Yes, Your Honor.
That the email, singular, should not be made part of the record that the Court of Appeals considers? You shared with me everything you wanted to?
Yes, sir. Basically, that was the issue of it.
Okay.
That's why, I filed my objection to it.
Got it.
Because knowing that that is my whole defense to my case. And for me to stipulate to that, it's like I'll be,
Right. No, I understand why you're resisting this. I get that. And should I decide to include that email as part of the record, that doesn't mean you're admitting that you got the email. You're still going to be able to argue, if that's your position, that's a fascinating email. But look, my email address is Hutchins1234, and this got sent to Hutchins123. Or maybe it got sent to the correct email address for you, but your position is going to be, I don't know how to explain it, but I never saw it. If I had seen it, I would have hopped online. It wasn't difficult for you to do. It wasn't at a strange time. You could have done it if you knew about it. I suspect that's going to be your argument.
Yes, sir. With that said, Your Honor, if the defendant's attorney would stipulate that what you just said would not actually saying that I waive my defense to this email by being in there, it's not gonna, tip the scale toward their favor, then I would, kind of like go with that issue.
Okay. Well, I think I understand what you're saying. I'm not going to ask either side to stipulate to anything, but I want you to understand that if I decide to include the email, I won't be telling the Court of Appeals, hey, here's proof. I'm simply saying, here's additional part of the record. There's sort of the capital R record, which is what's in Odyssey, like when something's e-filed. But sometimes in a case, there's more than what you just see in the docket. Like you've been watching this trial, and the lawyers enter exhibits, but sometimes something comes up and they say, hey, I want you to make this part of the record, but maybe it's not something that the jury sees. And so I think that's what this email would be. It's not you admitting to anything. It's these lawyers saying, we think the Court of Appeals should at least be able to look at it. They may not find it convincing, and you're not, first of all, you're opposing it. You filed the motion, and that'll be clear to the Court of Appeals. But if I rule against you, I'm not deciding that that means you got the email or that you're now forced to acknowledge that you received the email. Your defense is your defense, and if it's that you never received it, it's the it part that I want to get in front of the Court of Appeals. What is the it? What was sent? What was supposedly sent that some people got, but you say that you didn't get? Does that make sense?
Yes, sir, I understand.
Okay. All right. Anything else you want to add?
Well, I mean, now you being the court, the judge, and your discretion to make the decision as to whether you're going to allow it in
Right.
or not, and I accept your decision. On
Okay. Well, I appreciate that. And I appreciate you coming all the way here. I thought it would be important that we meet face to face rather than some fuzzy little screen. I know that's not convenient for you, but again, it's a testament to how seriously you're taking these allegations that you brought. And whatever the Court of Appeals decides, I wish you best. You should know that my dismissal was, I don't want to say the wrong thing. I think it was without prejudice. Right. So that doesn't, just play this out. The Court of Appeals could reverse me, and then we're back and we'll talk about how to move your case forward. If the Court of Appeals doesn't reverse me, that doesn't mean you can't bring this suit again. But it does mean if you bring it again, first it will come to me as a related case. You're going to want to check your email address because now you know how my staff communicates about certain things. But you'll know to call and say, hey, I haven't seen the email about a scheduling teleconference. So what this might do is delay your day in court as opposed to deny your day in court. I just want to make sure we get it right, whatever it is. And so I read this law about how you can add something to the appellate record. And I felt like these lawyers had hit upon the correct law, but it also required a hearing, which meant, unfortunately for you, you had to drive all the way up here. How long was the drive?
About 2 hours.
Okay. Sorry about that. Well, it's rush hour, so it'll be 3 hours to get back. But you're welcome to stay and watch the rest of the trial. It's closing arguments. It's about as interesting as it gets.
Yeah, well, thank the court, and I like to thank the court for acknowledging that I do take this case serious.
Okay. Well, I would expect you to. And I appreciate your time. I appreciate you coming all the way here. I know Fulton is not home base for you, but you are always welcome in Fulton County if that's where your litigation takes you. Okay?
Yes, sir.
All right. Anything else on behalf of Georgia Power? On behalf of the PSC? All right. PSC's been busy these days. All those data centers are going to raise my bill.
Please don't let what they're doing now affect the decision of this.
Right. I'm about to say Mr. Hutchins wins and I get 10% of whatever he collects so I can afford my power bills. All right. Well, I appreciate it. And I would ask you all to make sure you take care of the court reporter. She's going to have a partial record on the fly. She did put everything together and we'll take it from there. All right.
Yes,
Nice meeting you, sir.
yes, sir. Thank you. Thank you.
She keeps it around.
She has,
She's on.
As I go outside and you go.
Yeah. That's on the other side. Okay. Oh, you're saying we're going to be shooting.
Thank you.
That was confusing.
We already know what it is.
Cool. Yeah, one thing for her to do would be to watch this on Zoom, because it's just like every 10 minutes, what's up? And then it's a big production. And then the lady next to her keeps falling and you're together. They're done.
31 minutes.
Yeah, we'll get through it. You know what we should do is say, she can come back and sit with them during deliberation. Mm-hmm. Right.
Did you say it's a crew now? Did you say it's a crew now?
For us, that's what they want. Track.
Tell me that's the money.
Okay.
Right about that. Looking forward to the show. I didn't say that.
When you're ready for a good one.
The picture I sent you, you belong with that.
Listen.
We've got the bar in August.
And what courtroom was he in?
He's doing, some prelims and stuff now. But he just got told they could move it up to trial division in January.
He wanted to come to this sensible.
You know, I joked with him, I said, I've never worked in a cab, but I know more people who work in a cab. It was my time again. All the super, all the people out in that office, people out there. You know,
Really?
yeah, I mean, they're all.
When I
It's
was
funny, it's like,
at work.
no, it's a full, I was DA. Yeah, yeah. Oh, okay, yeah, I'm Ron. Yes, lawyer, I'm lawyer. Yeah. Yeah, I was in the picture case file, I was like, hey, so, yeah.
Don't tell her how long you're being. Don't tell her how long, and you probably look at me like, shit, she looked back. I was just telling her how I was ugly and crying. a while ago. I went to the graduation. I was like, oh, oh, okay. Dogs off the death row. And they take these valued children.
Right.
That are teaching them how to do this.
Yeah.
Child.
Well, good luck.
So where do you keep your mascara to grow? Because it's all nice and.
All the time. It's like, let me do that, I'm like.
No, listen.
I should.
I went to this only other day in the summer, because I keep all my money now, I stopped. And he says, we were taking those, drop them up, doing the month of July, and all
That thing is hard.
more. So.
She's herself.
And then they go,
Very
like,
well done.
Very-
She's herself.
no, you don't do that. No,
Yeah.
that's,
Yeah.
no, that's bad.
It's so fun.
That's bad.
I'm just saying, yeah, she just sticks it in there and I'm like, okay.
That's bad. But anyway, so we let that other person on that, where they live.
You lose right now.
Not in the
One of the times, yeah, this.
Liz, right?
You know, I mean, you know, this night, what?
Y'all. Y'all do that.
Yeah.
Showing how I am.
Right.
And I do.
Oh, this was.
I know, I live on my. But let me show you this, I swear to God. I am not, okay. We mailed this, look at this, look at this. We mailed this to. And I'm really surprised when the football club.
Right.
It took about a year to get back to me. And the address is collection. So I'm not getting my mail, but you know what I do? Amazing. Visa, American Express, that's your like,
It always makes.
then, okay, so tell me how.
Only they turned it on. Video, so it's one of the things he's doing, the state is considered for represent.
Just show up, just make sure you show up.
Yes, Joe, those are the big parties.
I'm not talking. You don't have to answer.
But that where it is. Yeah, yeah. And then I had represented not where, I received APD here. I had an issue at work. So they give me the rest of the decision. It's all PAs in my clients. You know, the CDs, it was very funny. It's just like, we get both sides.
Okay, listen.
So, yeah, so it's,
So.
so you know, investigative.
Yeah. She's. Everybody coming to be her. Hey, baby. She don't come.
So started in there. This whole thing about. See how long?
So you got, thank you. Sorry, I can't print back there. I'm just trying to print the jury charge. It wouldn't connect.
Something is not connected.
Tony. All right, well, let me know when you're ready and then I'll get on the record.
He went to the restroom.
Yeah.
Okay.
Okay, well, Mr. Rao is a very capable oralist, and so he can do it if need be.
Investigator, go grab a white man.
Yeah. All right, Ms. Rivers, are you ready? I'm not going to him in until Mr. Abadi gets back, but we'll get on the record. Okay, we're back on the record in State versus Poole, except we're not. Mr. Poole's not here. Maybe he's with Mr. Abadi. Let's separate them. There's Mr. Poole and look at that, arriving at the same time through opposite doors.
We're not getting to the record.
Nope. Mr. Poole is now in the courtroom with his lawyers. Both our prosecutors are here. Mr. Abadi, you ready for the jurors? Mr. Miller, you ready for the jurors?
Yes, Your Honor.
Okay. The jurors have indicated to Deputy Gordon that they'd like to say cell 6 today. So, Mr. Rao, if you could, unless you are running anything technical for Mr. Abadi during his closing, if you could start to get together all the videos. We have a set of equipment in the jury room so that jurors can watch videos that are in evidence without having to schlep out here, discuss them, pause them, do all the things that you've asked them to do, Mr. Miller. But I need to get them all on one thumb drive so that we can upload them on this computer that's not connected to anything. So if you could start doing that, and then the two sides can confer to make sure that all the videos that ought to go back with the jury and nothing more are on that thumb drive. And Mr. Miller, if you or Ms. Byrd, while Mr. Rao is doing that, could go through the evidence and segregate it into two piles, the things you think are going back to the jury and the things you contend should not go back to the jury. That'll be then teed up. So once Mr. Abadi's done, you guys could sort of swap. And while I'm charging the jury, we'll actually be ready to give them most of the evidence right away and not spend 20 minutes having you guys go through all the exhibits after I've charged them. Make sense?
But so you want me to do that while I'm speaking?
So I don't want you to disrupt, and if you want to be watching, then Ms. Byrd could do it. But I'm asking one of the two of you, much like Mr. Rao is going to be getting the videos together, just to start putting the exhibits into two. I don't think it's a very thick pile of things that don't go out, but I think we've acknowledged there are a few things that may not.
Okay.
So I don't, if your preference is, hey, I want to be watching because I want to be objecting, then let's have Ms. Byrd do that. But both sides are two-headed monsters. So the other head can be doing this evidence prep. Okay?
Do you need anything?
Thank you.
All right. Then let's bring the jurors in, please.
All right, the jury.
Is that our licorice? We provided that? Oh. I'm impressed. That's an upgrade of our snacks. That means one of my colleagues had some really nice stuff and I had to figure out where they got that budget. Self-supplied. Okay. Don't sneeze it up. Thank you, Deputy Gordon. Everyone else can be seated. So ladies and gentlemen, close to the final curve in the last lap, Mr. Body's going to present the state's rebuttal / closing to the closing. When he's done, I'll charge you with the law that you must apply to the facts as you find them to be. And Deputy Gordon told me that you all would like to stay 6-ish to at least get some traction with your deliberations. That's what we'll do. We'll all be here until you say we're pulling up for the day, and then we'll make sure you get out of here safely. Okay? Mr. Body?
Good afternoon. No matter where you start, no matter which piece of evidence or which category of evidence you begin your deliberations with, they all lead you to the same conclusion. Whether you start with evidence from the scene, whether you start with the science and the records, no matter where you start, they all lead to the conclusion that Kenneth Poole was the driver. The defendant talked to you about corroboration. And what each category and piece of evidence does is it corroborates each other. That's what we're going to talk about in the next, hopefully, half hour, 45 minutes. Get you guys out of your seats and back into the deliberation room. We spent the last 2 weeks listening to all of us talk. Some of you are very expressive with your face, and I don't blame you. I don't want to hear us speak anymore either. So I'm going to try to be brief. I'm going to try to be quick. I'm going to make my points. I'm going to try not to repeat the things that have been said by both Mr. Rao and defense counsel, Mr. Miller. So if you were to start with the scene, ladies and gentlemen, the scene is, exit 2 off Georgia 400 and Lennox Road. You've got physical evidence that's left at the scene, that being the vehicle. You've got video and photo evidence of that physical scene. You've got dash cam, body cam. You've got photographs that were taken by Corporal Lee. All of that can be used, God bless you, all of that should be used.
Is there licorice everywhere?
The other pieces and other categories of evidence that we're gonna talk about. And that next category is your witnesses. You've heard a lot of witness testimony presented to you by the state, by the defense. You've got love of the lounge witnesses, is how I describe them. There's all of the information they can give you is information that happens at the lounge. They can't give you any information as it relates to what happened after that 2017 white Infiniti owned by the defendant left the area of downtown, as they told you. Then you've got witnesses from Memphis, and I described those as Mr. Tate, and you heard from Ms. Martin. Both are witnesses who are from Memphis, providing information that was relevant to the case. And then last, you heard from several witnesses that were labeled or identified as expert witnesses. They were qualified as experts, and they testified on their subject matter and their area of expertise during our trial of this case. Then you have what I call the science. You've got the collision reconstruction, which you heard from Corporal Lee, you heard from Mr. Swanner, the science that is used in order to be a collision reconstructionist, the main principles that no matter who you are, no matter which company you work for, which law enforcement agency you're employed by, everyone has to use the basic same principles to begin their investigation in order to get to a conclusion. That includes physics. We heard a little bit from Corporal Lee about the Newton's laws that have been around for hundreds of years that, to my knowledge, haven't been challenged as we all sit and stand here today. The laws of gravity, which doesn't need to be explained. And last, the last category of evidence that we heard and saw during the process of this trial is what I call records and data. You've got the crash data retrieval report, the autopsy report and information that you received from Dr. Henninger, and then the medical records and the EMS records that we've heard about during the course of this trial and through the testimony of several witnesses. And when you use each category of evidence, no matter which category you start with, they all lead to the same conclusion. They build on each other, they corroborate each other, no matter where you start. And they all give you the same conclusion that the driver, the person who was found in the driving or the front compartment of the vehicle with his feet at the steering column or steering wheel is the defendant. There's no getting around that. There's no way to not use the laws of physics in order to come to your conclusion. And that's exactly what the defense wants you to do. They want you to ignore the science. They want you to ignore the things that cannot be changed, the things that have been reported, the laws of physics, Newton's laws and things of that nature that you have to apply in order to get to a conclusion. Now, you heard about the scene throughout this trial. And when you're thinking about the scene during the deliberation and the physical evidence, think about the vehicle. That's your main crime scene. That is the piece of evidence in which the crime occurred and where the point of impact occurred. Think about who was in the car. Think about where they were in the car in relation to the primary impact or damage of the vehicle. God bless you. Think about who was forced out of the vehicle and where they were found relative to the collision impact, the point of impact. And then when you are thinking about the testimony, deliberating about the testimony as it relates to the theme, the scene, excuse me, use the videos and the photos to corroborate the testimony. Because what the videos do and what the photos do is they corroborate the testimony of Corporal Lee. They corroborate the testimony of Trooper Clark. Now, when you're looking at the physical evidence and you're recalling the testimony of physical evidence, we talked a lot about the path of travel. And when you're thinking about the path of travel, the testimony that was given about the path of travel and how that path of travel was corroborated what you saw on Trooper Clark's dash cam. Think about the damage to the car. It was only the front, or the main point of impact, the main damage that you see on that vehicle, that's serious, severe damage is on the front right side. Think about where the fire was. You saw on the dash cam, you can see when the fire starts on the dash cam, you can see when the fire goes out. And you see that the fire is only in the front compartment. Why is that important? Why is the fact the fire is only in the front compartment of the vehicle? Because the only person that is burned is Kenneth Poole. Detarius Minor isn't burned. Devin Jones isn't burned. The only person who has burned is the only person who is in the front compartment of the vehicle, Kenneth Poole. Again, the most severe damage is in the front passenger right side. The motor oil and fluids from the vehicle. There was no testimony that Detarius Minor had any motor oil or other fluids on his body. You didn't hear any testimony about that. Again, you had no testimony burns from motor oil or fluids that caught on fire and then burned Mr. Minor. The only person that there was testimony about that had motor oil and fluids is the defendant. Again, why is that important? Because the only person who was in the front compartment of that vehicle is the defendant. If Mr. Minor started his journey in the front driver's seat, front passenger seat, anywhere in the front compartment of the vehicle, he's going to have motor oil on him. He's going to have all of the things that this defendant had on him. How, again, the laws of physics and science would not allow him to escape from all of the conditions that this defendant encountered. And that's because he was in the front of the vehicle. The occupants, we just talked about where they were in relation to the testimony, evidence, the dash cam footage and the videos, and then damage to the scene. All of that corroborates what we saw and know about the point of impact. And Mr. Miller talked to you about the dash cam and the evidence as it relates to the markings that were found by, identified by court, and you heard no evidence. You saw no, you heard no evidence, testimony, you saw no evidence that there was ever any indication that a vehicle was going to take a right turn. What Corporal Lee testified and talked to you about, what the video shows, it's uncontroverted. The defendant goes left. There's never a hesitation to go right. There's never a thought to go right. That's not evidence. That wasn't testimony, and that didn't happen. That's why there's no evidence for testimony of it. Again, you've got the videos. You have the videos of the dash cam of Trooper Clark. You have the dash cam of Trooper Buffington. You have the dash cam of Trooper Gunnell. You've got the body cam of APD Sergeant Stinson. And again, you have all the photos. All of that is important. Buffington and Gunnell's dash cam show different angles from when they arrived. But Trooper Clark's dash cam, obviously enough, as you've seen over and over again, captures the pursuit, the collision, the positions where everyone was found, just seconds after he arrived on the scene. It captures the extraction of Mr. Minor and Mr. Poole. All of that is important because what Trooper Clark saw, what Trooper Clark then testified to, was captured and memorialized for each one of you guys to see. There's no question about where Kenneth Poole was extracted from. There's no question about where Detarius Minor was extracted from. You can see it with your own eyes. Kenneth Poole was extracted from the front of the vehicle, and Mr. Minor, who, as soon as you can see on the dash cam, Trooper Clark arrives on the scene seconds after the crash. The only person you can see, the only person that is visible is Kenneth Poole. And that's because Mr. Minor is always in the back seat, back compartment of the vehicle. Whether the car is right side up or upside down, doesn't erase the back seat of the vehicle. So when defense counsel says there is no back seat. There's a back seat, the car's just upside down. So Mr. Minor, as testified by all of the officers, by every member of the EMT, whoever was at the scene and witnessed what occurred that day, it is uncontroverted that Mr. Minor was extracted from the back seat of the car. Why is this important? So as you watch the car travel, Group Trooper Clark not far behind it, off the exit, you saw up in the corner that the vehicle catches on fire. Literally, you can see that the vehicle's on fire after it hits the wall, basically. So it's not like the vehicle rolled and as defense counsel mentioned, you'll have this video of that. This isn't some hit the wall and there's a violent over and over roll. It literally, as described by Corporal Lee and described by Jeffrey Swainer, the defense expert in his report, that the vehicle hit the wall, it rotated and overturned. There's no mention of barrel roll. There's no mention of rolling open once, twice, 3 times. In his report, just as Corporal Lee testified, each one of you was that the vehicle hit the wall, front right side, slid down the wall as it impacted, came off the wall, down the curb, rotated clockwise, and overturned. And Corporal Lee talked to you about why the vehicle, after it was rotating, came to a open stop or overturned on its roof. It was because of the fact that both of the tires to the right side had been flattened because it went up on the curb as it before it hit the wall or the embankment or the concrete wall on the exit of Georgia 400. And as it was coming down and as it rotated clockwise, he said either tripped, gripped, I forget the exact term he used, but it's when, because the wheels, the tires were flat, the metal part of the wheels began to grip the road. And that's what caused the overturn as the car turned clockwise. These are photographs that capture the scene the night that the collision occurred on April 9th. And all of this is important as it tracks the journey or path you can see on the video. He described why these markings are there. He described the point of impact and these scrapes on the wall as the direction is went down the wall and again down the curb from the embankment, causing it to turn clockwise and overturn.
And the vehicle overturned on by everybody.
Is it that? Thank you. Following from the back is the defense counsel wants you to believe he's in the spot that Trooper Clark found. He never moved. His arms moved, his lower body, now here we can see his pin from the front collision of the vehicle. His feet are stuck in the steering or well of the driver's compartment. You can see the slamming on the brakes. He's attempting to make that right turn at dangerous speeds. And where we see the defendant moments ago in the video is exactly where he's extracted from. He never moves, he can't move, and again, that's because he's pinned from the front collision of the vehicle with the wall. Here's just a photo or a close-up of what you just saw, exactly the position that was described by Trooper Clark, that was described by Trooper Buffington, Trooper Ginnell, that was described by Captain Henderson, that was described by EMT Larry, or goes by Mike Berry. Then you saw the extraction. No question as to where this defendant was taken from when he was eventually freed from being pinned from the driver's compartment of the vehicle and allowed or to get medical services finally as the extraction took. You heard from medical professionals and fire professionals and the law enforcement 40 to 45 minutes. But what's also equally as important is the video captures the extraction of the backseat passenger, Terry Minor. Watch his feet.
Really interesting tattoo.
We all learned after Sergeant Stinson testified, we've heard from Dr. Henniger, we were able to see the photographs of the autopsy that was done for both Mr. Jones and Mr. Minor. And it was clear who had the large, interesting tattoo on the abdomen for his torso, and that was Terry Minor. But if you look closely, again, watch Mr. Minor's feet, out there, they're gonna be on.
Guys, right on the stretch.
There goes Mr. Poole in front of the vehicle. Next, Minor. Directly from the back seat of the vehicle, from the back passenger door of that vehicle. Again, it's the point of impact in which the car collided with the concrete wall. And just like I've described, when you're looking at all parts of the scene, when you're using your common sense and your reason, it's clear that the person found in the driver's compartment of the vehicle laid in the direction in which we later learned from the experts of the point of impact and what the principal direction of force, because of the direction they were coming from and the impact, which was the front right side of the vehicle. Mr. Poole is extracted in the exact way, the pathway in which that the principal direction of force would require, what the laws of physics would require. So when you're back there deliberating, use your common sense as it relates to the science, as it relates to the things that have been proven over and over and over again, and think about why they're used. Because they've been proven over and over and over again is why they are used universally throughout all accident reconstructionists, whether it be the GSP members of the SCRP team or a private investigator like Mr. Swainer. Now, as it relates to the witnesses you heard from Adriana Lewis, Brandy Jefferson, Adrian Poole, Clinton Patrick, Corey Williams, and Jamarcus Phipps, as it relates to what happened before what occurred a little after 3 a.m. on April 9th, 2021. You heard from people from the scene. You heard from Captain Henderson and Chief Middlebrooks from the Atlanta Fire Department. And remember what Chief Middlebrooks talked to you about, when Chief Middlebrooks testified about. And remember what was asked of her. And remember who you don't see on the video. But is there a question that Chief Middlebrooks was present on scene on April 9th of 2021? Just because she's not captured on scene, it's clear she had a recollection of it, she had a report, or the Atlanta Fire CAT report. So just because she's not seen on the video, just like Joe Connors, does not mean that she wasn't there. You heard from members of Grady EMS, the EMTs, Mike Berry, Joe Connors, testimony from the previous hearing, and you heard the testimony of EMT Derek Pettis. Again, you heard from Ms. Martin, Mr. Tate, and then the experts. Think about what this was testified to. She's a member of the defendant's family here in the Atlanta area. There was no evidence, there was no testimony about the defendant's familiarity with Atlanta. And he wasn't familiar with the area that he had been traveling that evening. Remember the testimony about when the defendant and Mr. Minor actually got together, when the defendant and Mr. Minor actually saw each other. They were the two people who actually, based on the testimony of the witnesses from the lounge, that saw each other for the least amount of time. Remember, Mr. Minor and Mr. Poole didn't meet up with each other until the lounge. Mr. Poole and Mr. Jones had been together previously, and they had gone to Ms. Lewis's house and cut her hair. And I think the testimony was a member of her family. And the testimony of Ms. Jefferson and the other witnesses, Mr. Williams and Quentin Patrick, was that they didn't see Mr. Minor until the lounge. That was the testimony. How would Mr. Minor know where the defendant parked that night? There was no testimony that Mr. Minor and Mr. Poole saw each other until the lounge. That Mr. Poole had been with Mr. Jones the entire evening, that they traveled from Memphis to Atlanta together. They left Encore at 3 a.m. That makes the collision impossible. That makes the crash impossible. Because you saw the pursuit starts, I think it's at 2:57 a.m. and then the collision happens at 3:01 or 3:02 off of the Lennox Road exit. The 2:25 a.m. screen grab that you saw with Ms. Jefferson, and I can't remember, I think it was Mr. Patrick who was in the Facebook or Instagram story or live. That was screen grab at 2:25. Who's not in the video? You don't see the defendant, you don't see the Terry Minor, and you don't see Devin Jones. Remember that as you're going through the testimony of all of the witnesses that night who testified about the lounge. Remember, just as many of the other witnesses couldn't remember times. Does that mean certain things didn't happen? No. It just means certain things happened at different times than was described or told to you by the defense counsel. You heard again from Trooper Clark. And you've heard a lot about Trooper Clark. You saw Trooper Clark's dash cam. You saw his actions and what he did after the pursuit began. You saw what happened and what Trooper Clark did and how he activated after the collision crash happened. And like Mr. Rao said, that's absolutely his job. That's absolutely what he is supposed to do. But if he was trying to railroad the defendant as he came in here to testify, what you have to think about and use your common sense is there are many things that he could have lied about, that he could have made up as it relates to the time, knowing his knowledge of, for example, the medical records, seeing other videos and testimony. But he told you the truth. And if he was going to lie to you about the statement the defendant made, his fabrication, ladies and gentlemen, as you know from your common sense, would not be three very simple questions. And the defense counsel asked you, why did he lie? And that he didn't care. Well, how about he didn't lie? How about that? It wasn't recorded, but it was recorded in his report. That was very close in time to when the incident occurred. He didn't write his report 6, 8, 3 years later. He wrote his report, started it as he testified to in his vehicle at the time that the incident occurred, after the incident occurred, and then it was finished later throughout the course of the investigation in the next 7 to 10 days is what his testimony was. And remember, he asked the defendant, why did you run for me? I don't know. Did you have a good reason for running for me? He said no. And he asked if the car was his. And then he left. Now, why are the answers that the defendant gave and Trooper Clark, what he recorded in his report as he recalled, based on the questions he asked, why is that important? Defense talked to you a whole lot about corroboration and corroboration of this, that, and the third. Well, his statements are corroborated by his statements that he made to Joe Connors, in which the defendant admitted that he was the driver, and then his statement to Miss Martin, when she called really to check on his well-being, asked if he was okay, if he needed anything, and then she asked him why he was running from the police. And remember what she told you. She told you he said he didn't know, he panicked. All very similar to what Trooper Clark remembered the defendant saying in response to his questions. And why is that important? That's important, and why is that corroboration? Because Trooper Clark, Joe Connors, and Miss Martin, they didn't know each other then, they don't know each other now, and they won't know each other tomorrow. And that's important because if there was some huge conspiracy, as defense counsel has pointed out, there's been a number of years, passage of time since this incident occurred. You would have heard testimony, you would have seen evidence of Trooper Clark reaching out to Miss Martin, Trooper Clark reaching out to Joe Connors, and vice versa. There's this big conspiracy so they can all make sure they get their stories correct, when statements were made, times and things of that nature. And ladies and gentlemen, that's because Trooper Clark didn't lie, Miss Martin didn't lie, and Mr. Connors didn't lie. You heard the reading of the testimony of Joe Connors. Joe Connors could have lied and said he remembers everything. They're watching the video, things of that nature. Everything sticks out to him. He said this. He just said he didn't recall. He could have also said, I didn't say any of that. But the testimony was, I don't have an independent recollection, but I have no reason to dispute that I was there and that I said what I said to Trooper Clark. The science, you heard all about it. I won't go into the details of each of the principles that were talked about during the course of this trial, talked about during the two closings that you heard prior to this. And then you heard from the expert witnesses. And I'll get into the specifics of what each Corporal Lee and Dr. Henniger indicated and testified to during the course of this trial. But you heard from Corporal Lee as it related to the collision and the reconstruction of it. And then you heard from Dr. Henniger about the cause and manner of the death for both Mr. Jones and Mr. Minor. You also heard about the common pattern of injuries that, based on his many years of experience as a medical examiner, his many years of doing autopsies day in and day out in order to come up with the cause and the manner of death. He told you that in order to come up with an accurate cause of death, he has to look and during the autopsy and have a background about the mechanism of an injury, about using his knowledge, his experience, science behind the laws of physics to determine how somebody died, the cause of a specific injury, femur fracture, jostled organs, things of that nature, and how his knowledge about the pattern of injuries corroborate or match the position in which each person in the car would have been. Now, as it relates to the records and the data that are used, or the conclusions of the application of the science that you've heard all about. You saw the crash data retrieval records, which talk about the airbag deployment, whether anyone was restrained or unrestrained, the vehicle system, that the dynamics of the vehicle, and the delta V, which is the change in velocity from the impact of the vehicle with the wall. You heard about the autopsy findings, the injuries that Dr. Henniger found and determined the cause and the manner of death, and how the importance of understanding the mechanism of what caused the injury is to his analysis. You also heard a lot about the medical records, the ENS records, and the Grady Hospital records of this defendant. As it relates to the crash data retrieval information, you learned about that Corporal Lee did the extraction of the crash data retrieval data or information. He talked to you about the event record, event 1 and event 2, how he knew event 1 had nothing to do with this collision based on the lifetime, the excuse me, the ignition cycle of the crash and then the ignition cycle download, how the 500221 made it clear that that was a collision or crash that happened in that vehicle before the incident in this case. On the first page of State Exhibit 137 you have in the back, it gives you a list of definitions. It tells you about the information that's provided within the crash data retrieval report. And what it will tell you is this system, this Bosch system, it only can hold 2 events at a time. So this is event 1. Event 2 was the crash that we've heard all about on April 9th, 2021. You heard from Corporal Lee and you saw in State Exhibit 137 about event record 2, the things that were important as it related to the maximum delta V, longitudinal and lateral wise, and what that meant as it relates to the severity of the collision, change in velocity from the force of the impact. We heard all about the different airbags that this car had frontal and side airbags on all sides of the vehicle, how quickly the frontal airbag were deployed after the initial impact. You learned that it was 3 milliseconds, which is, Corporal Lee said it was very fast, basically, that it was before you could even blink your eye. The airbag was being deployed in the front. This is a diagram of what Corporal Lee testified as related to principal directional force, what you saw during Detective Dr. Henninger's testimony as it related to the principal direction of force, which way it be coming from, what obstacles or things in the vehicle each person would be encountering and hitting. You heard all about that from both Dr. Henninger and Corporal Lee and from Mr. Swain. Again, there's no evidence in the crash data retrieval report of any attempt to make a right turn. It was always he was making a left turn, didn't hit the brake until 4.5 seconds to the impact, which was 0. And if you look on the crash data retrieval report, as we talked about, that the brake was pressed from 4.5 seconds continuously by his foot, and at the point of impact, 0, which would have been the 78 mile an hour number that you see at the bottom of that chart in event record 2. You heard a lot about the autopsy findings. You heard about the injuries suffered by Mr. Jones and Mr. Minor. You see that Mr. Jones, just like Mr. Poole, has a right femur fracture. They were both in the front driver's seat and passenger front of the vehicle. You heard also about the injuries that Mr. Minor suffered, skull fracture that he suffered from side to side of his head. Heard about the injuries that he had to the right side of his torso, as Dr. Henninger and Corporal Lee testified would be consistent with him slamming with hard backs of the seats, both that he would have encountered from the back seats, front seat. You, most importantly, as it relates to the injuries from Mr. Minor, it's about the injuries you didn't hear about the injuries that Mr. Minor did not sustain. He sustained no lower extremity injuries. You heard the testimony of both Dr. Henninger and Corporal Lee that the front impact collision of such high force that it is common that there are lower body extremities to the front passenger of the vehicle, whether it be the driver or the passenger, which we see here with Mr. Jones, and which we later learned and can be seen in the medical records for Mr. Poole as it relates to his right femur fracture, his left tibia and fibula fractures, and then the fractures of his fourth and fifth, I think, metatarsal or his toes and his right foot recorded in the medical records. What you also don't see, and what you see with Mr. Poole, is that Mr. Minor has no burns. He has no burns, no motor oil, nothing from the front compartment of that vehicle on his body. This was a list that you heard from defense counsel and Mr. Rao as well during their closing as it relates to the injuries that Mr. Poole suffered. Again, he suffered the lower extremity issue, the fractures to his fingers, tibia, and his toes in his right foot. Who you did not hear about his injuries from, but you heard nothing about the injuries that he had to have serious invasive surgery for, was Mr. Swainer. Not once did Mr. Swainer in his report, not once did Mr. Swainer during his direct examination ever mention the lower extremity injuries that this defendant received. The injuries that kept Mr. Poole in the hospital from April 9th till April 26th when he was discharged. Not a single word in his report, not once when he spoke to you yesterday, did he mention anything about the injuries that this defendant received in his lower extremities. Why? Because they're consistent with and prove that he's the driver of the vehicle. He also, yesterday and today, didn't tell you about any lower extremity injuries that Mr. Minor suffered. That's because he didn't suffer any. He suffered no lower extremity injuries. You heard from Dr. Henninger, you heard from Corporal Lee that somebody in the front compartment of a vehicle at a high velocity collision or crash that's on the front end, in all situations that Corporal Lee said that he testified at scene, and what Dr. Henninger, based on his training and experience as a medical examiner, would expect to see is lower extremity injuries, which is why Jeffrey Swainer didn't talk to you about that, which is why Jeffrey Swainer did not include that in his analysis. Yet he was hired for the one sole purpose, as Mr. Rao said, to match the pattern of injuries of each person involved in this crash to determine where they were the occupants at the time of the collision. So think about why that information was not presented to you. Think about why Jeffrey Swainer did not use that as a part of his, he described the totality of the circumstances for the one job he was hired to do. Again, the crash data retrieval report corroborates that Kenneth Poole was the driver. The brake is on from 4.5 seconds to the moment the crash occurs, which is consistent with and why the defendant has all of the lower extremity issues that he has, why his toes are broken, because he's mashing the brake at the time that he hits the wall in an attempt to try to correct what was about to happen. You saw in the grading record from the doctor, Malika, that he had airbag burns, and her sole service was the burn service. There's no evidence that contradicts, there's no evidence, this evidence is uncontroverted that this defendant suffered airbag burns to the face, which is consistent with the airbag that deployed at 3 milliseconds, and then the second deployment at 6 milliseconds, the front driver's side airbag. Then you heard a lot about GCS, more than I, and I'm sure most of you who are not in the medical profession ever wanted to hear about GCS, Glasgow Coma Scale score, whatever it may be. I now think I could probably do an evaluation as it relates to anybody's GCS score. But the point that this slide, this is trying to make is that throughout the medical records, they are described as Mr. Poole as alert and his GCS being 1515 by BMTs. Then you go to 4/9/2021 at 4:19 a.m. after he just arrived. Patient is calm and cooperative. He's speaking normally. His GCS is 15. Then you got again at 5:38, GCS is 15. Then shortly thereafter, 15, 15. Everywhere you were to search the medical records, and you'll have them, you're welcome to do the search, the 2000, I think it's 199 pages. The only time that his GCS is ever described as an 11 is by Todd Clark. The individual, as we learned, doesn't assess the patient, probably never saw the patient, just spoke to EMTs as he was arriving and reported it as an 11. The defense counsel wanted you to use the information side by side from the EMT records as well as from the Grady hospital records. And he told you that everything that Mr. Clark recorded was correct, except for the GCS score. So he had to be right because everything was correct on his, but not on the actual author of the report. But the actual author of the report tells you he's in unit A74. What Mr. Clark, the person who's not in the ambulance, who's not driving, or part of the response team, he records the unit as 643. So he's incorrect again. Grady records also tell you throughout that the defendant experienced no neurologic deficits, that he had no diminished capacity as it related to decision making. You heard from Ms. Freeman and other witnesses who talked about what occurred as a treatment for Mr. Poole evolved throughout the days in which he was at Grady Hospital. You heard shortly after he arrived, he had to give verbal consent after explaining and asking any questions as it related to the traction pin in order to stabilize his femur prior to surgery. Throughout the records, you will see as you review them that it said that the patient again was calm, cooperative, he was alert, that he was able to understand, and he had no diminished capacity as it related to his decision making and his understanding of the procedures that were done. Then you heard about April 17th or April 18th into the early hours where it was reported that Georgia State Patrol came to the hospital and told Mr. Clark about the charges. And why is this important? And more importantly, use your common sense and your reason. Why is this recorded in the records? Why do the records make a specific notation that officers came and talked to Mr. Poole? It's because his vitals changed. Because that's what the records are monitoring. That's what the doctors are monitoring to make sure that his health and well-being are the number one concern. When you're at the hospital, that is the number one concern. His vitals change. Why do his vitals change? He tells you. He was notified about the charges. I won't read that to you. You guys can all read, and it's found in the records. But think about the importance of why this is notated. It's because, again, his vitals changed. Something as it relates to his medical care changed. And as a reaction to what he was told about the fact that he had charges and he needed to turn himself in, which he later learned he did. Now, again, why are the records important? Because they corroborate all the other things that you learned about or heard about during the trial. They corroborate the scene, they corroborate many of the witnesses, and when you use them in applying the science, it corroborates the science. It makes the science make sense. And what you saw throughout the records is that the injuries that the defendant sustained as a result of the motor vehicle collision were consistent with the pattern injuries that would be expected and are commonly seen in somebody who was the driver of the vehicle. What do the records, why are the records important as it relates to the defendant's ability to understand? Because you heard argument and questions as it relates to the defendant's inability to understand his surroundings, understand what was going on, that he only knew his name, and things of that nature. We know that's not true because the records tell you that. Hundreds of times in the records, his GCS is at 14 or 15, a normal functioning human being or individual. Hundreds of times, it's talked about his orientation, his consciousness level. Hundreds of times is it talked about the fact that he understood and was able to provide verbal responses and make the decisions in order to consent to specific procedures. What you'll see in the records too, is they indicate some of his belongings. They don't just indicate that he had his wallet or his license. It also indicates that he had his phone, which corroborates the photograph that defense counsel put in with his aunt. When she was taking a photo of the defendant, with his eyes closed as he laid in the bed, and the phone that was next to his, the clicker of the TV changer in the hospital that lay on the bed. She said she used somebody else's phone to take the picture and that was her phone. Well, we know that can't be true because all of the witnesses testified who visited Mr. Poole, that it was one in and one out. One in and one out. And I would submit to you, and using your common sense, and I know many of you are nurses and other medical professionals in our medical industry. I would challenge all of you, based on the number of years that you have worked in the medical profession, when did you ever leave your cell phone at a patient's bedside? It's not a nurse's phone. That person's phone in the, that photograph is the defendant's. Now, you also heard, like we just talked about, a number of visitors visited the defendant. I think it was either Ms. Lewis or Ms. Poole, I can't remember, but one of the two indicated that somebody was with the defendant at all times during the day until they were kicked out. Every single day during his hospital stay. I think that was what the testimony was. You heard from Mr. Patrick and maybe Mr. Williams, I can't remember, maybe it's Mr. Phipps, that certain individuals were able to sneak into the hospital room and visit with Mr. Poole, who lay there comatose, according to them. Completely contradicting the medical records that you will have in the back, all 2,199 pages. And I asked you to think about, why is that important, that testimony? Why is it important that it was testified to that every single day, the member of his family was there every hour on the hour, as many times that somebody could visit, that these individuals, Mr. Patrick, I think it was Mr. Phipps, again, was able to sneak in and visit the defendant, and not just snuck in, had an interaction with the nurse who said, I won't look, you go in, have your time with the defendant. And apparently, as Mr. Patrick, I think, testified to, they changed his dressing or bandage, and he screamed in pain and things of that nature. Where in the records is that important? Where in the records do you see that Mr. Patrick, Mr. Phipps, Ms. Poole, Ms. Lewis, Mr. Poole's mother, we heard about, visited him often and every day? Where is that in the records? Where is that log of their visitation in those records? It's not. You'll have those. You can look. They're not in there. So this whole conspiracy that is crazy, that when Mr. Poole was being worked on in the ER and spoke to Trooper Clark, that not being in the records, that's not an anomaly. That seems to be a pattern. The people who visit the patients, they're not recorded in the records. And you'll have the records. And each one of you who work in the medical profession will understand and be able to point it out in the records as to why and how their family members and friends are also not recorded in the records. And I don't say that to say that they weren't there, because I don't question that they visited their family member and their friend every day. But the fact that they were able to visit, and there's no records or evidence of that, goes to show that Trooper Clark isn't lying. It corroborates what Trooper Clark told you, that he was there, he didn't cross paths with a lot of medical professionals, and he was able to interact with the defendant. It corroborates, the medical records corroborate that Trooper Clark was actually able to communicate with the defendant, that the defendant was of sound mind. And how do we know that? Because it's all in the records. You heard from Nurse Freeman, what I asked you think about and deliberate about the testimony that Nurse Freeman provided. I'm sure she is fantastic at her job. I have no question that she knows what she's doing at the hospital in which she has been working at for a number of years. But the testimony was she had never been, she never worked at Grady. She didn't know the Grady policies and procedures. When asked about it, she had no testimony or information that she could provide you as it relates to any of the records that she reviewed specifically as it related to Grady. She talked to you a lot about AO ×3, but as you go through the records, at the time the defendant was discharged, he was AO ×3. Use your common sense and your reason as it relates to what AO ×3 actually means. And what didn't they talk about? What didn't Ms. Freeman point out during her testimony? See where it says orientation level? 8:00 a.m. on 4/9/9/26. orientated by Fuller. Orientated by Fuller, which is what she talked about with the highest level of orientation. She said it was AO times 4, but clearly breaking into two systems. They have AO times 3, and they've got in the flow chart, the neurological examination that records the orientation level times 4. And that, ladies and gentlemen, is hours after the crash that the defendant was in. Oriented times 4. You heard from expert chiropractor, Dr. Collins, talking about how he was certain, based on his hour or so interview that he had with the defendant through the internet over Zoom, that he was certain that the defendant suffered from a traumatic brain injury. That his medical opinion, beyond all medical certainty, was that the defendant was suffering from a TBI. And he talked to you about why he thought that. And the main reason he was able to talk to you about that was the GCS 11 by Mr. Todd Clark, who never saw the patient. And then this notation, that decrease in the GCS of greater than 2, or the increase in the NIHSS was the reason why he diagnosed, was a key piece of the reason for his diagnosis and the traumatic brain injury. But that section was under notify the physician. Use your common sense. In this notify the physician section of the records, there's nothing about the defendant's actual GCS. There's no information about any levels, any vitals related to this defendant. This is a note, as it says, notify the physician if his GCS dropped 2 or greater, because that would obviously indicate something serious is happening. There's been a turn in the medical care or in the status of the patient. But what there's no note of, what there's no reporting in the records, is that after it says notify the physician, a physician was ever notified. Instead, what the records show, and what continuously is shown through all 2,000 pages, is that the defendant's GCS remained at 15 or 14, at the normal levels of somebody not suffering from a traumatic brain injury, from the levels of a person who is conscious, who is alert, who's able to communicate, who's able to understand and be oriented of his time, place, person, and all the things of that nature. And then the last box on the right-hand side is just to show you where it says belongings collected. And it talks about, obviously the defendant didn't have dentures, but as you go further down, jewelry, it talks about the cell phone and his wallet as the belongings of the defendant. And you saw on the records that some of his belongings were given to him and some of the belongings were given to members of his family. Now, why is all of that important? Why was all the going through the medical records, why was all the testimony in relation to what was picked and chosen to talk about as it relates to the defendant's injuries, the medical treatment of the defendant, and the defendant's status during his stay starting on April 9th. It's important because, again, you heard from Ms. Lewis, you heard from Ms. Poole, you heard from Mr. Patrick, Mr. Williams, and Mr. Phipps talking about the defendant was comatose, that the drugs made him unable to communicate, that he couldn't open his eyes, that he couldn't talk again or communicate verbally or non-verbally. But you've got 50 plus medical professionals in those records who are trained to do what they do as it relates to trauma, who are trained to do what they do as it relates to medical procedures, the life-saving procedures that were performed on this defendant, and not one of them say any of that. The defendant couldn't talk, communicate, open his eyes. In fact, if you go through the records, there are many times where it talks about his ability to open his eyes and see and things of that nature. And never once does it say the defendant can't see. I'm sure it was uncomfortable to open his eyes, uncomfortable to receive the drops as the records describe. But never once does it say that he was blind or close to blindness or anything of that nature. And if those things were occurring, as each and every one of you know from your life experience and from using your common sense, then it would be in the records. There's nothing in the records that talks about the fact that the drugs had a negative impact on the defendant's mental status, that the defendant suffered any mental breaks or mental health emergencies, that he had any sort of psychosis or hallucinations in regards to the pain dosage of medication that he received that is common based on everything in your life and you're using your common sense that most people who experience pain would receive. And as I said, as I started, no matter where you start, whether you start at the evidence that was collected from the scene, that you can see in the videos that, is memorialized in the photos and the dash cam and the body cam, you would start there. Or if you start with the science, as it relates to the core principles that have been used for hundreds and hundreds of years in relation to, life in general and the common principles that have to be used in order to do many of the things that each and every one of you do. And what the accident reconstruction experts are required to use in order to begin their investigation, to begin their evaluation and analysis of the evidence we've seen or from the records of the data. You start there. You start with the records, the data, the things that were recorded in the medical records and the EMS report by Mike Larry. You start there. No matter where you start, they all lead to the exact same conclusion. They all lead to the fact that the defendant was the driver, exactly in the compartment or area that he was found. There's no evidence, zero evidence that was presented to you during the course of this trial that Mr. Minor was ever near the front compartment of the vehicle at the time of the collision. And we know that based on, again, the science, the principal direction of force, the fact that the defendant went in the same exact direction, almost, as I argued, ladies and gentlemen, the same pathway travel that Devin Jones was going. But Devin Jones didn't have the same obstacles and things that were keeping him in his seat that this defendant had. The defendant had the luxury of being one seat over and his feet getting stuck in the driver's side that was farther, obviously, from the point of impact that allowed him to remain in that vehicle and not be ejected. And what I ask you to do as I sit down, as each and every one of you go back to the jury room and begin deliberations. Defense counsel, defendant wants you to believe that defendant Kenneth Poole was not the driver. That's the conclusion that they come to. That's the conclusion that they want you to come to. But in order to come to that conclusion, in order for each and every one of you to make that determination, you have to ignore everything else. You literally have to ignore every other piece of evidence. When you look at the crash data retrieval report, when you look at the evidence from the scene, where the defendant is found, where Mr. Minor is found, when you look at the medical evidence and the injuries that are commonly seen in people who are in a front impact collision and are in the driver's compartment of the vehicle, all of the lower extremity injuries that we're seeing in the defendant, his foot being on the brake, and seeing the fact that he had broken toes as it related to the lower extremity injuries he received, the fact where Mr. Minor was found, where Mr. Minor was extracted from. When you use all of those pieces of information and you don't ignore the things that they're asking you to ignore, you can only come to one conclusion. There is only one verdict that will speak the truth of what occurred on April 9th of 2021. And when you use all of the information, when you actually use the totality of the circumstances, unlike Mr. Swainer, you can only come to one conclusion. And that's this defendant was the driver of the vehicle that killed both Mr. Devin Jones and Mr. Terrence Minor. There's no other conclusion you can come to when you actually do an evaluation of all the evidence and when you actually do an evaluation of the full totality of what happened on that night. And when you do, ladies and gentlemen, you won't be telling the defendant anything he hasn't already known all of these years. How do we know that? Because he didn't turn himself in. He fled from responsibility. And he's trying to flee from the responsibility that he started fleeing from on April 9th, 2021. And I ask you, ladies and gentlemen, to hold the defendant accountable. to hold the defendant responsible for the things that he did on April 9th of 2021 that caused the death of his friends, that caused the death of the Terry's minor, and that caused the death of Devin Jones. And when you use all of the tools that you've been given, when you use your common sense that you came here with, the only conclusion you can come to is that this defendant is guilty beyond a reasonable doubt on each count of the entire event. Thank you.
Thank you, Mr. Abadi. I'm gonna ask you all to just stand up and move around a little bit. I'm gonna give you the jury charge now. It is not nearly as dynamic as anything Mr. Miller, Mr. Rao, or Mr. Abadi has done. There will be no video. My voice won't be raised. I just do want you to move a little bit, but I'm ready with the charge. I'm gonna give it to you in a second. There are a few pictures up here. I think you might have been using them, Mr. Miller, but I just want to make sure they end up in the right place. If they were your copies of state's exhibits or they're out of the stack of state stuff. Let me get something on the screen. I'd lower the lights so you could see it better, but you will not stay awake for the jury charge if I lower the lights. So hopefully you can see it without too much of a glare. And Ms. Bird, you're the closest. If you would please come grab. I have a copy for the defense and a copy for the state. Oh, you're wedged in there. Sorry. No, that's good. Mr. Rao will do it. I forgot. You explained. Stay where you are. But that's funny. All right. Two things about this charge before we begin. First, and probably most important, this document I'm reading from will be with you during your deliberations. So feel free to write things down, but you'll have this, just like you're going to have the indictment back there. Number two, there are some legal concepts that I am required to explain to you all using certain language that higher courts or the legislature has indicated are mandatory. So if every once in a while there's a turn of phrase like, why are you talking like that? It's not the way I talk. The jury charge is very much meant to be accessible. But if there are some stilted words in there, that's not me showing off with a 25-cent word. That's just something that thing is defined that way. I endeavor to make this something you can follow. What I'm reading will also be on the screen. If you're a listener, you're welcome to listen. If you're a watcher, you can watch. If you listen and watch, great. And again, point number one, you'll have this with you during deliberations. All right, let me get this working for me. A grand jury has indicted the defendant for felony murder, vehicular homicide, also known as homicide by vehicle, and fleeing and attempting to elude. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent, and this presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. I'm going to need you to step outside, okay, while I get through this. Thank you. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. A doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all that evidence, you find that your mind is wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about his guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that's been presented. You must then apply the law I'm giving you to the facts that you find. You must decide this case based only on the evidence presented here during trial. That evidence consists of testimony and exhibits. Evidence does not include the indictment or the plea of not guilty, anything said by me or the lawyers to include their opening and closing remarks, nor does evidence include any questions that were posed. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. I saw the car run the red light and hit the pedestrian. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. I heard screeching of wheels and what sounded like the impact of metal on flesh, but I didn't see the car hit the person. That could be circumstantial evidence that a car hit a pedestrian, what someone heard, but they didn't actually see it happen. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, as I've said, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of witnesses. In deciding this, you may consider all of the evidence, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their bias for or against a party, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here before you to statements that he or she made before this trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You have heard from several expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to you and me, the average people. Experts are permitted to give their opinions based upon their training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, or fear of injury. The burden of proof is upon the state to establish that the statement was voluntary. If you do not find that the statement was voluntary, you may not consider it for any purpose. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe that unsupported statement. There's no specific amount of evidence. There's no specific amount of supporting evidence necessary. You must determine whether other evidence proven beyond a reasonable doubt sufficiently supports the defendant's alleged statement to justify a conviction. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way, in reaching your verdict. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but simply is the intent to do the thing that happens to be illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from consideration of words, conduct, demeanor, motive, or other circumstances connected with the acts for which the defendant is being prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of that crime unless the evidence shows beyond a reasonable doubt that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. All right, we are now getting to the charges that provide the elements of the crimes that are charged in the indictment. And the first is felony murder. For felony murder, the state must prove that the defendant, number one, caused the death of another person, two, by committing a felony. The state does not have to prove that the defendant acted with malice, that is the unlawful intent to kill, in order to prove felony murder. Fleeing and attempting to elude, as it's charged in this indictment, is a felony. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of fleeing and attempting to elude, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when that death ultimately occurred. The second offense charged is homicide by vehicle or vehicular homicide. For that offense, the state must prove that the defendant, number one, caused the death of another person, number two, by driving a vehicle, and then three, in reckless disregard for the safety of persons or property. The state does not have to prove that the defendant intended to cause the death of the other person. And finally, fleeing or attempting to elude a police officer. For this offense, the state must prove that the defendant, number one, was driving a vehicle, two, and when he was given a visual or audible signal to stop from an officer whose uniform prominently displayed his badge and whose police vehicle was appropriately marked as an official police vehicle, that defendant did not stop, but instead fled. The state must further prove, the way it's charged in this case, that while fleeing, the defendant did at least one of the following. Either he drove in excess of 20 miles an hour above the posted speed limit, or he fled in traffic conditions which placed the general public at risk of receiving serious injuries, or he drove in reckless disregard for the safety of other persons or property. Ladies and gentlemen, you should consider each count in the indictment individually. The defendant may be found guilty of some, all, or none of these charges. If, after considering the evidence, together with the charge that's almost done, you should unanimously find, beyond a reasonable doubt, that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on the verdict form for that offense. There'll be a verdict that you'll be filling in for each of the counts of the indictment, guilty or not guilty for each count. If you do not believe the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous, meaning you all agree. Your verdict must also be in writing, meaning you fill out that verdict form, signed by your foreperson and dated. By no ruling or comment that I have made during trial have I intended to express any opinion on the credibility of the witnesses, the evidence, or the possible guilt of Mr. Poole. Your verdict must be based solely upon your consideration of the evidence, according to the laws that I've been giving you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that another juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You all are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign that verdict form I've been talking to you about, to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider everyone's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor, unsurprisingly, may you conduct any research. You have all the evidence in this case. It's either enough or it's not. It would be improper to supplement it with any outside information. To assist you in complying with these instructions, Deputy Gordon will be holding on to your electronic devices during your deliberations. Yes, you'll get them back tonight if you don't finish tonight. You can bring them back tomorrow, but while you're deliberating and that door is closed, your devices are in my office beeping and making noises and whatnot. I'll take your question in a minute. Going forward, if you need to communicate with me for any reason, it must be in writing. And we know you guys are good writers. But if you have a question as a deliberating jury, you're going to write it down. Could you please explain what this means in the jury charge? Or could we see Exhibit X if for some reason you don't have Exhibit X back there? Write it down. Upon receipt of your question or note, I will confer with the lawyers, with Mr. Poole present, and share with you whatever response I am allowed by law to give. And unfortunately, that last little clause means I may from time to time have to write, you have to figure that out yourselves, because you've asked a great question, but it's one that I'm required to push back to you and not say, oh, the answer 2 + 2 is 4. I'm not able to give answers to all of the questions you may have. And with that, my instructions are concluded. Ma'am, you had a question.
The clock in there doesn't work and I use my phone to know what time it is. Is there a clock that works?
We'll get a clock that works in there, because no, you can't have your phone in there. The exception to that rule is there's like, my spouse is about to give birth and we don't know which beep is, hey, it's time. And so you'd have your phone in there only to answer that call. Or a few people have devices for medical reasons. But if you don't fall into one of those two categories, I don't recall anyone saying you're expecting in the next week, then no devices back there. We'll keep you posted as to what time it is. I'm going to ask all of you to retire to the jury room with one exception. I'm going to ask Ms. Lewis Grayer to stay here, but the remaining 12 of you should go to the jury room. Please don't start your deliberations until Deputy Gordon delivers to you all the evidence. It's a lot. You have in the jury room, you've noticed there's a TV. That TV doesn't get cable, but it has a little computer on the back, and in a little bit, Deputy Gordon is going to upload into that computer all of the video evidence that's been admitted so that you can watch that video evidence as a group and you can talk about it in there. You can stop it, pause it, do what you want, and have discussions. You don't need to send out a question saying, can we watch State's Exhibit 99? Unless we didn't send it back there. But I've asked the lawyers to make sure that what Deputy Gordon places on that computer, and there's a keyboard for you to operate, is all the video evidence that was admitted that properly gets back to the jury. And then you should have all the documentary exhibits that are supposed to go back with the jury. There may be a few reports you don't get, but all the pictures and things like that you'll have to look at should you want to look at them. Any other logistical questions? My recollection is you want to go till 6, so we'll go about a half hour, and then Deputy Gordon will check on you, but you should go back. It's fine for you to select your foreperson during the time you're waiting on getting the evidence, but again, you don't deliberate till you get the verdict form, the jury charge, the indictment, et cetera. Okay? Thank you.
All right, the jury.
All right, you all can be seated. You're not in trouble, but you are our alternate. We always have 2 extra jurors because you never know when we may have to excuse a juror, like we did. Your colleague, Ms. Lawson, was excused real early on in the trial. I'm gonna have you stay tonight along with this group. When they're done for the evening, we're gonna let you go too. We're not gonna forget about you. You're gonna be in the alternate jury room. There's a door with what looks like a tornado on it. It's got a restroom and all that. You're gonna be in that space. You get to keep your electronic devices and you can read or text or whatnot, but no outside research. You are still in that cocoon of knowing only what was presented in court about this case. It may come to pass that we need to excuse one of the deliberating jurors. And if we do, you go in and they have to start their deliberations over from scratch and you become part of that discussion. We'll talk at the end of the day about whether you need to come back tomorrow. They're not going to finish tonight. And so we're going to still need you to be an alternate. It's really a question of how quickly you could get here from home if I called you to say, we had to excuse a juror, Ms. Lewis-Greer, we need you down here. And if the answer is you could be here in 15 or 20 minutes, then it's okay if you're at home or at work, as long as you're not talking about the case. But if you're someone who it's 45 minutes to get here, then we're going to need you to show up when they show up. But you can bring work, you can bring whatever you want to do. And in that room over there, you'll be able to do that while they're deliberating. Okay? You should go in there and grab your stuff, give them all a hug, and then head to that room. Mr. Rao, were you able to get onto a thumb drive all the videos?
Yeah, Judge, I gave that copy to make sure that they were.
That they concur that those are the videos. Ms. Bird, are you checking that or is Mr. Miller doing that?
I have it, Your Honor. There's defense 19 and 21. I don't see it in the box. It was the thumb drive that we entered through Ms. Jefferson.
It's in there, it was a separate one without a casing.
Right, those are her, I'm not the social media guy, but her Instagram videos or whatever, those were all admitted. Well, I don't remember if H was, but regardless, I
took H off of the thumb drive, but I don't see the thumb drive.
Well, the jurors, we need it for the record. The jurors don't need it, but if you found it, that's great. Are they on the universe that Mr. Rao created?
No, they're not.
Okay, well, if you'll add them other than, I think it was H, which was, I think, a text or something. While you're doing that, Ms. Bird, were you able to go through the exhibits to, or Mr. Miller said that was his job?
No, he didn't say that was his job, he just did pass him over so I can go.
Okay. I'm gonna go print a verdict form and let you all look at that. It's gonna be just like last time, and hopefully the printers are working.
It will start first of March.
Okay, that's easier. They just wanna head out, so the alternate's still back there?
Yes.
Can you have the alternate come out for 1 second? That's the right call. We're gonna deliberate for 10 minutes. Actually, they all need to come out. That's gonna give you guys plenty of time this evening to get the exhibits in order and for me to get the verdict form. We actually need to bring them all out. So just slide all the way down, grab a seat. It'll be quick. I didn't realize they wanted to go home. He's in trouble already?
Yes.
Okay. It's already the jury's not getting along. It's terrible. Pardon me?
She's got
Oh, yeah. No, we're good. Take your time.
Sorry.
Great. Take your time. So jurors, Deputy Gordon told me, and I think I get it, given what time it is, if you were going to wrap at 6, the thinking is let's just start fresh in the morning because there's so many exhibits. The lawyers are still getting them in order numerically. So where's exhibit 19? And it's way in there. We will have ready for you, once all 12 of you are here, you cannot deliberate with 10 or 8 or whatnot. All 12 of you need to be in the room. So if someone takes a break, I got to walk down the hallway, then you're breaking from deliberations. But once all 12 of you are here tomorrow, we'll have ready to go all those things I mentioned. We'll already have loaded on the machine all the videos, and you'll have the paper exhibits, indictment, jury charge, and the verdict form. What time do you want to show up in the morning? So we're ready for you. I count 9 fingers. All right, 9 fingers it is. And Madam Alternate, do you think you need to be here, or are you like 10 minutes away so that if we need you, we can get you here quickly? Okay, why don't you get here at 9 as well? But you should pack accordingly in that you won't be deliberating. So if you want to bring your Netflix account or whatever you want to do, or work, yeah, papers to grade, and you'll just be in the super special room that's more comfortable to do your alternate thing. And we'll handle it that way. Any logistical questions? Yes, ma'am.
We were gonna pick a foreman, are we able to still do that before we leave tonight?
If all 12 of you stay, you can do that. You can pick that's fine. But all 12 of you need to be in the room to do that. I'm not kicking you out. It's just Deputy Gordon said you don't even have their exhibits yet, so they're not going to deliberate tonight. But you could do step 1, which is designate, if it's like a runoff election and you're campaigning, you can do that. But he's going to make sure that all 12 of you stay there. No one can leave until you've done that, okay? Alternate can leave. Already a bonus. But the rest of you can do that and then head out. There should be in there letters. Ms. Hansberry let me know that people are beginning to doubt this whole jury thing. Like, really? You're still here? Who's this McBurney guy? You should have those. We will have another one to document tomorrow if you need that, or
Tomorrow, yeah.
that's Ms. Hansberry. Great. If you need more, we'll have more. But for those of you who need something, that should do it. Okay? Other logistical questions? Seeing none, thank you so much.
I just took a bomb on that special. Guys.
No, it's right here.
I'll take the one that goes,
You wanna look at 1920?
what's the clock? Is there no clock in there? Or it's just an old busted clock? You don't have to worry about it right now. I want to wrap up in here so Ms. Rivers can go. I'm gonna go get a verdict form, and have you guys look at it tonight. We'll get on the record in the morning that the verdict form has no objections. I'm gonna ask you all to finish, I'll stick around for it, your review of what's going out and not. We can get on the record tomorrow morning if there's a disagreement. That way Ms. Rivers doesn't have to stick around for that. But anything we need to get on the record at this point, Mr. Rao?
No.
Mr. Miller?
I would like to get what's going to the jury on the record.
Oh, we will get that on, but I'm not gonna make Ms. Rivers stay for that because it looks like people are still moving papers around. We, the lawyers and I are gonna stay till we're done with that and we'll have our discussion. And if there is a dispute, we will get it on the record tomorrow morning, along with everyone saying the verdict form is great. I'm gonna go work on the verdict form. You keep working on the exhibits. I'm gonna let Ms. Rivers go, but we'll make a record of our discussion in the morning, okay? Thanks. Yes, ma'am. Do it while you can. Quick.